It's been 12 months since acquittal, and so much has passed us by. Such a scampering with evidence, and some blatant flat-out lies. There's a special new press sector, and Hank Breeden is his name. He is a dirty Boston lawyer, and his arguments are lame. He's trying to squash all of our experts, as he has no case to claim. He should have won an Oscar medal to convince the court he's sane. He can lie without a conscience and keep that smirk upon his face. I bet he wears those silky undies, the ones with edging made of lace. And Judge Beverly Academy is so biased for the state, is wading through 100 motions in a rush to seal my fate. So you can bring in Massachusetts, cause we all ain't got no quit. And we all know that the truth is my car is not the thing John hit.
There's a new
pandemic in town,
and
it's taking creators
it's down.
Down a rabbit hole of corruption
In a Massachusetts town.
It strikes at
That's
the
the
heart of
bloggers,
bloggers, no matter podcaster or receiver. It can strike you like a Lexus, then you've got Karen Red River fever. Well, all the symptoms are quite acute, and you'll ask things differently before.
Ask it differently, Mr. Jackson.
You will utter what if anything,
What if anything?
or you'll be screaming
Screaming
outside.
outside.
You'll swear she said I hit him 3 times while making butt dials as well. No matter how hard you try to fight it, you just can't unring that bell. So once you finally say I'll allow it,
I'll allow it.
like Auntie built the darn diva, you'll find yourself behind that buffer zone, cause you've got Karen Red River fever.
And let's hope there is some justice for Mr. John O'Keefe. Good morning. Good morning. Holy crap, that's big. Woo! Yeah, that's still big. Good morning. Good morning, Christine. How are you? Did you like my little karaoke sesh? Hopefully that's the last time we have to play that. Let's hope that justice is righteous and quick. Fast. What do you think? How long do you think they're going to take, Christine, to deliberate? You think it'll be quick or long? I'm hoping they'll come back today, but I know it's wishful thinking. I can only hope that they're not silly enough to fall for the BS that is Mr. Hank Brennan. Let's face it. That's pretty much sums him up in a nutshell. Now, did we all have a good weekend? Welcome. Sorry, I forgot my manners. Welcome to the Defence Rest. It's your first time here. Suffering your jocks. If it's not, well, you know what you're in for, so buckle up. We are on verdict watch. Karen Reid, trial 2.0. The jury clock has hit 2 hours and 38 minutes so far. deliberations are underway. They end up leaving Tuesday, you reckon? The jury end up asking to be let out early on Friday. I don't blame them. Having to listen to Hank Brennan for over an hour would, drive anyone to drink. So they started this morning, and just looking at the verdict slip, I was having a read through it. It looks like they may have even added some extra lesser includeds, if I'm not correct, because I don't think they had on it involuntary manslaughter. I thought they had it as vehicular manslaughter, which was while operating a motor vehicle under the influence. Because they've got manslaughter while operating a motor vehicle under the influence, then involuntary manslaughter, then motor vehicle homicide, and then operating under the influence. So, yeah, there's there's four four charges under the manslaughter, plus the other two. Oh, look, I don't know. We'll have to wait and see. There's nothing happening in the courtroom at the moment. They're just showing old court scenes and bits and pieces, and nothing particularly exciting. But I have got a few things that I'd like to go through. I actually did a couple of things over the weekend, believe it or not. And, well, firstly, I did a bit of an analysis on, I started doing the mock closing statements. Then I did an analysis of their actual closing statements, and I did an analysis of Hank Brennan's overall conduct during the Karen Reid trial. Because, I can. So we've got a bit to go through. I don't believe for a second that they have met their burden of proof whatsoever on any of the charges at all, not even the vehicular, the DUI, because they can't prove that. They can prove that she was over the limit at 7:30, but they can't prove that she was over the limit at 12:30 when the supposed incident occurred, because she could have quite easily have gone back to John's house and continued drinking there. So the retrograde blood alcohol isn't indicative of when her last drink was. It could have been at any time. So they can't definitively prove that either. And do check out the poll. Have a vote on the poll. I thought I'd do something a little bit different. That's me, as you do. So you reckon they'll come back tomorrow? In the morning or in the afternoon, you reckon? I don't want it to drag on too long for the poor bugger. It's got to be just, I can't even imagine what is going through her brain. Do you go to court and wait? Have you got your bags packed? Do you know what I mean? Like, I wouldn't even know where to start. What did she do over the weekend? Like, did she, all right, well, I could be facing, I could not be walking out of the courtroom today. What do I wear? It's just awful. Just awful. But there's not a great deal that you can do about it, is there? Unfortunately. Oh, all right. I've got a few things up on there. Let's have a look. Share the screen.
Sometimes outside of the courthouse and in various platforms on social media. But what counts is what's presented in the courtroom. What counts is the evidence. What counts is what the jury is able to consider. And that's what we saw during the progression of the trial. I want to show you a live look at the courtroom. That lovely white fan on the ceiling is known all across the country as it is where our cameras have to be fixated when nothing is happening in the courtroom. That is because the jury is in the deliberation room at that courthouse in Dedham, Massachusetts. They're in there for 2 hours and 44 minutes and counting. They did about an hour and 40 some minutes on Friday before they had the long weekend. They are not sequestered. They got to go home over the weekend, and it's on the honor system that they
I would
do
have
not
preferred
do
they
any
were
independent
sequestered.
research or discuss the case with anybody. So in our last hour, we looked at the best moments from the Commonwealth's accident reconstruction expert. So this hour, bringing you the best from the defense's crash reconstruction expert, Dr. Daniel Wolf from the company ARCA. Let's look at some of his testimony on direct.
Oh, sorry. I needed a mouthful of coffee. Needed an all of the above. Yeah. You like my poll? Did you have a good weekend, my love? Get up to anything interesting or exciting? I didn't. Oh well, I went to. Sorry, I don't. That's not correct. I actually went to Tanya's on Sunday afternoon and had a play around over there. Had some lovely dinner. It was good. It's very nice. She made me a fireball. Yep, and I drank it, which is unlike me because I don't like cinnamon and I don't like whiskey. But it was nice. Did you? Well, I was thinking that we should finish off our song today. I wrote my daddy. Aww. That's so sweet. That's nice. It's lovely. You obviously have a nice, close relationship with your dad. That's good. Mine is a gutless narcissist. Yeah, we won't go there. Do you want to share it, or? Oh, coffee is so good, so good. What I caught on the weekend on Miss Shorty's stream. What happened with Kurt? Because I sort of quickly did a quick scroll through. I only hang on. I flicked over during the lunch break when Shorty was on, just to see how she was going, and the poor bugger. I just took one look at her. Kurt was doing his banking, and she's trying to hold the fort and keep everyone entertained, and he's just got his head down. All you can see is the top of his hat. He's not even speaking. And he's whinging about banking. His banking app was down or some shit. And so I sent her an email, and she messaged me. She sent me a text. I won't repeat it because it's not for anyone else to hear online. But yeah. But yeah, I went back through like the last half hour on double speed, and I couldn't. Someone said he had a hissy fit with her or something. I didn't see. I didn't see. Cool. Yeah. So, all right. I suppose it's probably not the place to discuss it for everyone to hear. So, sorry, love. I don't like to say anything negative about any other creators. That's not what we're here for. Yeah, no, it's my dad. Yeah. And he never was. And he's a two-bob snob as well. My dad and I used to be very, very close. And then my parents split up, which they should have done a long, long time before they did. And he remarried, or they both remarried. But I have never had such intense feelings of hatred towards anything or anyone. But this thing that he married, I would strangle her with my bare hands. Literally. Oh, okay. No, I'm the eldest of three, and I was the I don't know, the golden child, I suppose, because I was good at school. I never got into trouble. I did everything right. The nerd. Got married, had kids, got house, did all the right things in the right orders. But then I got diagnosed with I went to uni, was successful, did nursing for 15 years, ran my own business for 12. And then I got arthritis. And yeah. There's no monetary value in that. Nothing that he could grade me against.
What is this photograph showing in terms of the orientation of the arm and the hybrid test dummy, or ATD?
So
I'm the eldest
the
too.
orientation is to depict, again, the orientation that Dr. Welcher indicated in his static and dynamic test to
Actually,
show.
I don't normally get onto Facebook, but I did this afternoon because Anna, one of our OGs, has been having a few issues, and she found me on Facebook, so I accepted her friendship, and then it flicked back to my page, and it came up with this blast from the past. Oh, hello, darling. Of photos. Yes, I added you as a friend. Oh, well, I sent a friend request anyway because I saw you on there, and I very rarely get on Facebook. So, yes, I accepted her friendship and then saw this blast from the past, and I'm like, oh my God, I have to put. So I uploaded a couple of the pictures onto Canva. There you go. So this this is me and my youngest. That was in 2016. So what's that? Nearly 10 years ago. So she was probably, she must have been 14 there because she's 24 now. She was still at high school then. You can see her uniform. And there was a thing I'd written on Facebook, something about losing weight, and someone had commented on it. Well done, that's awesome. I think my vibrating machine is working too. And she sent the picture of this, the foot vibrating thing. And I wrote back, my vibrating machine looks way different to that one. And the next comment is my daughter saying, "Oh, Mum, stop!" So I embarrassed the shit out of her there. And I think I continued after that as well. And she put these up for my 50th. I can't even remember what the first one was for. but the second one was actually just after a massage in Thailand. Yep. So that was 10 years ago too. Just a little bit different. And that was probably about 7 years ago, 6 or 7. Yeah. So that's my baby. One of my babies. She'd be mortified knowing that I showed that. Oh well. She'll get over it. Let's have a play of this.
I know I don't tell you enough. I've been proud of you my whole life. You're the greatest daddy ever.
Aww.
I know I don't tell you enough. The farm boy who saw the world, the brilliant man who saved the world, the best daddy, the best Opa. I love you, I'm proud of you. I know I don't tell you enough. The farm boy who saw the world, the brilliant man who saved the world, the best daddy, the best Opa. I love you, I'm proud of you. I know I don't tell you enough. I learn from you, I travel far with you. I love you, Daddy. I know I don't tell you enough. I know I've been proud of you my whole life. You're the greatest daddy ever. I know I don't tell you enough. I love you, I'm proud of you enough. I know I don't tell you enough.
Oh, that's awesome. And what did he? Oh,
don't tell you enough.
hang on. What did he say? What did he say when you sent it to him? Was he surprised? That's lovely. You'll have to play that in your band with your kids. I don't know, but I'm really anxious about this verdict watch. I really am. I'm really struggling. I don't understand how I got so personally invested. So it's not something that I'm. It could go either way. It could go either way. That's what worries me.
What happens when again that ATD arm that we had is attached to a test dummy and is struck at 24 miles per hour?
Next slide, please. And what is this?
So this is a thermal image of the taillights just after the install, with the average temperature at about just over 33 degrees Fahrenheit.
Next slide.
I know.
And what are we looking at?
So you're looking at a top-down drone video with the Lexus here on the left.
I'm right there
that
with
will
you.
accelerate in reverse up to 24 miles an hour, striking the ATD arm.
Let's watch that, please.
Hello, sweetheart. How you doing? I have no sound on, but wanted to say, ah. No worries. Yeah, we're just saying we're a bit anxious. I don't like it. I mean, technically, they have not meeting any of their burden, but that doesn't really mean a lot when it comes to a jury. I just hope they're not stupid.
Next slide. What are we looking at in this slide?
I reckon we last week we went over to Discord and watched a movie together. It was so much fun because you can it's like the one channel, and you all like join that channel on my Discord, and we just share the screen, and you can either talk or you can type in chat, and you can watch the thing together. It was awesome. It was so much fun, and we watched something funny. We needed a laugh, I think, and I really think that's probably on the cards as well. Instead
So
of
this is a
sitting here going
top-down
over everything.
video from atop of the forklift, or where the arm is suspended, attached to the dummy. So you're going to see the vehicle enter from the bottom into going to the top of the screen.
I'd like to try. And you've got your wrench there, love. You can keep it well greased.
Next slide. What is this view?
It's just another perspective. This is a slow motion video where you'll see the Lexus in reverse. I think this one actually has kind of a long build up before it starts here.
Really? Oh, what's her name? So she's in Vinny's now. Justice Jane. Yeah, right. Well, you can certainly have the honours should you see her. You are free to do as you please. There's Vinny. What's he under? Is it under Vinny Politan, or is he under Law and Crime? He's under Law and Crime, isn't he? Nope. Oh, my back. Oh, okay. So he's got a live down. He must be down there. Oh, come on, open up.
They towed my car. Yeah. Oh, no.
my goodness.
Can we take a picture with you?
Sure.
Can you? I will, and then if you don't mind. Hey, I'm good.
What's that?
Mind if I get one, Vinny?
We were in high school.
Okay.
I'm the student council president.
Oh, you know.
That's right. It was a close race, but I still won. Sure.
I'm a little short, so.
The other one, that's the other one.
Oh, yeah.
Watch, I'll get
Awesome.
Vinny, how about a quick selfie?
Yeah.
Hi,
Hi.
doing a great job covering this.
Thank you. I hope I can do this right.
No, you can tell we're not selfie.
Hey, you turn it that way, you'll be good.
There you go. Is that good enough?
I love it. Oh, you got those long arms. Sure.
Thank you.
Awesome.
Thank you. Excuse me.
One more.
One more.
Okay. Thank you.
Well, hi.
How are you? Mind if I take a picture? My daughter's.
Awesome. Great to meet you. Yeah.
Okay, great. Thank you. I'm gonna photobomb you from behind. Thanks.
Thank you.
Do you remember me? Up at the house?
Oh, wow. I can't see you with
I
the
know.
sun in my eyes.
Hi.
How you doing?
How are you? We can read.
It was,
Yeah.
oh, you had to do that so you could be over here,
Yeah.
right? Gotcha.
Yeah, I didn't
Gotcha.
have any other picture.
Sure.
It's like, oh, well, I gotta do it.
Still 911 call. Second house.
Yeah.
They got street up. Shows them like a couple young patrol.
All right.
There we go.
Awesome.
He said if it's good with us.
All right, that's the full tour, ladies and gentlemen. Woo. It's a lot of people.
But it's a
A lot of what's a little choppy, of course. Yeah, it's always choppy. But a lot of people, I think, are expecting a quick verdict. I don't know if they're going to get a quick verdict. I mean, we do have a sample.
Hi, my name is Cindy Campos. I'm coaching, and my husband's a former police officer, and I'm going through a bunch of stuff down in Barnstable, and I can't speak about it because I'll be under arrest if I talk about it. You have to FOIA it.
Okay,
Thank you.
thank you. So,
There's no Thursday. I forgot.
what's that?
No Thursday.
They can't because of the holiday,
I think so. Yeah. It's a federal holiday. So,
but it's state court. Federal holiday doesn't impact.
you know, so-
They are going to observe it because it's not a state holiday.
No.
Yeah.
See, I'm
What do we do Thursday?
hopefully that we can verdict.
Well, I don't know. That sets it up for a Friday verdict, by the way.
Yeah.
It totally sets up a Friday verdict.
Earlier.
So no deliberations on Thursday. I think that turns. Wait, think this through, Grace.
Yeah.
If there's no court on Thursday, that turns Wednesday into a virtual Friday.
A virtual Friday?
Yeah, because there's the Friday factor that goes into calculating when a verdict's going to be. Things speed up on Fridays,
Again.
right? So it'll have a Friday feel. So
Call it Friday.
Wednesday might be the day, folks. Wednesday might be the most likely day. Obviously, it can happen at any minute,
Today.
any moment. Today?
Today.
Today.
It's before lunchtime.
Yeah.
Always after lunch. Always after lunch.
Yeah. A lot of people are believing today. They think it's a quick verdict.
I hope so.
I never believe in a quick verdict. For a case this long, with this many witnesses, this much evidence. How now, folks, I haven't been able to read any comments because I don't know how to read the comments on here. Trying to read the comments. Uh-oh, I just lost myself. There we go. Trying to. All right, folks, I'm going to have to go vertical. I got to go vertical, see if I can see any comments.
It's not a very good view there, Vinny.
Have people been commenting or no?
Yeah. Most of them are on YouTube.
Oh, this is the best I can do. Look what I did. There's a new beta. Puts the comments up so little you can't even see them.
What the heck?
That's the best I can do with the comments today, folks.
Someone wants to know if your blood sugar is 95.
Mm.
What's when you got that?
That's a bit of a weird question.
No, it's not 95. I will not reveal the blood sugar.
Hmm.
I don't want to start the blood sugar game today, but it's not 95. It's a little bit higher because I took a couple of glucose tablets. I took a few glucose tablets, so I didn't. I gotta get over here, so I wouldn't collapse.
Trial.
So, all right, folks. I got to get ready to go on TV. We'll be streaming all week. Vinny Verdict live streams. Get the flavor for them. I'm going to set up at some point in a place where I can do comments, etc.
Folks, put those cameras up. I have jurors coming down.
Oh, okay. Got yours coming down.
Oh, is that good or
Got
bad?
yours coming down. So we'll be streaming all week. We will have updates. We will have notifications. But I gotta get ready to go on TV. And I'm going to try to connect with some other folks who are here. So thank you for watching. Anyone who super chatted. Again, I couldn't put comments up. The software just wasn't working today. Sorry. Thank you so much.
Right
Stay
on.
tuned.
Yeah. Yeah. Hello? Oh, I've no idea. I would too if I had to sit and listen to Hank for an hour in there. Hmm. Hmm. Oh, is that the
Thanks so much for being with us here on Court TV Live. I'm Julie Grant. I want to show you the trials we're tracking for you across the country. Testimony is back underway in Sean Diddy Combs' federal sex trafficking and racketeering case. A juror was dismissed earlier this morning. His defense team not happy about it. Updates for you on that one throughout the day. In South Carolina, there's no court today in the trial for this defendant, Megan Jackson. She is accused in what we're calling the coroner affair murder case. Her defense is choosing to put on a case. They're going to begin their presentation tomorrow morning. And in Massachusetts, we continue on that verdict watch in defendant Karen Reed's retrial.
that just takes me to the homepage of the Dedham, Massachusetts homepage to the Flag Day parade. Is that today? Is it the flagpole parade? I don't know what you want me to look for, doll. You got JSTV. Who's JSTV? Ah, okay.
Cases over the death of
impact from a right rear taillight of the subject SUV?
It was inconsistent.
And what do you base that opinion on?
Based upon all of the impact testing that we did with the clothed ATD arm in the laboratory as well as the field.
In any of the testing that you did you ever see taillight pieces cut, puncture, or fray the sleeve of that hoodie?
No.
The exemplar hoodie, I should say.
Correct.
Did you reach any opinions or conclusions as to whether the rear taillight of the subject SUV was involved in a center of mass strike of a pedestrian at a high speed rearward maneuver? What is your opinion?
That the damage to the subject Lexus is inconsistent with a center of mass hit.
What do you base that opinion on?
The testing that we conducted in that last test that you just saw.
Do you hold that opinion to a reasonable degree of scientific certainty, Dr. Wolf?
Yes.
Thank you. That's all I have.
All right. This is a good place for a break. Or do you want to get started?
All right, here's what we're going to do. We're going to step aside from this testimony for a moment to bring in our law enforcement expert analyst, Sunny Slaughter, watching along, someone who watched trial number 1 and trial number 2 for us. Sunny, good morning to you. In terms of what the defense presented, in terms of their accident reconstruction expert, Dr. Daniel Wolf from ARCA, what, if anything, do you think he shared tipped the scales of justice toward defendant Karen Reed?
Good morning, Julie. Thank you for having me again. And thank you this morning for your initial commentary focusing on John O'Keefe, the victim in this case. You have done excellent in doing that. I know you have a question. I'm going to answer it. But I wanted to say thank you for always focusing on the victim.
Thank
in
you,
terms
Sunny.
of this particular, oh, you're welcome. In terms of this particular expert and what tipped the scales, I don't know if anything tipped the scales in her defense, because from this expert, what I actually got was that he leaned towards the Commonwealth in that explanation for what they were doing in the reconstruction of this particular scenario. I don't think he overly harmed her, but I also don't think he did anything to say that this actually didn't happen because of all of the different scenarios that they just showed. Now, I'm a former EMT from New Jersey. There's a plaque behind me on the wall given by the governor. So I've been to actual crime scenes, hit and runs, murder scenes with a hit and run vehicles. And I did not take away with all of the things that people think that he did in terms of helping the case. I think he might not have harmed her dramatically.
Miles per hour.
Before you
Just
play this,
go to the
Dr.
bloody-
Wolf, I failed to
Hey,
ask
look,
this.
your
It may
turn.
be obvious. After each of the tests,
Be looking from their own perspective, like we all are from this case, our own personal experiences, things that we know, that we've seen. And I think I would have told them to not use all of the clips from that reconstructionist video, because it doesn't tell the story for me that I know based on my experiences, exposure, and expertise.
Wow, really excellent and insightful analysis from you, as always. Sunny Slaughter, thank you kindly for weighing in. We're going to hit a break, and when we come back, we have 2 very special guests who are going to be joining us. One of them is a dear friend of Officer John O'Keefe, and the other is one of his cousins. They're going to join me live after the break. Don't go away.
I know. I know. It's so sad. It's really, really sad. Let's flick over to. I like watching different things. There we go.
To what we call the Bowden defense, because that's how Alan Jackson wanted to use you, that you can't trust the messenger here because, you know, how they got to giving the message was really, it's a legal term, screwed up. And therefore it's an improper, incomplete investigation. And you need the specifics from you to say that. So what were your final specific 3 opinions, if you're allowed to get them, if you think you're allowed to get them?
Yeah, I sort of want to be careful, and I think you realize why. I think generally speaking, my report laid out opinions based on those 3 things that I already discussed, which is what did they do? What was the best practice? And is it what they did inconsistent with the best practice and inconsistent with their own policy guide? And then I offered a conclusion of what I think ultimately those 3 I's, the incompleteness, inconsistencies, and inaccuracies, how that led to their final conclusion, and whether you want to call it improper or not, ultimately those steps, I believe, created a final outcome that makes it hard to trust that the process was accurate, consistent, and yielded the correct suspect.
Oh, I'm blown away by this, and I'm blown away by the fact the jury could not hear this, Michael Bryant. I mean, this is, to me, it's ridiculous.
It's wrong. It's just wrong, but it's not the first thing we've said that about in this trial. That's for sure. Let me ask you, Michael, are you going to be following this? I know you're on vacation, but do you have some curiosity about what's happening?
Yeah, 100%. You know, it's interesting. When I retired, my focus was on.
You retired at what, 35? What do you mean you retired?
I'm actually in my 50s, but yes, I retired with the focus of starting my own company to provide, you know, sell side and other location investigative assistance and trial and expert. What I found, and I never really thought about this sort of concept of providing investigative review, for lack of a better term, but it surprisingly has become up more and more since I've retired. Is, you know, because I've worked so much, hundreds and thousands of cases, is that just look at it, Mike. Tell us what you think. And it's not something I expected to do, but I sort of enjoy. And what's interesting is I've worked one recently where I looked at it, I was like, wow, great job. They did a really good investigation. And my response to the attorney was, have they offered you a deal? Because you might want to consider one. This is an incredible case. They did an amazing job. You know, it goes back to Mike, and it is if you do a really good case and you have great process, you have a great case management, the way you collected evidence, and it's easy and easy to navigate and absorb what happened, a great timeline. When you look at it as a on the other side now as a defense, it's like, oof, these people are prepared. I don't know if I want to go to trial with these people. Maybe I should consider a plea. Hey, client, this doesn't look good for you. Where this case, you don't see any of that, and I think that's sort of yeah, it's tragic. I think ultimately, and I think the tragedy is that, you know, this should have been done not only to the process or proper, but it should have been over the top done for John O'Keefe. That's how we would have done.
I've got the verdict form, but I haven't added it into it because it's a trial analysis. So it's I suppose I could give an opinion on its fairness, if anything. But I did do the analysis of both the closing arguments for the defense and for the prosecution. And what I'll do is I will add them to the Discord chat.
On it, you would have been. Now, these guys went.
Well, I remember
over investigated the case, not under investigated it.
Yeah. And I think as we sit there and watch this trial, we think about the O'Keefe family, and we think about how they're all in on this prosecution, and yet
I'm just waiting for
it really an investigation
answer the other one.
They should be proud of, consistent, and confident in, that the real criminal has been found, if there is one. And I think
Right.
the answer is no. And I feel for them because they're not going to get the justice that they really deserve.
Yeah, I totally agree. And when you watch the I think I was prohibited from watching this trial, but I tried to catch up a little bit the other day after I realized I wasn't getting called. But when you look at the last trial, watching that family sit there, I've been on this side of the government for a long time, clearly, and interacted with many victim families. And I remember working a young girl that was working at a liquor store, and she was shot point blank in the face. And that case was so devastating. The letter the mom wrote me after we found the three suspects, I keep it, and sometimes I still read it. It's just so. As a father of three kids myself and my own two daughters, it was.
Save it.
I mean, it broke me to read her letter and to see the grief. And that grief exists for them. You probably would expect after this to be a wrongful death suit against Karen, but there should be a wrongful investigation suit against Canton PD and Massachusetts. Yeah. They should sue them because ultimately it's their job to collect the evidence, identify suspects and eliminate suspects and come to the ultimate conclusion of who did it in a fair process.
Yeah.
I have two comments. One really is a comment. The comment you made before about how you advise lawyers and all on it. I always tell people that a lot of times you hire experts to give them advice because sometimes your expert will say, hey, get the plea deal here. And you can go armed with that opinion by somebody like you. It's not that when people ask, well, how many cases have you been hired on? You want to be in a high profile case? No, you're giving that knowledge to the lawyer to give it to the client so they can make an informed judgment. So that really is extremely important. And the second thing is you started your own company. Is there a link that we can post for your own company as to what it is, where it is, and where they can find your CV, et cetera, et cetera, et cetera?
Yeah, I'd be happy to provide something if you guys wanted to post it later. I'm not sure how I would do it right at this moment, but
he's on vacation. Come on, Linda.
Everyone's
I would appreciate that.
Yeah, we would like to do that. And the funny thing is, we have everybody in this. I don't know if you've found this. Has named people like they've named Dr. Wolf, Crash Daddy. We had Chris Plord. Steve Plord, who was in California, who was a major accident reconstruction on this, who's been going on and talking to us honestly about what the police didn't do and didn't do. He was spent 45 years with the California Highway Patrol, and his opinion too, this was an absolutely abomination of an investigation. And he's been named Crash Lord Plord. So I'm not sure how our viewers are going to name you. I don't know if they're going to call you a police daddy or what.
I've seen a few suggestions here. We'll have to see how that comes down.
So Daddy Easter. Daddy Easter.
Wow.
Linda, you bring up a good one. Is CHP? I've worked several vehicle homicides, people trying to get across the freeway or hit by a vehicle. CHP, that was sort of what I compared this crash investigation to, because ultimately it has to be a crash investigation, which no one ever really conducted until years later, it seems like. Minus Trooper Paul, his attempt at that. We could probably spend a whole show on Trooper Paul, but the CHP is incredible at this. They do an amazing job.
All right, have a read of that.
The amount of effort that they go into crash reconstruction is incredible. CHP is an incredible organization for that.
Yeah, and we could tell that, and he was pretty honest. He even talked about it.
I just did a prediction from the AI to see what the outcome was be and how long the deliberations would take. So I've just put that up on the main chat on Discord. I just said what I was saying here. Yeah, I know. Well, the only thing I can think of is that right from the very start, if you remember, when Karen went back, when she left the hospital and went back to John's house to collect her stuff, and she was confronted with Peggy and, all of John's family were there, and Paul got the phone call from Michael Proctor right then and there and went into the other room and took it. And from that moment on, that was the end of it for him. And that was what, 4 hours after the actual incident, after he'd been found. And he's telling Paul that he has a suspect, he knows what's happened, and he's going to go and seize her car and her phone. Zero investigation. Zilch. So I'm actually I'm sitting here and I'm in pain. So I might go and do a verdict watch. Lay down. My back's killing me. Shouldn't be, because I haven't done. There's stuffing around with my tablet at the moment, my painkiller. So I'm transitioning across. And yeah, I'm struggling. So I'll keep this one on, the Justice Serve TV. And I shall go and log on and watch with you in the boudoir. Alrighty.
Something about we didn't even know about the diffusers and the light, that they're so far deep in there that to get in there, you really have to get in and actually break them. You know, a small hit, you know, a side hit, it's not going to break those diffusers. Something I didn't even know about, that I was learning from him as he's talking, and that you know, that was a big deal. The scene wasn't locked down, that there weren't patrol cars, that you didn't even wait till you could wait till the snow melts. You just secure the scene, wait till the snow melts. You'll see where everything is, whether it's a day, 2, 3, whatever. Yeah.
I totally agree with that. And you sort of hear excuses of, oh, the weather. Well, at that moment, the weather wasn't that bad that Karen Reed couldn't drive around in her Lexus, by their accounts, under the influence. You know, you got Kerry Roberts driving around. And you look at some of these videos, the roads were pretty empty, but you know what was driving around was snowplows. And having worked some very remote locations, you know what you end up doing is people that are getting around, hey, give me a ride. I need to get somewhere. Like when they say they couldn't go back to the police station, there was 1.5 miles to get proper evidence collection bags. Why don't you ask one of the snowplows, hey, go back to the PD. One of the people at the police department is going to give you some evidence collection equipment. You're going to bring it back here, right? Yes. Thank you.
Yeah. Or one of the other folks that should have been there to help. And I mean, it's just laughable.
Right.
And you'll be happy to know, now that they've had the audit, you know, they did an audit of the whole process. Now they've put little baby CSI kits in the squads.
Right.
So at least they have that.
You know, it's interesting. When I saw that, I was just shocked. I was like, you know, when I worked a gang task force, a gang and drug task force for about 8 years. And you know what I had in the trunk of my car? An evidence collection kit. Because at any moment, you're probably going to collect some drug or weapons from people. And you have to collect it properly. If you don't start at the beginning being prepared, you've become unprepared, right? So absolutely. You know, it's interesting, you brought up the vehicle again, and I wish I could share something that I saw in the evidence that if they would have collected, I think would have answered a lot of questions.
Well, don't tell us now. If there's a not guilty verdict, save it. If it's a not guilty verdict,
I mean, ultimately they missed things that you know, it's interesting. They sent preservations for things but never followed up. And that's indicative of what we talked about earlier, is that by the 2 o'clock briefing that they probably had, they'd already decided who did it and never went back to collect things that they had sent preservation letters for.
Yeah. I just noticed Jason Hodges had a note. They need body cams too. Well, they did add those. They have body cams as well. Before I let you go, I have a question about your name, and it relates to a dumb story about my son. Okay. Easter is an interesting name, obviously. So I want to get the derivation of that. My kid, who was living in the East, goes to San Diego State, and he gets the nickname Easter. And I thought, oh, it's because he lives in the East, right? No, it's because he's wearing a shirt one day that everybody thought you'd wear to Easter. It was like a short sleeve, little dress shirt you'd wear for pictures with the family. So where does Easter come from? What's the derivation of that name?
That's a great question. My dad's family's German, but people keep telling me I look Italian, so I don't know. I'm
Italian.
If you want to make the story even funnier, is my dad's was a reverend or a pastor. So the name Easter, obviously the
you go to see a Reverend Easter for Easter.
Yeah. Yes, and what my youngest sister was actually born on Easter Sunday, believe it or not, one year. So you can't make these things up.
No.
But Yeah, growing up, I wasn't called Easter. I was called Christmas. I don't know why. Anything, just some other holiday.
That's funny.
Well,
Yeah,
we
could
hope-
have been worse. Could have been Halloween or something. Could have been Flag Day.
I even get today people, but what's funny is my name's spelled just like Easter. I usually say Easter like the holiday, and people always look at me cross-eyed. And I'm like, really? Or how about Easter Bunny? They're like, and it's like you could. What are we talking? Everyone's most of the time it's not Easter, it's Esther, and I don't get it, but whatever.
Well, we put our thumbnail on to advertise, but we didn't want to tell people you were coming on because we didn't want any chance that you couldn't come on, that somebody would say there's some kind of gag order, because there's not. But we held it, but we put on our, and if you were smart, I think somebody figured out Easter Monday verdict question mark. And we just said
I thought it was sort of a play on the Easter Sunday concept, but yeah. Yeah, I mean, clearly I have limitations of what I would discuss just professionally, because that's their evidence, their request. I think in general, we can have a general discussion about it. I was not a witness in the case. I'm not aware of any gag order that was presented to me.
Right. You're not a witness.
But clearly I don't have opinions that I would offer that I think would violate that trust. And ultimately I can't have opinions about the FBI investigation because of non-disclosure agreements. So our discussion is general topics.
Yeah, and I've been bugging Mike for a while, so we are so happy that you took the opportunity, especially when you sent me that first note, said I'm on vacation. I immediately was thinking, okay, a week or two, we'll get back to him. And you were complaining you didn't have a suit. I think I don't see anybody complaining about your attire. Not one person. So
well, yeah, I didn't bring a suit and didn't bring a collared shirt on vacation. So
good for you. That's the way it should be. That's the way it should be. We understand. So anyhow, so we hope to try to get you back if there's a jury verdict, get your opinion, especially if it's not guilty.
But I would love to discuss it again if you have other matters that you're interested in discussing. I'm always great. I mean, this is an area that you would think I would walk away from the law and that stuff. But, for the last decade of my career with the FBI, I taught witness testimony. I taught agents and investigators across the country how to be good witnesses. And so the interaction with lawyers and the courts is super interesting to me. I wish in some ways my wife, because she should have gone to law school. And I love the discussion. People think of it as an argument, but I think of it more of so I grew up as an athlete and being a competitor, and court to me is a competition of wits. It's like a battle of the minds, and how do we interact with each other? And so what's interesting is you see, like, even in this case, people would be like, oh, they prepared you to testify. And the reality is it was sort of looked at as like this icky sort of moment. But the reality is that both sides do it. Both sides prepare their witness. And oftentimes I even tell when I teach witnesses, it's not just as much a preparation for you as a witness. It's a preparation for the attorney of how they should be asking you questions. What's your style for your going to response, so that they're asking you questions that one, the answer to, and one that you're capable of opining upon. And so I think ultimately, when people ask me that question about didn't they prepare, attorneys have years or decades of learning how to ask questions. We should teach witnesses how to answer them, right? And because it's not intuitive. The interaction's not intuitive, and oftentimes you'll see in newer witnesses is that the defense themes that they have the most trouble with are ones that make them feel defensive, and they instantly get very defensive. And there's no reason to be defensive. Did you prepare to be? Did the prosecution prepare you prior to trial? Yes, absolutely. That's it. There's nothing to be defensive about. Of course. When I get asked that question, yes, absolutely. Every time. I like to do that. It's a very important aspect of being an expert witness, is helping prepare and provide I had one guy, you provided a direct script to the prosecution. Absolutely. I do it every time.
Interesting. Have you had a ham sandwich lately?
Yeah, right. Don't get the bureau in. What is it? One of the bureau signs is a ham sandwich. More roast beef, right? I think was the old bureau standard. But yeah, guys, it's been really great being on. And if there's something else that you whether it's this matter or another,
That's great.
Invite me on. I'd love to.
Absolutely.
I got plenty of opinions.
I'd love to have you on with Crash Daddy Plord, actually, because the two of you really get along about your experience being from the law enforcement side and seeing things and calling them as they are. And you can't have a better witness than that. You're not witness Dever, never say Dever. And poor Yuri, and I don't know if you caught up, poor Yuri mechanic who speaks 5 languages, asked for a dictionary on what was the word?
I saw that. What was it? What I can't remember the word. I want to say
I can't remember the word either. Was it theory or was it? I can't even remember. It seems so long ago.
It might have been an I word too. I had to watch everything super fast because I was there, not a gag order, but there was
a sequestration, right?
Sequestration,
just in case they pulled you back in.
Yeah. I mean that's sort of more my wheelhouse as well as the examination or the review of witness testimony. And you know what I thought was the most dramatic in terms of law enforcement testimony was how poor the law enforcement for the Commonwealth testified, which is they need to be the standard. And in fact, the standard wasn't them. The standard was some of these just civilian witnesses with limited to no testimony experience. And instead, Yuri should be the gold standard for testimony if he really has the experience that he says he has. But instead, I found him to lack a lot of credibility. He seemed to have a perfect recollection when it benefited the Commonwealth and a flawed recollection when it benefited the defense. And you just saw him constantly filibuster in a way, which is never good when you're a fact witness. Shouldn't be filibustering. It's the facts and only the facts. He could have come off as if he was to be presented as the Commonwealth's gold standard. He knows everything. He was part of everything. He's our go-to. He should have been prepped slightly better to be a sort of a cooperative with defense. Yes, that's right. No, that's not correct. He should have been the yes and no man. And instead he was the let me explain this. Let me get ahead of this. Let me explain it in my own terms. That's never good for a fact witness. Fact witness should never be doing those things. And I cringed when I watched it on fast forward, but it was very cringe. Even his demeanor of sort of, I'm up here on the king's pulpit, just lean in and relaxed in. I didn't like any of it.
Remember, he was effectively the replacement for Proctor, so the bar was pretty low already. But yeah, he was bad. He was a horrible witness, and I'm sure the jury is kicking around his testimony right now.
Yeah. Before we let you go, this is a great question because you were denied because the judge said it's within the ken of the jury to know how the police procedures, that the jury understands what was wrong with the police procedures. And this witness, Colin Sixter, does Mr. Easter think Joe Public knows what police procedures and best practices are? And that's why how she denied you. She said, of course they know. So I guess that's the ultimate issue.
You know, I don't have opinions about the judge in this case because that would be improper.
No, not the judge. I'm not even asking about this. Do you think that the normal person knows what you were going to testify about? Is it within their normal ken by just watching this jury? I guess that was the issue.
I'll give you the answer I think Yuri should have given. No, I don't. That's not to disparage the public. I think you have some very informed public that have more experience watching crime scene stuff. But your general public, if I were to go ask my mom these things, she'd be like, oh, no, you can't do that. No, mom, you can't do that. And that's not because my mom's not smart. It's just that there's certain nuances to law enforcement techniques that aren't generally known to the public. And I think the things that I think we could all agree that you don't collect blood evidence in a solo cup. I mean, that's common sense. But if it's such common sense, then why did the cops do it? Right.
Yeah.
Right. So then it begs the question is, if common sense is so common, why did the cops commonly screw it up? And so then it just needs to be pointed out from another professional. Another professional needs to come in and explain, no, ladies and gentlemen, I want you to know that this is not how it's done across the country. And clearly I'm not a spokesman for all of law enforcement across the country. I'm only providing my opinions based on my own personal training and experience. But I can tell you, I can't imagine another law enforcement officer looking at this and objectively and thinking red solo cups and a grocery bag and a leaf blower was the best practice.
Yeah, it's crazy. Well, I don't know. Based on what we've seen and heard of you and our chat, I think you would have had a pretty powerful impression on this jury, but unfortunately, they did not get that chance. So, Michael, thank you so much. Hey, I have a lovely car for you. You know, pick one of these car off my lot. Thanks for coming on, man. And I will reach out again. I guarantee it.
Thank you.
Yeah, thank you. Appreciate it. Have a good one, you guys.
Go vacation.
Thank you. I appreciate that. I'll see you guys later. Bye-bye.
Thank you.
Great guy. Yeah. Too bad the jury did not get to hear from this guy, right? That's
wow. I know Disney's going to ask me, I'm going to say, can we cut that as a breakout and run it over and over again? I don't think I've used a lot of police procedures experts. I don't think I've ever seen one that good, that informative, that can tell you and speak. And that's one of the things he says. You got to be able to relay this to people.
Of course. And, I'm reading the chats and I noticed a number of folks could not get past how unattractive he is and how hard he is to look at, because I couldn't even hear.
Some of us are so shallow.
Yeah. Like, all I'm doing is looking at his dimples. So, okay, here we go. So yeah, this is like a TV expert witness, right? I mean, this guy's from Central Casting. You wouldn't believe him because
I believe everything he said was that. I believe that.
He takes a stand and go, well, I don't know what he's got to say, but I like it.
Yeah. So we can't cut it out to after the stream ends, but yes, we will do that. I mean, people should go back. We can tell people to go back and start watching the beginning of the stream from about 10 o'clock. He was about when he came out, 10:02.
Yeah, and I told him 20, 30 minutes, but obviously he was happy to share his thoughts, and I'm glad that he did.
Yeah, no, he's just and give it and to sum up, I mean, I have obviously more than I have in my writing with him. Incomplete, inconsistent, inaccurate. Incomplete, inconsistent, I can't remember the three eyes, inaccurate, right? Inconsistent, inaccurate. That's how, and he just thought about those today, about summing it up into those 3 words. Okay. Yeah. I mean, and just, it was fabulous. And how's the jury going to know all this? Unless they're told. You're absolutely right. They think that this is all proper.
Other than the very obvious solo cup leaf blower, I think, yes, I get that. People will think, oh, that's odd. But beyond that, you need a pro to explain to you what should have been done and what was not done.
Yeah. Now we did.
I do think it's an interesting, point that he made early on about how this was one of the, brothers in blue. People should have been parachuting in to help out. Wow. He would have walked in the snow to get there to help out. But why didn't that happen? And even though he wasn't really able to answer that in the context of, well, maybe he had some other cops with, different priorities, the impression is there.
Right. Absolutely.
There has to be some motivation not to help a fellow downed officer.
Yeah, there was something and he said that everyone should be happy. We have a super chat from Vintage Lady. Sorry I held it for you. We didn't want to interrupt Mr. Easter on his vacation or look like we were doing that just for donations. But now we can talk. Vintage Lady, thank you so much for this donation. Lyndon, Michael, great work. Loved listening to you both. Donated TV 6 years ago, phone news and vile content commercials. Thank you for not going on Fox Percy. I went on Fox Nation because I was one of the panel asked to. As a lawyer, and my opinion was the case had not been proven beyond a reasonable doubt. I've been on twice, and I got into a little tete-a-tete with John DePetro, and that simply had made the rounds in the news, because there's links to it. We even have, I think, you have to go find it. We can't post it separate and apart because it would be on YouTube a copyright violation. But there are links to it, and you can go find them. So, but yes, we have our own streaming network here. We're streaming, and people may want to watch Mr. Morrow. He's a very nice man. He's got a show, and everyone's going to be streaming this verdict when it comes in.
Of course.
So, and he's a lovely, even if, he may think differently than I do, but he is so respectful, and it's lovely to be on with him on his show. Not so much maybe with some of the other guests.
Well, he makes you look good, and somebody needs to slap that guy around. He's just embarrassing.
He's okay. I did not ask about the 227 search CLT. I think because he answered it in the what he said about the data with Celebrate and the time that you can't rely on. He doesn't rely on the times for anything. Any of these apps, he doesn't rely on time.
No,
so I think
I was glad to get some support for my belief that it is just too much hocus pocus still. Maybe it'll be better someday.
Yeah. And I'm sorry, Ashley, I didn't get to him. Did he see a lead investigator like Michael Proctor? I think we kind of know the answer to that from how he told us.
And as nice as he is and professional, I'm not sure he'd be using the words
No.
most would when describing Michael Proctor.
He wasn't going to use, you could see that he wasn't using words that necessarily denigrated people. And I think when we get to Proctor, we're going to use those words. Michael Bryan and I are going to use those words.
He's earned it. So, he's earned it.
Yeah. So, yes, the judge denied the jury slip change. I wonder what the slip, we have to go look and see what the slip was that was asked for, right? We have to go look to see what the
changes proposed were.
That was asked for. I'm sure. I mean, of course, as far as I'm concerned, you could burn this to the ground, this jury slip, but that's not going to get anywhere at all. So, Michael, you did a great job getting that first interview.
Oh, happy he was so helpful. It was,
so helpful.
Yeah.
So helpful. You cannot, we don't know. Disney says we don't know.
It wasn't attached to the motion.
Oh, what else? What else? What else? Let's see. Let's replace the jury slip with one, and we don't attach it.
Yeah, that part was impounded, I'm sure.
Oh my goodness gracious! Oh lordy!
So,
but I did. You know, it was interesting. He says he's not going to tell anybody, but there's something that could solve the case one way or another. We'll never know what that is. It's I felt like when he said that.
Interesting.
There was the movie Twilight Zone, which I replayed all the time. You can get them on YouTube.
Submitted for your approval. Yes.
Oh my gosh. I remember an episode that I watched, and there was a courtroom scene because I'm a lawyer and I'm rewatching these replays, and there was a question about whether or not a knife that somebody had was a knife that caused the injuries, and they were starting. That was the time I guess they were starting to see whether or not you could sample for blood, that had been on the knife or not, right? And they didn't say what the test was or anything like that. It wasn't that. And at the very end, somebody took the knife, and just before they could do the test, cut their arm so there was blood on the knife, and so you would never know the answer, right? It was just a dramatic. Well, I don't know what the episode was called, but it was so dramatic. Okay, and I think that was that's what I felt when he said that.
We'll get to the bottom of that on a subsequent visit, I think. So
yeah,
we got to wait and see if the dust settles on this case, because let's face it, if there is another hung jury mistrial, I think most believe they will try Karen Read a third time. And if that happens, perhaps Mr. Easter is involved. Who knows? Perhaps I don't know if it would have to stay with Judge Canone. I think she would want to maintain control of it, but I think there would be a strong effort to get her recused.
Yeah, and the problem is that Karen Read may not have. I mean, she has kept these lawyers in court almost every day since January this year. Okay, almost every single day they had to come in, they had to fly in, they had to do this, they had to do that, they had to bend over backwards, they had to bring ARCA in. She was always gravely concerned, And I'm not sure. First of all, I don't know if Hank Brennan would retry it if he were involved, right? And I'm not sure that the defense can retry. People can't spend a year away from their offices on cases.
Sure, and family and other clients, and
right.
Yeah.
We are in the twilight. Someone says we are in the twilight zone. Good comment.
That is true. We're definitely through the looking glass, people.
Yeah, that was Sharon Logue. We are in the twilight zone. Good comment. Really good comment, Sharon. Let's see this. That is a great comment. We are in the twilight zone, I have to say. Again, let me show you Michael Easter's website, and but now he's branched out though into police procedures. I can see why. Whoa.
Yeah. Well, look at his FBI background, his police background. Yeah. Pretty amazing dude. He's done a lot in really a pretty short period of time.
Yeah. Now, you haven't been able to get close to the courthouse, Tom?
No.
Well,
it's over there somewhere. It's not far, but no.
What you've done, I need to compliment you, and I want everyone to. I want to hear. Yeah, we do. Michael Bryan, we started this case when we were there before, but he's been there. This is, I think, your 13th time now, right? Maybe 14th. I've thought. I think it was your third. I thought 13th may have been Friday, and this is 14th. because Friday the 13th is the 14th. But you, when we first started broadcasting for this case, April 1st, seems like it was a year ago, but it was April 1st. You were there and you were going around, you were talking about how the paddy wagons are there, and you heard the police say, we'll give them one warning and then we're going to arrest them, basically throw them in the paddy wagon and all. And then you were back and forth and you went to see and you met Scott and you met Tom, CPU. And you were gathering with your microphone, you're gathering what's happening, what people are doing. And then you passed the officers and you passed Hardman. And I'm not going to go through the whole story. Who told you that basically you have been going past her? He's been watching you 5 times, doesn't want to see you come back. From that, you and Tom CPU end up filing a lawsuit. You with Jason Grant, one of the people holding signs, filing that First Amendment lawsuit. And there was the buffer zone prevented people from going into the buffer zone for a long time. Well, you should see what the First Amendment zone is that you're responsible for looks like today, Michael Bryant. You would be proud that you stood for the First Amendment, and we here at Justice Served TV are proud of you.
Well, I appreciate that. Just doing the right thing, right? And I think, having not been more than driving past today, I think it's even busier than it was Friday. For the reasons I mentioned, people had a chance to think about it over the weekend. Let's do it. Let's go. So I'm curious to see, how far afield people have come from. I know somebody that Tom had on earlier was
Sorry.
it's not far, but it's a drive. It's a drive.
Oh, I got halfway down the hallway and got hamstring cramp. That fucking hurts. So I've just made it to the bedroom. I'm out of breath, but I'm here. Fuck, I hate cramp.
I'm going to throw a programming note, unless you just, unless you got something else lined up I'm unaware of. We talked about what we're waiting for, verdict, questions, whatever. Our Justice Watch continues, and now we've got to be pushing close to 4 hours now. I don't have the official clock, but I think we got to be getting close to 4 hours. We thought about running the closing arguments from the sides, just to give folks some recollection as to what was happening most recently, what this jury is thinking about. So I'll throw that out there. I'm going to break down here, relocate somewhere closer to the court, and then I can go wander and get people's reactions. I do want to take the verdict slip, which we now know has not been changed, and get people's reaction to it and ask, how they would approach it. Because how do you know? People don't get a class on how to go through a verdict slip, and they sure didn't get one here.
Right.
So that's my plan. What do you think?
I think it's a good plan. Just give some notice to Georgia. GA Hello Kitty became a YouTube member. GA Hello Kitty. Thank you so much. And Joey Kane again gifted another Justice Served TV membership. Thank you. And then Joey Kane gifted another Justice Served TV membership. Joey,
it would not be Justice Served TV if Joey Kane did not gift a membership.
Yeah, somebody just said 007 Texas, Joey, the giftiest membership gifter. Oh, that's so great that you're being recognized even by the people that watch you. I think it's a good idea. Just before you go, we should tell people that they can go back and rewatch the beginning of the stream starting about 10 o'clock to listen to Michael Easter, because we would have to start a whole new thumbnail, a whole new stream, and we can't do that in the middle of the day. To listen to what he just said, it was just
really
absolutely amazing. And then also, we should mention to people that we are going to be on all day, and that the jury consultant, Richard Gabriel, thinks that it's going to be tomorrow or at the latest Wednesday, only because he thinks that everybody wants to wants to hear what they, wants to give an opinion about what they heard. Neil Rockheim. Okay, Neil, by the way, I'm going to show this because he is on call. He will be with us. Neil, just send me a text of when you can next come on, maybe after closing arguments, we review them. Ideally, they should have had the verdict form before the closing arguments. If they had it beforehand, Jackson could have given a suggestion on how to fill it out. Yes,
crazy
that's
idea.
What we do. What a crazy idea that possibly was.
It was almost as an afterthought. Yannetti says, Judge, can we have verdict slip? Oh, all right, here. I mean, are you kidding me?
She was talking about it like, you want this, and then I'm not going to do that because the Supreme Court said I'm right. Well, no, they actually didn't. They said, so you're right for this portion, but even if you were wrong, the remedy is she got a new trial. So we don't need to deal with that.
The appellate court didn't really get to the merits of her decision making. They just said there's already a remedy in place. Bye-bye.
By the way, thank you, Special Bendy Brothers. I really appreciate the compliment. Okay, so we're close to 4 hours, even on the another network's verdict clock watch. All right. Neil's going to let me know. I know he did let me know he can probably come on a little bit in the afternoon. And we do have Steve Plord on call. He will actually leave his deposition if he needs to come on with us if a verdict is going to be announced. And we'll try to get him. He's in California, so there's a little bit of time difference. I know I told him to watch Mike Easter's interview, by the way. So why don't we do that? Why don't we play? We had to really. We'll play Alan Jackson's.
Yeah, I would just do them in the order that they came. Okay, but I'm gonna go sell a couple of cars here. Look what we
Okay.
got here.
Oh, wait a second. Wait, there's a
Van. This
fan.
beautiful van.
Does that fan mean? Wait a second. Does that fan mean that
wait,
we have a
something's
question?
happening?
Does that fan mean that we have a question that they're going to open in court? Because you may not want to break down if they're going to open. Dizzy, do we know?
Is there some audio? Any clue? Should
Any
we
clue?
riff here for a second to see if that's anything? It's too early
just let me
for
see.
official lunch break. They've not had
it's-
to deal with that yet. You know, do they deliberate during lunch? Do they bring the lunch in? They haven't.
No, but I don't know why there's anyone looking on your monitoring. I think Aiden is in the courtroom this week.
He
or
is.
No?
He's in
He
this
is.
week.
Okay, and I know that. Let's see if he's got anything on there. I know that John DePetro also won the.
Shocker!
Shocker! Yeah, won the.
And I heard they put his name on one of the seats. That's what I heard.
Oh my goodness gracious! All right, so I don't see anything from Aiden. He's inside the courtroom with the day 2, so he hasn't put anything on. So I don't know. So you want to go try to set up, and if
I'll
the
do
fan
that.
has been there for a while, so if something happens, we'll go on, and
Okay.
Text
So
you.
in the meantime, enjoy these closing arguments.
All right.
Obviously, the
Alan
jury is
Jackson
thinking
first.
about
We're going
all
to
of
run
this.
him first. Yep, we're going to run him first. Bye, Michael. See you soon.
All righty.
All right. I'll wait till we start the arguments. I will keep my avatar, the 2B avatar, on the left, but I will be here in case the jury comes in or there's some question. But I do think it's a good idea to start the closing arguments while Michael goes to try to show this verdict form to different people and see whether they can get a reaction of, from ordinary people who are not trained lawyers. Trained lawyers don't even understand this, but say it's dangerous, right? Because it kind of suggests guilty, 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 guilty. It kind of suggests all these places to put guilty and only one place to put not guilty. As if you have to find Karen Reed guilty of something. So as soon as we go to playing Alan Jackson's closing, there we go. I'm going to go behind my avatar and let's watch and let's remember why we're here.
Collision. There was no collision. There was no collision. I want to take a minute to start off with thanking you. I want to thank you for your attention. I want to thank you for your patience. I want to thank you for your diligence. This is not an easy undertaking. Most of all, I want to thank you for your courage, because courage is what this moment demands.
Yep.
Not just to listen, but to stare directly at injustice and say, not here,
not today,
not now, not on our watch. That's what you're being asked to do. Stare down injustice. I want to start with a simple truth. You folks, not us, nobody else in the courtroom, you folks are the last line of defense. The last line of defense between an innocent woman and a system that has tried to break her, that falsely accused her, that tried mightily to bury the truth. This case was corrupted from the start. It was corrupted by biases, and conflicts, and personal loyalties that you heard about. And most fatally, it was corrupted by a lead investigator whose misconduct infected every single part of this case from the top to the bottom. In our opening comments to you a few weeks ago, we told you what to watch for. We warned you what to watch for. We begged you what to watch for. Watch for the physical evidence. Pay attention to the medical facts. Pay attention to the science and the physics. But also pay attention to the integrity, the very essence, the integrity of the investigation. But you also saw something during the course of the trial that none of us might have expected, something that should sadden us, something that maybe would anger us. On full display, you saw the lengths to which some police officers will go to protect their own at the expense of the rest of us, at the expense of Karen Reed, an innocent woman. Before we examine the evidence in the case, which we will do, we need to understand the very foundation of the entire system of justice in which we operate. It's the bedrock on which this entire system is built.
Look at
reasonable doubt.
Unless
This
he's
isn't just a
fake.
technicality, and it's not a slogan.
Absolutely
It's a
riveted.
constitutional shield that protects the innocent and prevents the government from punishing without proof. The Commonwealth has the high burden to prove every single element of every single charge beyond a reasonable doubt and to a moral certainty.
You're right.
As I said, those powerful words are not just some legal jargon. They're your mandate, they're your obligation, they're your community's protection against injustice. In our system of justice, Karen Reed sits here today, presumed innocent, cloaked in the presumption of innocence. That presumption is not fragile. It doesn't just disappear because there's a charge or a badge or a theory. That presumption stands firm unless and until the Commonwealth clears that high bar, the highest bar the law provides, proof beyond a reasonable doubt and to a moral certainty. That means at the end of this case, at the end of the trial, you think about one or more of the charges, you think, you know what, maybe that's true. It might be true. Then you vote not guilty. If you think it's possibly true or probably true, your vote must be not guilty. If someone among you thinks it's likely true or even very likely to be true, your vote is not guilty. It's because none of those standards, maybe, might be, possibly, probably, likely, very likely, none of those meets the extraordinary burden
You guys hear
of
me?
beyond a reasonable doubt and to a moral certainty. A moral certainty means a level of confidence so strong, so incredibly unshakable that you could go home, you would go home, look your loved ones in the eye and say, I am certain. Not probably, not likely. I'm morally certain, and my certainty remains unshakable. The law defines moral certainty as the highest level of certainty known in all human affairs. Think about that. You must be that certain about the entirety, not part of, the entirety of the Commonwealth's case. As we discuss this case, you'll see that the Commonwealth comes nowhere near, nowhere close to reaching that extreme burden of proof. Ladies and gentlemen, on January 28th, 2022, it was a Friday night. John O'Keefe and Karen Reed made plans to meet up with friends, go out for drinks. You saw through video evidence and eyewitnesses that they were affectionate, they were loving.
No
they were in
worries,
good
sweetheart.
spirits throughout that evening.
I'm just listening
They started
to.
off at C.F. McCarthy's, which you've heard about, and eventually made their way over to the Waterfall Bar and Grill. When they got there, the Albert family, they were already there. And they were already drinking. The Albert family, it's been established as a very well-known family in Kenton. They've got quite the reputation. Brian Albert was at the Waterfall, longtime Boston police officer. His wife, Nicole Albert, was there. She was with him. His brother, Chris Albert, who was a Canton board selectman. He was there. His wife, Julie Albert, their daughter, Caitlin, and his sister-in-law, Jennifer McCabe, whom you met, and her husband, Matthew McCabe, whom you did not meet. They were all there drinking before John and before Karen ever arrived. But also present at the Waterfall that night was Brian Albert's friend, Brian Higgins. We know that he had a romantic design on Karen.
Just
That
you
becomes an
wait,
incredibly
Brian
important fact
Higgins. Just
as we
you
discuss
wait.
the facts of this case. As the bar was closing around midnight, the Alberts invited everybody back to their house. They wanted to keep the night going. But the evidence revealed something interesting, that the invitation to John
You'll
O'Keefe
be
appears to have
sorry,
been
but
for a
your
different
flower
reason,
will be too
an
late.
alternate reason. Think about the video of Brian Higgins and what Michael Proctor in his investigation completely and utterly ignored. Higgins was agitated after a day of drinking, agitated that it was John and not Karen, John with Karen, not him. Recall that ominous text that he sent to Karen with her and John standing just feet away.
Well,
he got no response. And then we see this.
well,
That's what Brian Higgins was confronted with following his well text. What of all things starts going through Brian
that was
Higgins' mind?
fuck you.
Where does his mind go? What is he thinking about after seeing this, after witnessing this? He shows you. And if Michael Proctor had been the least bit interested, this video would have shown him too. Take a look.
Busting out the popcorn, folks.
Sparring, practicing, fighting techniques. Where was Brian Higgins' mind? What was he thinking about? And then what happens? Before you look at the next video, think about what you're going to see. This next video is after he sees John kiss Karen on the forehead, after he sends that aggressive text to Karen with her standing just feet away. Watch closely, and this is what you're going to see. This is what Michael Proctor and his investigation completely ignored. Higgins is very clearly upset. He's agitated. Chris Albert tries to control him, tries to talk to him, calm him down perhaps. Chris forcefully grabs Higgins' arm. You'll see that in the video that you're about to watch. It appears that Chris is trying to calm him down from something. Brian Albert's standing right there with the other two men, but Brian Higgins is having none of it. He appears to be hyper-focused on one person and one person only, John O'Keefe. In an instant, Higgins angrily jerks his arm away from Chris. Higgins rubs his brow, and he directly gestures at John, a gesture that looks a lot like, let's step outside. Let's go outside. But John looks at him, takes a swig of beer, completely ignores him. Take a look. Michael Proctor, the lead investigator in this case, had all this footage, but he did nothing. He had access to the exact same thing that you saw. Why did he do nothing? A few minutes later, Higgins then texts John directly. You coming here? 3 question marks. It's now 12:20 a.m. These guys are not good friends. They barely spoke or even acknowledged each other when they walked into the bar together, other than a quick greeting. So why was Higgins coaxing John over to 34 Fairview? You coming here after this? And why not text Karen? Because at that moment, he wasn't interested in Karen. He was interested in John O'Keefe. This is about 5 minutes before John gets out of the SUV and walks toward the house. About 5 minutes before Karen sees him alive for the last time. So what happened inside that house, or that basement, or that garage? What evidence was there for the investigators to look into? What did they ignore? Laceration over John's right eyelid, black eyes, a large dog at the home, an obvious dog bite on John O'Keefe's right arm, a head injury from falling backward onto a hard surface, alleged surface, a text from Higgins, one of the last people to ever communicate with John O'Keefe. "You come in here?" Those words now echo in the wake of John's death. But Michael Proctor, he didn't listen. When John didn't come back outside, Karen, very oblivious to what had happened, thinking she was just left alone in the car out in the cold in the middle of the night, she got frustrated and she drove home. She arrived back at home and her Wi-Fi connected to John's, her car or phone connected to John's Wi-Fi at 12:36 a.m. It's an important time, 12:36 a.m. She left John voicemail after voicemail after voicemail. He was unresponsive. He didn't pick up a single call. He didn't respond to a single text. The longer he didn't respond, the more upset she got. Her voicemails reflect that frustration after the fact. That's the frustration that you hear in her angry voicemails. She uses harsh words and foul language. She's obviously upset. She's obviously irritated because he didn't come back out of the house and he wasn't responding. But Karen did not know what you know. She didn't know what the investigators should have known. She didn't know what was happening with Higgins and Albert and with her boyfriend, John O'Keefe. When he didn't come home at about 5 a.m., Karen went looking for him in a panic. As you know, her worst fears were realized when she found John beaten, battered, bloody, and left in the snow in Brian Albert's front lawn. At 6 a.m., when Karen found John, you heard about the scene. It was described in detail. It was chaos. To use Mr. Brennan's word in his opening statement, it was bedlam. The screams for help by Karen, the yelling and the hollering, ambulances, emergency lights, fire engines, ladder trucks, paramedics, patrol vehicles, patrol officers, all of them swarming all over the lawn just under Brian Albert's bedroom window. And of course, as you learned during the course of this trial, Brian Albert, a sworn peace officer, a first responder trained in being a first responder, never came out of the house.
I can't believe none of them picked up that
Never went
article for
outside to help a fallen fellow officer who was laying on his own property. Never came out. And you learned through the undisputed evidence that the lead investigator, Michael Proctor, for his part, never went into the house. The Commonwealth has struggled to try to prove that John O'Keefe ended up in Brian Albert's front lawn because he was struck by a vehicle. They have failed. They cannot and they will not ever be able to prove that John was struck by a vehicle beyond a reasonable doubt and to a moral certainty, because the science does not lie, the medical evidence does not lie, the physics do not lie. Their investigation was flawed from the start because their investigator was corrupted from the start by bias, personal loyalties. Folks, they cannot prove a collision. John O'Keefe was not hit by a car. There was no collision. So let's start there. I want to take a minute to discuss the actual science, the actual physics, and the actual medical evidence that was presented in this case. The science, it's an old saying, is known as the silent witness. It doesn't lie, it doesn't forget, and notably, it doesn't take sides. If there was no collision, what are we doing here? In order for there to be a collision, there has to have been an impact site. The vehicle had to have struck John, period. I want to remind you of some of the most important testimony in the entire case, and it comes from the Commonwealth's own medical expert, Dr. Irini Scortibello, the Commonwealth's medical examiner, someone governed by law to make these decisions. We know that a person struck by a vehicle suffers massive trauma, broken bones, fractures, soft tissue damage, torn ligaments, contusions, soft tissue injury, severe tissue injury, crushing blows. None of that was present with John. None of it. Not anywhere on his body, including his right arm. Not one bruise. Nothing. The fact is, the injuries are not from a vehicle impact. Not his head injury, not those scratch and bite wounds. Not a single medical expert. Think about this. Not a single medical expert called by the defense or called by the Commonwealth has testified that John was hit by a car. Not one. Think about the irony. Not One. That's not just significant. It's literally the most important point in the entire trial. Listen again to Dr. Scorti-Bello's words. Question. You did not include in your autopsy in any fashion any discussion of whether Mr. O'Keefe's injuries were consistent with a motor vehicle accident, did you? Answer. No, I did not. She told you, quote, I did not see any evidence of an impact site, end quote. She was talking about John's body. The Commonwealth's own medical examiner, Dr. Scorti-Bello, performed the autopsy. She did it personally. She's the only one to have personally examined John's body, and she found no evidence of an impact site on his entire body. That in and of itself is reasonable doubt. You don't need anything more. The Commonwealth's case is done. It's cooked. Their own expert said there is no evidence of a collision, no evidence of an impact. If you want to know what an impact looks like, take a look at this. This is what a body looks like after being struck by a car at 25 miles an hour. And this is what a car looks like after hitting a person at 25 miles an hour. These are exhibits from Dr. Welcher, the Commonwealth's expert. John didn't even have a bruise. Make no mistake, Dr. Scorti-Bello was presented with the Commonwealth's theory of the case, the same case that you've been presented with, and she refused to conclude that John's death was a homicide. She flatly refused to conclude that there was a collision. And you know who agrees with that? That silent witness, the science, the physics, the data. Dr. Wolf and Dr. Rentschler, you just met them recently. They explained they were not initially hired by the defense. They were asked by another agency to conduct their analysis. They looked at the evidence from both sides, not taking a side for the defense or the Commonwealth, completely independent. They looked at the damage to the SUV on the one side of the coin. They looked at the injuries to John O'Keefe on the other side of the coin. Both PhDs, both engineers determined there was no collision. I'm not saying it. The science says it. That SUV's taillight was not damaged by striking an arm, and John was not struck by a 6,000-pound SUV. Period. Full stop. Dr. Dan Wolf did the testing on the taillight. Actual testing, not some ridiculous blue paint kindergarten project. He did lab testing. He did field testing. He did data testing. Actual impact force analyses. In every single test at every single speed, the taillight damage was inconsistent with striking an arm. In every test, the taillight damage was inconsistent with damaging the shirt, the sweatshirt. Remember that severe internal damage to Karen Reed's taillight. Not just the outer lens. The internal diffusers were completely smashed, completely shattered. ARCA testing established that all the internal components of every single test taillight, especially the diffusers, remained completely intact. Conversely, on Karen's taillight, the diffusers were almost completely gone. Folks, understand something. If any part of that diffuser portion of the taillight is broken, there is no light. It doesn't illuminate at all. It's just black. Let's take a look at a couple of photos. At 5:07 a.m. at One Meadows, that's the photograph on the left. What do you notice about the right taillight? It's completely illuminated. Later, at 4:12 in the afternoon, photograph on the right, it's lit up. How can that be? How can that be if the Commonwealth claims that those diffusers, the portion that lights up the light, were already scattered all over 34 Fairview? That's their theory. But don't believe your lying eyes. The taillight's completely lit up. That would be impossible. Dr. Andrew Rentschler, a PhD, a biomechanist, explained that at those speeds, the other side of that coin, John's arm would be basically destroyed. Contusions, swelling, torn ligaments, hyperextensions, dislocation of joints and bones, fractured, broken, and shattered. But as you know, John's arm was pristine, save those dog and claw bites. He didn't even have a bruise. Think about this. Think about that photo of those x-rays as you deliberate. You can manipulate a taillight fragment. That's not that hard. You can't manipulate a bruise. If they claim the car was going fast enough to shatter the taillight and shatter the diffusers, then it was also going fast enough to destroy and shatter John's arm, and it simply did not. How do they square that? They don't, and they can't. So they spent nearly $400,000 of taxpayer money to hire someone to dress up and look like John and paint his arm blue.
Yeah.
Which told you exactly nothing. The ARCA testing, conversely, also established that it is impossible for John's sweatshirt sleeve to be damaged by an impact with the taillight. The Commonwealth's theory is that the sleeve of John's hoodie sweatshirt was damaged by flying shards of taillight slicing through the shirt and through John's arm. I have 3 questions. Number 1, John's arm had about 36 abrasions. How did 36 shards of acrylic go through 9 tiny little puncture holes? How'd that happen? Somebody needs to answer that. Number 2, why are there no slices or cuts in the hoodie? All the defects are punctures. Punctures that you might get from, say, I don't know,
dog bite,
canine teeth. And number 3, if the shards cut bloody gouges into John's arm, that's their theory.
Where's the blood?
Why is there no blood, no skin, no tissue on a single shard of taillight that they claim came in contact with John's arm? The Commonwealth cannot answer a single one of those questions because John's arm was not impacted by the taillight. It doesn't make sense simply because it didn't happen. Compare and contrast the ARCA experts and their actual testing to Judd Welcher. He came to you in the Commonwealth's case in chief, and he told you that for the better part of $500,000, he'd come in and testify that John was tall enough to touch the taillight with his elbow. That's it. And even in that basic demonstration, he had to lean in to manipulate it to get the results that he wanted. Dr. Welcher then claimed that the reason he didn't do the reconstruction, the actual testing, think about what he said. There isn't enough evidence to determine what happened. I beg your pardon? What happens when there isn't enough evidence, in his words? You vote not guilty. That's what happens. That's out of his mouth, not mine. The Commonwealth also used the same company, Aperture, to try to establish a time of a collision that never occurred. The Commonwealth called Shannon Burgess, the supposed expert from Aperture. There is a cardinal sin for experts, folks, a cardinal sin. It's called confirmation bias. It's when you decide to change your opinion to fit a theory. The most important takeaway from Shannon Burgess' testimony was how brazen, how shameless he was in trying to change the data to try to suit the Commonwealth. Remember Mr. Brennan's opening statement. He made some promises to you. He said, this case is about the data. He stressed it over and over again. They've had 3.5 years to get this right. The Commonwealth has had this case for 3.5 years to get it right. So his top expert, Dr. Welcher, prepares a report. And that report says that John O'Keefe was struck by Karen Reed's SUV at 12:31:38. Note that time, 12:31:38. He was struck, he was immediately incapacitated, he was immediately unconscious. So says Judd Welcher and the Commonwealth's theory. But there was a huge, huge problem with that. And somewhere in the middle of trial, somebody must have realized it. They must have realized that the very data they produced unequivocally establishes that they are wrong about a collision. It could not have happened. Why? Because John was interacting with his phone after 12:31:38. Remember, the collision immediately incapacitating. How could he be interacting with his phone afterward? He was on his phone, opening his phone, checking his phone, reading texts on his phone, and locking his phone, all of it after 12/31/38, which is the time Welcher clocked for the moment of the impact. And he was taking steps and walking with that phone after 12/31/38 also. That's what their own data showed, and it devastated their case, and it devastated that false theory. There must have been panic, I'm guessing, in the room. What do we do now? The data shows John wasn't struck by the car. What do we do?
Enter Shannon Burgess.
Shannon Burgess. Question. Can you believe him? Can you believe Mr. Burgess? He came up with a brand new story right in the middle of trial. You might ask yourself, would an expert actually say something he knows not to be true? Would an expert actually say something he knows is not supported by fact? Would an expert shade the truth? You don't have to look any further than Shannon Burgess's CV to answer that question. That was a shame. Even with the pull and push and stretch and manipulation of the time data that Mr. Burgess came in here and told you about, it still shows that John O'Keefe was very much alive and walking around after they claim he was hit and incapacitated. Think about that. Matt DeSogra looked at Burgess's report and told you that in 30 out of 30 scenarios of the possible time skews that Shannon Burgess identified, he came in the middle of trial and identified all these other time skews that he called it. In every single scenario, John was alive and walking after they said he was hit. And that's a problem for them because there was no collision. Just look at Mr. Withen's data, Ian Withen. John O'Keefe took 31 steps at a steady rate, about 83 feet. And then think about this, in a westerly direction.
I got some good ones for when Hank's on.
Toward the house. Remember, it's 78 feet to that garage door. That's not a coincidence. The Commonwealth's witnesses, or the Commonwealth's witness, Mr. Ian Withen himself conceded that he has reasonable doubts about the accuracy of John's location data. Remember that question and answer on cross-examination by Mr. Alessi. Do you have doubts? I do. Are those doubts reasonable? They are. And remember, it's still the Commonwealth's burden. If their own cell phone expert has a reasonable doubt about John's location, so should you. John O'Keefe was inside, and the phone battery temperature further proves it. This is not speculation. This is science, and it's irrefutable. It tells us that he was not laying outside in the cold. He was inside somewhere a little bit warmer. Ian Withen told you that when the iPhone is exposed to freezing temperatures, think about these numbers. When the iPhone is exposed to freezing temperatures, it will drop from 81 to 21 degrees in 15 minutes. 15 minutes. That's a 60-degree drop in 15 minutes. Now look at John's phone. It was laying, according to the Commonwealth, it was laying directly on frozen ground. He arrived at 34 Fairview and his phone dropped only 20 degrees over the course of an hour. Then inexplicably, it stayed steady, never dropping below 50 degrees for the next 4.5 hours, never dropping below 50 degrees for the next 4.5 hours, basically through the entire night. He was not outside. He was someplace warmer, like a basement or a garage. Dr. LaPosada confirmed that John O'Keefe did not have hypothermia. No telltale signs, no telltale Wisniewski spots, no frostbite on any extremity. He did not die of hypothermia because he wasn't outside. Dr. Isaac Wolf, Dan Wolf, Elizabeth LaPosada, Judson Welcher, Andrew Rinchler, all agreed. Every expert agreed. This is how John O'Keefe died. A rearward fall from a standing position. What could make you fall straight back like that? Let's just think about that for a second. What could make you fall from a standing position as Judd Welcher just showed us? Standing up,
7
falling straight
tequilas?
back. Add a laceration to the right eye consistent with a fist or a punch, and you've got your answer. He certainly didn't sustain that wound on the back of his head by falling backwards onto a lawn. Dr. La Posada told you that the patterned injury on the back of John's head could only be produced by hitting a hard, ridged, or ledged surface, like a concrete stair or step. What's just through that garage door? Michael Proctor never stepped down in that garage to find out. What a shame. And look at the arm. Just look at John's arm. You don't need the top experts in the country, but you had them. You don't need the top medical minds on the planet on this issue, but you had them. These are dog bites and scratches. These are animal wounds. Not one witness has been called in their trial. Not one. 8 weeks and counting. Not one witness who actually disputes that John O'Keefe's arm injuries are from a dog. The Commonwealth could not find a single medical expert, a single medical witness who would come in here and tell you those are inconsistent with a dog bite or a scratch. And it's equally clear that there was no collision. Dr. La Posada told you in probably the clearest voice in the entire trial. You remember her testimony. He didn't get hit by a car, her words. He just didn't get hit by a car. You remember the question that was posed by Mr. Brennan. Did you consider the speed of the vehicle? She said, speed didn't matter because he didn't get hit by a car. She repeated it 3 times because it's true, not just because she says so, but because the medical evidence proves it. The medical science proves it. There was no collision. Dr. Rinchler told you unequivocally and just as firmly he didn't get hit by a car. The Commonwealth has not met their burden. They cannot meet their burden. The Commonwealth hasn't called a single medical professional, not one, to testify that John's wounds came from being hit by a car. Not Dr. Scortibello, not Dr. Isaac Wolf. Contrast that with the caliber and the quality of the experts who came in here to tell you what is obvious to anyone with common sense. Those wounds on his right arm are from a dog. This was not an oversight by the Commonwealth. It's just that there is no one out there. No matter how big a check you write, there's not a medical expert who's going to disagree with that. The fact is, this is the central fact in the case. The only fact that matters is literally uncontested by every medical expert. Uncontested, undisputed. There is no evidence that John was hit by a car. None. How much more reasonable doubt could there be? This case should be over right now. Done. Because there was no collision. So given all that, how did Karen Reed end up sitting here? Why is she even here? Why is she in that chair? Why is she in this courtroom? There is a reason for that. And it's a reason they don't want to tell you, and it's a reality they don't want to admit to. The reason we're here is because the system, the very system that was meant to protect her, that was meant to protect all of us, that system has failed badly. So now let's discuss the facts that were and were not presented by the Commonwealth in this case. Over the next few minutes, I want to talk about the utter failure of the police to investigate this properly and to investigate this fully. And what you're going to see is that Michael Proctor, the lead investigator for the Commonwealth, did nothing to actually and properly investigate this case. Let's start with the house. That's the most logical place to start. I think you'd agree. Brian Albert's house, where John's body was discovered lifeless in the lawn. A man, a police officer, is found dead on the front lawn, and no one secures the scene. No tape, no preservation of evidence, no crime scene log, no search warrants, no consent searches, no photographs of the house interior. They didn't treat the house as a crime scene, and shamefully, they didn't even treat the yard as a crime scene. The lame excuse offered by retired Lieutenant Gallagher: it was really cold and windy. that I didn't know if there was a crime that had been committed. What? You didn't know that a crime had potentially been committed? You have a man laying dead in the yard, and here are the undisputed facts that those officers were confronted with. Black eyes. Obviously, black eyes are consistent with a fight. Bloody nose, also consistent with a fight. Bleeding from the face, consistent with a physical altercation. A cut over the right eye, consistent with a punch. No coat in the freezing cold, not dressed for outside, dressed for inside, and one shoe on. I wonder where the other shoe could be. I don't know, maybe in the house 30 feet away. And then you find a broken and shattered drinking glass next to him, the type of glass that you might find, I don't know, let me think about this, in a kitchen, in a house 30 feet away. And John's phone was tucked neatly under his back shoulder. Lieutenant Gallagher actually claimed he did not know it was a potential crime that needed investigating.
What?
The neighbor across the street, Detective Lieutenant Kelleher, had a ring camera that was pointed at the exact direction where John O'Keefe would have been hit, and nobody bothered to secure it. Nobody bothered to secure it. Nobody even bothered to look at it. Of course, this was a potential crime scene. Of course it was. Let's not forget, this was Brian Albert's house, and that comes with privileges. Quote, is the homeowner going to catch any shit?
Nope.
Nope. He's a Boston cop too, end quote. That quote starts to make a little more sense now, doesn't it? Michael Proctor wrote those words just hours after John's body was found. He sent this in a private chat, in a private text he never, ever believed would ever be revealed. He sent that text in a series of messages that now belong to you. You weren't given the opportunity to hear from Michael Proctor, but you can read his thoughts for yourself. And I urge you, go read them.
209.
209, 209, in case you wonder. But here are the highlights. Proctor starts the conversation, quote, all the powers that be want answers ASAP. He's getting pressure, obviously. Get this done. His friend then asks what Proctor's probably thinking at the time. Quote, I assume you guys are out to make it cut and dry since it involves cops. Something stinks. And Proctor responds, yeah, to the something stinks. And then he goes on, but there will be some serious charges brought on the girl. Think about that. Hours into this investigation, there will be some serious charges brought on the girl. She's a whack job cunt. Yeah. She's a pig. Weird Fall River accent, though.
No ass.
No ass bitch. She's got a leaky balloon knot. Leaks poo. Zero chance she skates. She's fucked. And up to this point, Michael Proctor had done zero investigation.
Yep.
Nothing. Save talk to a grand total of 3 people, all of whom were named Albert or McCabe. That's it. And this was his mindset. This is the same lead investigator who sent the group chats that you heard about with Sergeant Butnick. Late night, sitting at his office, rifling through Karen's phone, bragging about looking for naked pictures of her. That text wasn't sent to his buddies or his friends. That text was sent to his supervisors at the Massachusetts State Police, for God's sake. And what was their response? Sergeant Buchanan liked this conduct with a big old thumbs up. He encouraged it. Ladies and gentlemen, a lead investigator is every investigator is supposed to be objective, an objective fact finder, no bias, no agenda. Michael Proctor went far beyond just insulting Karen Reed. He dehumanized this woman. He betrayed her as a human being.
Oh, absolutely.
He was fired for this blatant bias. If the Massachusetts State Police can't trust him, how can you trust him with this investigation and with your verdict? And with Karen Reed's life. The lead investigator in a murder trial was never called to testify. Think about that. That should stop you in your tracks. Wouldn't you want to hear from Michael Proctor? Wouldn't you want to hear from the lead investigator in the case? Don't you have questions? The Commonwealth did not present their own lead investigator to the jury, the very jury who is charged with judging the investigation. Michael Proctor clearly is radioactive, and the Commonwealth stayed away from him. Michael Proctor is no longer a Massachusetts State Police officer. He wasn't transferred. He didn't go on sabbatical. He didn't retire. He didn't resign. He was fired. He was terminated for cause. The Massachusetts State Police investigated him, found him guilty of dishonorable conduct, not just for those text messages, folks, for sharing confidential information with witnesses and for bias. Not just any bias, bias in this case. Fired. This is the man who touched every single piece of important evidence in this case. All the evidence that was brought before you in this trial went through his hands one way or another. The shirts, the shards. Remember that when Mr. Brennan gets up and gives his closing argument. The shirts, the shards, all in Michael Proctor's possession. Mr. Brennan and the Commonwealth, I think, have pinned their hopes on some microscopic pieces of, or close to microscopic pieces of plastic that were claimed to have been scraped from the hoodie several months after the fact. What he failed to ask every single every single witness is who had access to that shirt and who had access to those taillight fragments. And the answer is it was Michael Proctor. Not for days, not for weeks, for months on end, for months unaccounted for, before they were submitted to the crime lab, before they were ever scraped. Just go look at the chain of custody documents. You've got them. Why didn't Michael Proctor give those clothes to Maureen Hartnett with the crime lab when she was at Canton PD just days after the fact to receive those solo cups? Remember that? Just a few days later, she was there. She drove up. She did the driving to take the solo cups in the grocery bag, which has a ridiculous aspect to it in and of itself as well. Why not just give her the shirts as well? Give her the taillight fragments if any were found at that point. Why hold on to them? What could possibly be a reason? Why wait until March to book those into evidence? Now let's talk about some of the other problems with the Commonwealth's evidence. As I indicated, there was no blood, no skin, no tissue, no DNA found on a single piece or shard of the taillight that the Commonwealth claims cut and sliced into John O'Keefe's arm. Where is that trace evidence? Where is that biological evidence? The DNA. Where is it? They've got nothing. Not a single piece that the Commonwealth wants you to believe cut up John's arm. How is that possible? It's not possible. The only way it's possible is if those shards never touched his arm. Because it was a dog. Oh, and the one sample of DNA that they did find, by the way, was found on the outer smooth part of the housing. Not any shard. It was the outer smooth part of the housing. Nothing that they claim actually came in contact with John O'Keefe. Number two, that sample had DNA of two other men, two other unidentified males. That tells you that that DNA had nothing to do with a car strike. That DNA would be expected to be, John's DNA would be expected to be all over that car. Inside, outside, he had access to that car for months and months and months. He was in and out of it all the time. Show me some blood, then we'll talk. They can't, and they won't because it doesn't exist. That SUV never hit John. The hair found on the bumper. The Commonwealth really stretched its own credibility on this one. That magic little hair on the SUV supposedly survived a 37-mile drive in 47-mile-an-hour winds.
Sure as shit
That
is.
little magic hair just clung there, just hung on. That same hair that moved in between photos in the Sally Port. Remember that? There were two photos taken, and it was either the breath of the photographer or just the movement of walking by the hair. It literally moved between the two photographs. But that hair is supposed to have hung on in a 37-mile drive in a blizzard. The only thing that hair proves that the Commonwealth is embarrassingly grasping at straws. That hair has nothing to do with anything. But it doesn't stop there. There was another revelation at trial, a big one, a huge one, and it came from a very unlikely source. Christina Hanley, quiet, reserved criminalist who told you something the Commonwealth likely did not want revealed because it's devastating to their case. Absolutely devastating. And it's this. The glass on the bumper didn't match the cocktail glass. None of it. Remember, February 11th, Michael Proctor, without any other person with him, no witness, no supervisor, no other person with him, claims to have found a single piece of glass at the scene. February 11th, single piece of glass, Michael Proctor. Keep that in mind. Interestingly, the glass on the bumper that didn't match the cocktail glass, one piece did match one other thing. The Proctor glass. Those two go together. The only two things that go together from that bumper are the Proctor glass. We know that there's no glass in the taillight. We know that nothing else was shattered on the vehicle. Therefore, that glass had to be placed there. Didn't come from a crash, didn't come from a cocktail glass. So how did it get sprinkled on the back of the bumper? Whose proverbial fingerprints are on that glass on the bumper? The only thing it matched was Michael Proctor. What about the Ford Edge and that snowplow driver, Brian Loughran? He observed that Ford Edge parked outside Brian Albert's house at 3:30 a.m. That vehicle was moved directly in front of where John's body was found sometime between 2:30 and 3:30 in the morning. The only person connected to a car of that make and model, Brian Albert. Michael Proctor did nothing to investigate that point. Did nothing to investigate whose Ford Edge was parked in a spot specifically to block the line of sight in the exact position where John's body would be later found by Karen Reed. No one, not Michael Proctor or anybody else, checked it for evidence. No one even asked any questions about it. That Ford Edge, Brian Albert's Ford Edge, completely ignored. Michael Proctor failed to interview obvious witnesses in this case. Why? Why didn't he want to speak to the snowplow driver, Brian Loughran? Why did he falsely claim that no one plowed the roadway that morning? When police dash cam video, you saw the dash cam, it shows plows going back and forth all morning. Why did he wait so long, years even, to interview Heather Maxson and Ryan Nagel, individuals who were literally outside 34 Fairview at the exact same time John and Karen arrived at Brian Albert's house that night? Brian Loughran, had he been investigated or interviewed, would have told Michael Proctor that he drove past the lawn multiple times on January 29th, and there was no body on the lawn. He would have had a perfect view. Remember, the weatherman told you there was only enough snow at that time. I think he said, in a very charming phrase, only enough snow to track a cat. I think that was it. There was no body there. Heather Maxson and Ryan Nagel would have told him that they arrived at 34 Fairview shortly after Karen and John pulled up behind them, and they would have told Michael Proctor, at least Heather would have told Michael Proctor, that when she left 10 minutes later, she drove past the SUV and observed Karen Reed in the driver's side, dome light on, passenger seat empty. So where was John? Wasn't outside, wasn't sitting down, wasn't laying down. There's only one place he could be. We could all say it together if you could talk with me. He was in the house. But Michael Proctor did not want to have those answers. He did not want to have to disclose those answers. He didn't want the truth. The Commonwealth has presented a shred of evidence of when Karen Reed consumed her last drink that night. Think about that. It's critical information that the Commonwealth has to prove beyond a reasonable doubt and to a moral certainty. They have to prove when her last drink was that night. They have to prove it. We don't have to prove or disprove anything. Every single witness who was asked and who had an opportunity to observe Karen that night said the same thing. She wasn't drunk. She wasn't stumbling. She wasn't slurring her words. She was, in the words of Ms. Kolakithis, completely normal. Even Jennifer McCabe grudgingly had to admit that fact. It's on video. Instead, they used Yuri Buchanan to try to come into court and count sips of alcohol, which he admittedly got wrong. According to Ian Whiffen, the Commonwealth's own expert, the location data, using location data on John's phone, showed Karen driving lawfully. She was driving safely. She was under the speed limit. She was slowing and stopping at stop signs, slowing around corners. And Ryan Nagel corroborated that when he saw her make that left-hand turn onto Fairview. The Commonwealth has an incredibly high burden to prove that Karen was driving under the influence. They have failed to prove that beyond a reasonable doubt and to a moral certainty, because it depends on when she had her last drink. What happened after she got home and she was upset with John for not coming back out of the house? That would answer that question. As you well know, no one searched the house for signs of a struggle. Not that night, not the next day. I'm talking about 34 Fairview. Not ever, not once. Not with a warrant, not with consent. They never went into the basement, the stairwells. They didn't look at the walls. They didn't look in the garage. Nothing was ever examined. Nothing was checked for blood. Nothing was checked for DNA. They didn't look for a ledged or ridged surface. Zero. You'll remember how surprised Jennifer McCabe was to recall that there was a garage door even on the house. Except this was her sister's house. She's been going to that house since she was 5. She's seen that house. She's been in and out of that house hundreds of times, maybe thousands of times. She's been going to that house her entire life, and yet she acted surprised when I asked her about it. Remember Jennifer McCabe's answer when I asked her whether there was a door at the garage. I was asking her about the front door, the side door, and the garage door, and her answer was, oh, actually there is a garage door right there.
Oh,
Investigators never opened that door.
don't you know it's magic?
Let's change the scenario. What if it wasn't the house of a Boston cop? What if it wasn't the house of Brian Albert? We can be certain that investigators would have torn that house apart to get answers about why a fellow police officer was laying dead on the homeowner's lawn. You can betcha. But because this was Brian Albert's house, a Boston cop, nope. And because he was a fellow cop, an insider, they didn't even open the door. That is not justice, folks. That's just pure favoritism. Each of these facts is more than a question mark. They're failures of duty. They're blank spots on a map where justice is supposed to live. And every single one is a reason why you cannot convict Karen Read. Reasonable doubt abounds. If the Commonwealth failed to investigate every reasonable alternative, how dare they come in here and ask you for a verdict? They didn't investigate the case fully, and yet they're asking you to take the easy road and do their job for them. These facts do not represent reasonable doubt. Nothing does. Every one of these facts that you're seeing that we're talking about represents reasonable doubt. Every one. The police and the prosecution are in a position to take people's liberty. It's the most dire and consequential act a civilized government can take against one of its citizens. Their obligation is not just to try to get it right. They have to convince you to the highest degree of certainty known in human affairs. They have to do it all, every bit of it, beyond any and all reasonable doubt. And they have not done that here. And how about the homeowner himself? The host, the first responder, the Boston cop, Brian Albert, who was sparring and practice fighting with Brian Higgins just minutes before John O'Keefe appeared at his house, 34 Fairview. Brian Albert, who was watching Chloe that night, the German Shepherd. Brian Albert, whose phone and his wife's phone were never secured. Brian Albert, who never came out of the house. But that doesn't mean he wasn't awake. It doesn't mean that he wasn't on his phone. Think about this. Jennifer McCabe claimed that her sister and Brian Albert both slept through this complete chaos right outside their bedroom window. But Jennifer McCabe's phone records tell a different story, and they tell the truth. She spoke with them for the better part of a minute, 38 seconds to be detailed about it, at 5:07 a.m. And then she lied about that call. Remember that? What was the reason for that call at 5:07? Was it panic? Was it a warning? We know that conversation took place at the precise time Karen left her house to go search for John, 5:07. We could answer those questions if we just had access to their phones. Brian Albert, Brian Higgins, Michael Proctor wasn't interested in their phones. Not only did he not secure their phones, he never even asked. And what about Brian Albert's dog, Chloe? A dog with a history, a dog that is, quote, not good with strangers. Dr. Russell confirmed that John's patterned injuries were from a dog, just like the dog Brian Albert owned. And then Chloe just disappeared. Not there the next morning. None of the officers that you heard from said that there was a dog in the house. They didn't see her. She was just gone. And then ultimately gotten rid of altogether. Who gets rid of their family pet? Unless they had something to hide. Michael Proctor wasn't interested in that either. And recall the group chat with the Alberts and the McCabe's. They were getting their story straight. Matt McCabe, whom the Commonwealth did not call in this trial, instructed the group in that group chat, you'll recall, tell him to say the guy never came in the house. Think about that exact quote. Tell him to say the guy never came in the house. And Brian Albert, the patriarch of the family, exactly, exclamation point. He blessed it. With the truth, as we all know, you don't need to get your story straight. You don't need to tell someone what to say. It's just the truth. And what about the Google search? A Google search that Jennifer McCabe admitted having made. A Google search that was time-stamped by Celebrite at 2:27 a.m. A Google search that read, Haas Long to die in cold. It is uncontested and undisputed that that search was deleted. If the 2:27 a.m. timestamp is not true, why does Jennifer McCabe have to lie about it? Why delete it? If the 2:27 a.m. timestamp is not true, why create a false story about Karen screaming Google hypothermia? That's just a fabrication. That's just a made-up fact. And by the way, if someone does tell you Google hypothermia, why would you Google how long it takes to die in cold? Wouldn't you just Google hypothermia? Jennifer McCabe enlisted Carrie Roberts to help shift the blame to Karen. Why go to that much effort unless you're trying to cover for something? Keep in mind the entire foundation of her claim that Karen said Google hypothermia is this fantasy about Karen screaming it at the location, at the scene. That's her entire excuse. But that story went completely off the rails when Carrie Roberts admitted that she perjured herself to back up Jennifer McCabe's false story. That was a dramatic moment in court. It's an admission of perjury, and you don't see that very often in a courtroom. That tells you everything you need to know about the character and quality of the prosecution's case and their witnesses, lying and perjury and admitting to it. A fundamental tenet of any investigation is to ensure that witnesses are independent and not influenced by other witnesses. You start by separating the witnesses. Michael Proctor did none of that in this case, and we see the results. Think back to Jennifer McCabe's own text messages with Carrie Roberts. About Carrie Roberts, not with Carrie Roberts, notably. What Carrie Roberts didn't know was at the time she was being interviewed by the police, Jennifer McCabe was in real time. She was bragging about having influenced Carrie's testimony or her statements to the Alberts and the McCabes. Quote, she's telling them everything, all the stuff. Remember that timeline that we talked about with Jennifer McCabe? That's what she was referring to. She's telling him everything that Jennifer McCabe had put in Carrie Roberts' timeline. The Commonwealth wants you to believe that Karen Reed made a statement at the location, at the scene. I hit him. I'm sure you'll hear that from the prosecution in their final arguments. But their own witnesses contradict that. Jennifer McCabe admitted on cross-examination that her very first statement to law enforcement, confirmed that Karen didn't say anything. She asked, could I have hit him? Did I hit him? Is he dead? The physics and the science answer that question. Could you have hit him?
Yeah.
No, you couldn't have. Sergeant Buchanan also testified that the only statements Kieran Reed made at the scene, according to his conversations with the first responders, was, could I have hit him? Did I hit him? It wasn't a confession. It was confusion. And Dr. Russell explained that confusion. She told you why Karen Reed or anybody in that position might ask those questions. She was suffering from extreme grief reaction, which according to the evidence can last for years. Even her medical records confirm that diagnosis. It's common to ask those questions in grief. It's common to ask those types of questions in shock. You're trying to make sense out of the nonsensical in the moment. And the Commonwealth has tried to twist those words into a confession. There is no evidence that any officer at the scene ever heard Karen Reed say, I hit him. Not a single police officer at the scene came in to support the Commonwealth's claim. It's not on video. It's not on audio. It's not in a single police report. It's not in a single EMT or EMS report. Nowhere. The fact is, Karen never said, I hit him. You saw the video. Multiple officers were right there. She simply never said it. What did Jennifer McCabe do and not do when she got to 34 Fairview? She would have you believe, I want to set the scene for you, that she's confronted out of the blue with John O'Keefe's lifeless body. Her friend, John O'Keefe. He's bruised and battered. He's bleeding. His eyelid is cut. His nose is bleeding. Karen is screaming at the top of her lungs. Carrie is screaming back to Karen, shut up. Both women begin crying. Both women are giving CPR. There's chaos everywhere. It's building in the yard, just feet from Brian Albert's house, Brian Albert's window. Jennifer calls her sister at 6:07 with all this chaos going on. No answer. Jennifer calls her sister at 6:08 with all this chaos and bedlam going on. Still no answer. No lights come on in the house. In the midst of all this screaming and this chaos, Brian Albert doesn't come outside. Nicole Albert doesn't come outside during this maelstrom. And yet, Jennifer McCabe never goes inside to check on her sister. There's literally no signs of life inside the house. And Jennifer McCabe doesn't take a step inside that house to check on her family. Why is that? Does that make any sense? Everyone would sprint inside the house to make sure that there's no one in there that was hurt or injured or, God forbid, dead. Everyone would do that. But not Jennifer McCabe. The only way that makes sense is if Jennifer McCabe already knew that Brian and Nicole were just fine. That's the only reasonable explanation. And the only way she would know that they were fine is if she knew what happened. But Michael Proctor never explored this incredibly suspicious behavior. Don't you have questions? This would give anyone reasonable doubt. And don't you have questions also about Brian Higgins? Michael Proctor certainly didn't. Higgins had been sending flirtatious and romantic texts to John's girlfriend, Karen Reed. You'll remember I asked Sergeant Buchanan a simple question. Were those texts flirtatious in nature? He refused to answer that simple question. Do you remember that? Quote, I'm not comfortable putting a label on that, end quote. We read the texts. It's not a secret. Of course they were flirtatious. Of course they were romantic in nature. The reason he refused to answer that simple question is telling. It's because these flirtatious texts established a motive for Brian Higgins. Sergeant Buchanan could not bring himself to tell the truth. His bias was on full display. He was covering for another cop. Investigators also ignored Higgins' suspicious late-night visit to the Canton Police Department. That was after a night of drinking, by the way. Why didn't they investigate this? What was so important that Higgins needed to go to the police station at that time, 1:30 in the morning, while drunk, by the way? Why weren't they interested in those facts? Remember, he's an ATF agent. He's a cop, a member of the Blue Wall, and best friends with Brian Albert. He would know that the CPD would be the first to get the call when someone reported John missing or injured. He would know what to look for, what to listen for, to determine if a report had been made and when and what the response was going to be. You saw the skulking through the hallways with his hood up, moving bags between cars, and of course, that late night mysterious phone call on his cell phone, a phone that you don't have and that you'll never see. All of that, and Michael Proctor never gave him a second look. All of that, and the Commonwealth, who's supposed to be after the truth, didn't call him to the stand. If you have any unanswered questions about Brian Higgins, that's reasonable doubt. The police didn't interview Brian Higgins on January 29th, 2022, but he was at the police station, as we've just seen. You heard evidence that Higgins and Chief of Police Kenny Berkowitz, also good friends, were in the Sallyport together with the SUV for a, quote, wildly long time. Kelly Dever, another Boston cop, told you that. She also told law enforcement agents that she found it, quote, weird that Higgins could have access to that very sensitive evidence, the SUV. Folks, there is never a situation in which a witness, a potential suspect even, should be given access to the evidence in a case. But that's exactly what happened here. Higgins was given unfettered access to that SUV and its taillight nearly immediately, according to Kelly Dever's statement to law enforcement. And it was at that exact time, the exact moment that Higgins would be in that Sallyport, that the 42 minutes of the Sallyport video is just missing. It's just gone, vanished. Well, that's convenient. Now put in context the condition of that taillight when it was actually seized in Dighton. It was cracked, but not completely damaged. I ask you to compare and contrast Officer Kelly Dever, her attitude, her demeanor. That's all for you to judge. Her attitude, her demeanor, her truthfulness, her motives from the witness stand. Compare and contrast that to Sergeant Nick Barrows. Who's more believable? Officer Barrows is unattached to any of the players in this grand play directed by Michael Proctor. He's truly independent. And what did he tell you? Was the taillight, he was asked, was the taillight in this condition when Michael Proctor picked up that SUV at 412? His answer? Absolutely not. Absolutely not. It was cracked, but not completely damaged, not smashed out like that. So how did the taillight get cracked? How did it end up in the condition where it was cracked, as Officer Barrows saw it, but not completely damaged? Well, you don't have to guess. There's a video. Just watch. That's how it got cracked. And Judson Welcher's own recreation confirms it. Look at the contact. That's from the Commonwealth's expert. And that further is confirmed by the fact that there were no taillight pieces found in any of the initial searches conducted at the scene. 2 searches, 50-foot area searched. Not a single fragment was found until after Michael Proctor had access to and control of that SUV and its taillight. What does that say about the character and quality of this case? It's revealing what happened here at trial. One of the most dramatic moments probably of the trial, Kelly Dever. How can you trust this investigation when you saw how far a police officer will go? You had a front row seat to the power of police manipulation and police corruption, a front row seat. Kelly Dever was interviewed by a separate law enforcement agency, not a friendly department, not Boston Police Department, not Michael Proctor's MSP, a different independent agency. She told those law enforcement agents in a formal interview that she saw Brian Higgins and Chief Kenneth Berkowitz alone in the Sally Port with the SUV. She was detailed, she was clear, she was unequivocal, she remembered the specifics, she recalled how it made her feel, quote, weird. She recalled that how long Higgins spent, a quote, wildly long time, as she described. These are all incredible details to tell law enforcement. She couldn't have been clearer. She couldn't have been more specific. But then she's put on a witness list and she's subpoenaed by the defense. Oh boy. Then this rookie cop was called up to the police commissioner's office, the same commissioner that was the boss of Brian Albert. They have a meeting, a private meeting, and he says, wink, wink, nod, nod, we support you, Officer Dever. What else was said in that meeting? What else is reasonable to believe was said in that meeting? She claimed she couldn't remember. She claimed not to remember if he instructed her to do the right thing. But the commissioner of the Boston Police Department certainly said something to this rookie cop. And all of a sudden, that detailed, unambiguous, unequivocal statement to law enforcement became, what did she say? A false memory. Not, I didn't say it. She admitted she said it. She admitted she detailed the entire story. She just said, it's a false memory. What? So she's called to the commissioner's office to make sure that she would do the right thing. That's why she was called. And now we know what that means. In her words, my entire career depends on what I say here on the stand. I'll quote that again. Quote, my entire career depends on what I say here on the stand. You bet it does. That's how it works. And that's how we got here. At the end of the day, you have to ask yourself, can you trust the Commonwealth's case? Can you trust their witnesses? Can you trust their evidence? And here are a few of the highlights. A video that was played in a courtroom and sold as accurate. Turns out it was completely inverted, flipped backward, completely false. The test that formed the basis of their entire theory of the case. Watch closely as Dr. Welcher stands as a surrogate. Is that a righteous test, or is that a manipulation? Dr. Welcher tried to deceive and fool you by leaning into the car, manipulating the results of his own test. When the truth was revealed by Dr. Rentschler, the Commonwealth spent the next hour cross-examining him about how that test was meaningless. It actually didn't mean anything. Well, that's convenient now that we realize that it was a manipulated test, and it actually does mean nothing. It didn't represent the theory of the Commonwealth's case. That's what was suggested. That test does not represent the theory of the Commonwealth's case. Really? Then why was Dr. Welcher playing dress up in John O'Keefe's clothes, or identical clothes to John O'Keefe, when he was holding a glass? Why was he holding the glass right behind the vehicle? And why was he standing with his right arm oriented to the right rear taillight if he wasn't trying to recreate the circumstance that is the Commonwealth's entire theory? The Commonwealth stood up here with a straight face and told you they weren't trying to suggest that that's how John was hit by the car. Of course they were trying to suggest that's their theory of the case. They only abandoned it 2 days ago when it was revealed by our experts that it's physically impossible. That silent witness, that science, that physics has become very pesky to the Commonwealth because there was no collision. Dr. Welcher also told you under oath that there were no x-rays taken of John's arm. He tried to deceive you into believing that John's arm might have been broken. I don't know. I didn't see any x-rays, so I can't tell you what the damage was inside the arm. Really? The Commonwealth has had those x-rays in their possession for 3 years. And again, it took the defense to bring out the truth. The x-rays do not fit the Commonwealth's theory, so you weren't shown. And Dr. Welcher wasn't going to admit it. And my goodness, then we get to the sweatshirt. That was a moment. Mr. Brennan, stood here in front of you and dramatically held up John's sweatshirt, not just to the witness, but to you, and asked Dr. Wolf about it multiple times. Specifically, while it was in that plexiglass, asked Dr. Wolf about the multiple holes in the back of the sweatshirt. He interrupted Dr. Wolf, and Dr. Wolf started to look at the sweatshirt and say, well, and he said, how about here? Here's a hole, here's a hole, here's a hole, here's a hole, dramatically tapping on that plexiglass. It was clear what the suggestion was, that the holes in the back of John's sweatshirt were from January 29th. That's the impression that was expected to be left with you. That's the impression that he wanted to leave with you. And that's false. The truth is, the Commonwealth created those holes. They aren't holes from road rash. They weren't made on January 29th. Those are cuttings from the Commonwealth's own crime lab, folks. That's what those holes are. And even with 3 prosecutors, all 3 of them, sitting right there in the room at the time, it had to be the defense to correct that record, to bring out the truth. If we hadn't done that, what impression would you folks have been left with? That's more than negligence. That's dangerous. It's dangerous. I'm going to guess that Mr. Brennan's not going to say much about this, about the fraud that was attempted on you. And if he doesn't, that speaks louder than any concocted excuse that the Commonwealth might come up with. It's shameful. It's shameful. We are after the truth in this courtroom. You're entitled to it. Demand it. Why would the Commonwealth stoop to a stunt like that? It's desperation. They know what you now know, what their experts know. There was no collision. So now we've reached the final moments of the trial, and you've seen the facts and you've seen the evidence, and we've just talked about dozens and dozens and dozens of facts that are reasonable doubt. Each one of them are reasonable doubts. These facts, these note cards that you're looking at, piled high, one on top of another, literally stacks and stacks of them covering the table. As you mentally sift through those cards, realize that every one of them is a massive hole in the Commonwealth's case. Every single one of the note cards represents a hole in the Commonwealth's case. If you're holding mentally even one of those cards, you're holding reasonable doubt, folks. You're holding a not guilty verdict. Reasonable doubt is not a sliding scale. It's a wall. If the Commonwealth cannot get over every one of these dozens of walls, you have to acquit Karen Reed. The truth is, Karen Reed is not guilty. Not because of technicalities, but because the facts, the law, the science, the physics, the data, they all say so. They demand it. The Commonwealth does not have a theory about how John was hit by the car. They haven't even shown you that it's possible that he was hit by a car. And the reason they haven't is because it's not possible that he was hit by a car. There was no collision. Your job is not to do their job, their burden entirely. It's theirs. They have to prove this case and their theory beyond all reasonable doubt and to a moral certainty. And not only do they not have a theory, they can't prove one that doesn't exist. All you need to know is that the Commonwealth failed. They failed to provide you with a truthful representation. They failed to prove the essence of their case, that John was even hit by a car to begin with. They failed to prove any intent on the part of Karen Reed because she has none. They failed to investigate the actual suspects in this case. They failed to present the lead investigator to you. They failed to justify the perjured testimony that you heard discussed in this case. They failed to hold accountable an officer who came in here and lied to you and claimed false memories so she could do the right thing to cover for a fellow cop or cops. They failed to maintain a fair and unbiased and honest investigation. They failed to present you with the truth. And this is what you get. An investigation that's riddled with errors and omissions and a rush to judgment and conflicted and corrupted from the start. Every part of it. That is the literal definition of reasonable doubt. How can they ask you to be morally certain based on this evidence? It's a tragedy. When the government fails so completely, so catastrophically, when there are dozens and dozens of points of reasonable doubt on the table, your duty, your oath is clear. Your sworn obligation under the law is to acquit Karen Read, not just because you can, because you must. Justice demands it. Do not let the Commonwealth get away with this. Don't let them get away with this. Do not endorse and sanction an investigation that is broken and corrupted top to bottom. But just as importantly, do not let Michael Proctor get away with it. And make no mistake about it, folks. If you convict Karen Read of anything, if you convict her of anything, science, the physics, the data, they lose. But tragically, Michael Proctor wins. Remember his texts. Something stinks. Yeah, but serious charges will be brought on the girl. She's fucked. Could you ever say to yourself, this is justice? The fact is there was no collision. A car did not kill John O'Keefe. So I ask you, let your voice be heard, not in whispers, but in truth. Let the community feel through your verdict that justice cannot be bent and that it will not be buried. Find Karen Read not guilty, not guilty, not guilty. Thank you.
Well, the first full day of jury deliberation.
Well, we're going to come on with Michael Bryant in a second. We thought we'd spare you doing Hank Brennan right now. We just wanted to take a gander back at where we got to, how we got to here. That's Alan Jackson. Remember, I loved his threes. First, it's there's no collision, there's no collision, there's no collision. And then he ends it with the same triplicate, the thematic, not guilty, not guilty, not guilty, which is why, interestingly enough, when we had our first exclusive interview this morning with Michael Easter, the police procedures expert, you know that the court did not allow, and I'll repeat that, did not allow, and I'll repeat it again, did not allow to be heard before the jury. You can see maybe why, because he would have been further devastation to the prosecution case. And quite frankly, I think it's error. I think it may be actually reversible error if there is a verdict without hearing what the police procedure should be. Okay, so what we have going on, I just want to let you know, Michael Bryant had to relocate to do his interviews. We have created such a big First Amendment zone by being one of the first people who sued the Commonwealth, right, for the violation of First Amendment rights, how to do the right thing. And we were small little network coming out. None of the big guys would come out. We did, along with Tommy CPU, and then some of the protesters who were standing with signs, including Jason Grant, good guy. We've had him on our show. Love to get him back when there's a verdict to get his reaction. We actually took the step of hiring an attorney. Michael Bryant actually did, and we actually sued the Commonwealth. Michael Bryant was the lead plaintiff in that case with Tommy CPU. All the cases went before the federal court, told Judge Beverly Cannoni to redo her order. She did, and actually enforcement got worse. So then Mark Randazzo and the Liberty Center kept the case, went back to the judge in the federal court. He said, look, you can't do it this way. And so what happened? We still had the hush zone, or we still had a little bit of a buffer zone. but everyone could stand in as long as they weren't like having signs that said, free Karen Reed. They could say Norfolk County is controlled by criminals. That's within the First Amendment right. That was Erica's case, right? So now there are so many people there today that Michael Bryant got to walk a little bit. Actually, he was the interviewee because of what he did by Vinnie Politan, Court TV. We had that interview. We're going to try to play it since Michael gets on. But he's out in some parking lot set up way away that supposedly you can't park in, but there's cars that are already parked. Everyone's parking because there's no way to get to that courthouse. That the First Amendment zone, as we have renamed it, has grown and people have come. And those are the same people that would have come all the way throughout the trial had there not been this illegal, improper, and violative of the First Amendment, both buffer zone enforcement. Okay, buffer zone enforcement. All right. The signs can have the Bible verses on them. Okay, the sign like Jason Grant did. He can have a Bible verse, right? But oh my goodness gracious! So we did that, and here we are. So, but we're so proud of Michael Bryant. We're so proud of the fact that the First Amendment zone has replaced the buffer zone, right? And but we're not so happy that we're going to be in Timbuktu when we're going to be doing this show. So we will actually let Michael Bryant come on. I'm just waiting for him to get set up. He had to move a little bit because the Starlink, as you can see, I don't know if you live on the East Coast, we have not had such great weather since this trial started. And when you have a little cloud cover, the Starlink, which is great in open air, okay, is not so good where there's a little cloud cover. So we are actually trying to set up at a new place and then bring him on. So we're not going to run Hank's clip right now, his summation right now. We want to get a little bit. Now, if we have, I don't know there he is. I see here he's coming on. And Dizzy, I don't know. We found you on Court TV. We found you on Vinny. You have it queued up. So, all right. So let's see when Michael Bryant comes on, how he wants to introduce his interview with Vinnie Politan from Court TV. All right. And then hopefully we will get to play our own Michael Bryant's interview. And it's a big day for us because when I said to you, we started with Michael Easter, I asked him, what are the three areas you have spoken to the jury about that this was an improper, incomplete, inadequate investigation? And he said, I'm going to use eyes. Okay. Also, it was incomplete. It was inconsistent. And it was inaccurate. Okay. So those were the eyes he used. And then he went through why, without giving us the specific wordings of his report and all, why it was incomplete, inconsistent, and inaccurate. And he could say a lot more. So please go back. You can actually queue up that interview. It's about 10:02 when we started the show. And you can listen to that while you're listening to us live. You can listen to both. And if you haven't seen it, it's an important interview and one for an hour. There you are. How close are we from the courthouse, Michael Bryant? Are we? Can you see it?
We're a lot closer than you. Am I on? Hello?
Yes, you are. Hello. I did the same thing this morning. I was up in the face of everybody.
Okay. See the default to the MacBook Pro microphone, which blows. So now I've got it on the right microphone. Okay. Yeah, we're just a block away, but again, and the video I'm now uploading will give folks a sense of how crazy it is within a few blocks of the courthouse. And I'm about a half a block past that. Parked illegally, got my tent up, certainly illegally. This is a nice little community park here. Wait
a second. As your lawyer, okay, I would say to you,
suggesting I don't make any statements.
Yeah, I think you just made two. Obviously, you misspoke.
Obviously, I'm delusional. The heat. I'm clearly out of my head. Don't know what I'm saying.
Thank you. Skystar's page became a YouTube member. Thank you so very much. Yeah,
so
right.
So I found a spot. And I think I will double check the upload, but I think that little journey through the First Amendment zone is going to be up pretty quickly. And I incorporated in that the interview with Vinny because I was just rolling. And Vinny was waving me in. He said, come on. And so he was in a commercial break. They have those things, commercials, so annoying. And so I just hung out while they came back from the commercial, and then we just had a little interview.
Because we have the interview with Vinny already queued up.
Let's see how bad that looks.
Let's see how it was, and then we can do your interview that incorporates that interview. We'll get you twice. Let's see. I know it's coming, and it's coming. We watched The Fan of Injustice. Watch The Fan of Injustice. The Fan of Injustice. There he goes.
It's crazy. Robert Blake found not guilty. I thought he was going to be found guilty. And to Vinny's point, you just never know.
It became a parade for the Derek Chauvin trial. Once he was found guilty, when people were waiting, crowded around their phones, crowded around radios, listening, and once they heard guilty as charged, I mean, it erupted in Minneapolis, and it turned into really a block party, a parade that went on for hours because people were just so happy and so connected to a cause. Though it's unlikely to think about Karen Reed
Brian is going to be interviewed.
the death of George Floyd in the same breath. You're hearing from people.
Into Court TV alum Michael Bryant. Michael, great to see you.
Nice to see you. Hey, could you give me your thoughts on this verdict slip? I'm asking folks what they're thinking of this second page of the verdict slip. Take all the time you need to figure that out.
It's a little confusing. What are your thoughts about the scene here? Because you've been in a lot of the big cases.
It's unbelievable, and having seen this grow over the last 2+ months, I never would have anticipated this. First of all, let's just say the lawsuits that were filed on behalf of what I'm calling the First Amendment zone led to this, because the cops here were brutal in keeping this whole area sanitized. Really, the buffer zone, they called it. It was just wrong. We filed the lawsuits. Mark Mendoza did an amazing job. This is the result. And is this, are people yelling, screaming, burning buildings? I mean, this is a pretty sedate but large crowd here.
It's extreme. I mean, it shocked me when I walked up, because I was here back in May, and a few people here and there came back with the relaxed rules and the anticipation of the verdict. How do you think it'll go here, though, if it comes back with a guilty, like we see in the overwhelming majority of verdicts on Court TV?
I'm going to call it loud disappointment. I mean, I don't think any of the state troopers' cars are going to be turned over. Things are set afire. Major disappointment, and hope that on appeal things will be changed.
How about, and the alternative? The not guilty comes down. What do you think happens in the streets here?
Just a loud uproar of vindication. Remember, this is, Vinny, this is as much about Karen Reed as it is all the folks who live here, who see issues with law enforcement here, who see issues with the DA here, who see issues with the court here. And this is a symptom for them. So if they see a victory here, I think they're going to read it as a victory on a much larger scale.
And folks are watching you streaming where? On Justice Serve?
Justice Serve TV. Yep. Justice Serve TV. Linda Kenny Bodden and I having some fun there. Yep.
All the Court TV alums. Great to see you, Michael.
See you, buddy. Hang in there.
Michael Bryant. Ted.
Well,
right,
good
then.
plug.
So
Good plug for us.
I got your plug in there. I got your plug in there.
Thank you very much. It's very nice of you. And I wish it plugged you more, because as I said earlier, you are one of the heroes. You are one of the people in the lawsuits that caused this. I mean, he's amazed to see it. That's because, what, this would have been growing all the way through, Michael Bryant. People would have been there all the way through. That buffer zone did a good job for what they've intended to do.
It really did.
It seemed like there was no Karen Reed support.
The silence zone. Yeah. I see some notes going by. How tall is Vinny? He's like 8 foot tall. So that's why I look so short next to him. And I had asked him, I said, Vinny, I know it was a number of years ago we worked together, but how come you look the same? And I don't. So he's got some special elixir or something going.
You cracked me up. You cracked me up. Anyhow, so for all of our people that are joining us from Twitter, from X, okay, please, if you like us, go to our YouTube page and hit the subscribe and share. We have a lot of you. We have thousands of you on from X here, and we welcome you. We have no idea how many people would be joining us. And also, remember, we have the interview that we did this morning from Michael Easter. That is kind of important. I'd say kind of very important, because it's going to show you if there is a verdict against Karen Reed because of this police procedures not being called. That's going to be reversible error. But you did more interviews, Michael. What did you do? You told Vinny you were talking about these verdict sheets, which I have in my hand.
Yeah, I just wanted people's opinion on it. Not that I was surprised by the confusion. And of course, I have to, temper it with this is a very biased crowd. I'm still looking for, like Diogenes, I'm looking for one honest prosecution supporter. I have not found any. And so I'm asking these folks what they think. And of course they think, well, it's going to be easy because we're not guilty and then it's all done. I said, but work me through that form. How do you get from A to B to C? what does it do for you?
Neil Rockheim made a very good point before we go to the forms. He said, and it's true, normally you have these forms before you close that you can say to the jury, okay, now all you have to do here is you go here and you check one. And even if the form is confusing, you tell them why it should not be confusing to them, and you show them how you get to the verdict of not guilty for what you are defense attorney. She very casually or purposely didn't give these verdict forms to the defense before they closed before the jury, and they were asking for them. Are we going to get one? Oh yeah, here.
Yeah, okay.
Yeah, you really want that? So the defense filed a motion. They said that they had filed a verdict slip, as they call it there. I'm going to call it verdict form. They filed a verdict form slip, is what I'll combine them all. But in the madness of the other day, where she just kind of handed it to them, and everyone's trying to look, and they're trying to give an alternative form, and all in response, the wrong one got filed, and they wanted to correct it to the one that they had marked as an exhibit, which is LLL for Linda. Okay, ironically, and what does it have on it? Let me walk you through what the defense asked. Okay. The defense asked, and the first count they didn't really have a problem with. The first count was the homicide, the murder count, right? The second count, manslaughter. It says manslaughter while operating a motor vehicle offense as charged, not guilty or guilty, and then explains the reasons why you have to check if there's a guilty. If there's a guilty, you have to check manslaughter while operating a motor vehicle under the influence of alcohol, and or manslaughter while operating a motor vehicle under the influence of alcohol with a blood alcohol of 0.08 or greater. So the defense asked that there be a not guilty and a guilty, so they could choose. The jury could see, we don't just have guilty, because the original the court's verdict form, we don't need to put that up right now, we had it earlier, only has guilty on the 4 counts dealing with count 2 and its lesser included. It only has guilty. They have no place for the jury to check not guilty or even believe they could be hung on it. Okay. And then the defense wanted on the involuntary manslaughter a lesser included, simple, not guilty or guilty. All right. That seems pretty clear. Denied. On the motor vehicle offense, homicide, felony, OUI, liquor, and negligence, lesser included offense, not guilty or guilty. Okay. And the guilty says you have to check one or more of the following: motor vehicle homicide, felony, OUI, liquor, and negligence by operating a motor vehicle under the influence of alcohol, and or motor vehicle homicide, felony, OUI, liquor, or negligence by operating a motor vehicle with a blood alcohol level of 0.08 or greater. So guilty, that's still not guilty or guilty. Let me just avoid the last one, the plain OUI for a second. But the point is that all of the defense is asking for is, at least if you're going to use this stupid verdict slip to begin with, and you're going to charge the lesser includeds, that Hank Brennan didn't want any of the lesser includeds. Apparently, defense wanted one of the lesser includeds, and we're going to talk about that next. You have the option to choose guilty or not guilty. So that's the difference of what the defense asked for, and they wanted. They did the same thing for, the first murder, and murder in the second degree has guilty or not guilty. All right, on all of them, and this was denied, just denied.
Yeah, I mean, it's far too logical. It makes far too much sense. Have you spent much time talking about the penalties for some of these lessers?
No, I did not. How about you? Did you?
Yeah, I've done a little bit. I did actually the other charges as well. Obviously, the bigger charges. First one is the mandatory. That is, of course, they describe it in Massachusetts as OUI. I realize in most places it's a DUI, driving under the influence. They've expanded that, operating under the influence, so that it covers things other than driving. Technically, if you're on a bicycle or on a skateboard,
or like in New Jersey, if you're just sitting in your car at the driver's wheel, it covers it. You don't need to be driving.
Operating.
Yeah.
So it's manslaughter with the OUI overlay. It's a mandatory 5 years, max 20. Okay, so.
Well, we know where that's going if she gets convicted.
Yeah, I mean, and that is the second charge, and that's the one that hung the jury up the last time for the leaving the scene of the accident, and that again was disposed of almost immediately last time, from what we hear from the jurors, pretty quickly. But that is technically leaving of the scene of an accident where death results. It's a felony. mandatory minimum 1 year, up to 10, and then these all come with monetary fines. Not monetary fines, and then of course second-degree murder, the top charge, again quickly disposed of by the last jury. Mandatory sentence of life imprisonment for the top charge. Of course, like any legal statute, life doesn't always mean life. Is life, that's the sentence, but you're eligible for parole after 15. So it's not life without parole. So, and then under the others, I know the OUI, I think you looked at that, right? A couple of years. Obviously you lose your license. She's had no license for 3 years.
That's the one we haven't talked about. That's the one apparently the defense wanted. That was the only lesser included they wanted. And that she's already had her license suspended for how many years? So, but there's also another agency. All right, this is the criminal aspect. There's also another agency that deals with your licenses in every state. They can actually have your license taken away forever if there's a death, if they find there's a death involved. By the way.
Yeah, the DOS, the Department of State, for most states, that administrative agency has really the first look at things like this.
Yeah.
So
what was the penalty for that? What was the penalty for that, Michael?
I thought it was max 2.5, but it's all at the discretion of the judge.
Yeah.
Which is what concerns people.
Well, yeah, because if she gets convicted of that, the judge is going to throw her in prison. It doesn't matter. We know this judge is not going to. This is personal now because the defense attacked the judge.
It could happen. The folks gathering, and I mean it's more than gathering. It's I continue to call it the Trevi Fountain, which is about where I was doing the interview with Vinny. It's just packed. I mean, these stairs like the ones behind me, just chock-a-block people, boom, 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 and on the berms on each side, and even across the street, which has been sort of a sanctuary. The street right where the steps to the courthouse are.
Right.
That has been pretty much empty except for the media when the parties come and go. Now on the lawn area next to it, people are starting to filter in there. And I don't think it's prohibited. I think it's just been respected, maybe thinking that people didn't want to be rousted by the cops. But now they're starting to filter in there and we'll see what happens. There was a gathering of at least 7 or 8 stadies just standing at the curb.
And stadies are for people who don't know.
State troopers, the state troopers, MSPs, Massachusetts State Troopers. So the stadies are just hanging out there, and the point is they got nothing to do. People are not destroying property. They're not even loud. And you remember that Alan Jackson told the crowd last Friday, like, shh, keep it down. Now they do that. They do this. Am I doing that right?
Yes.
This is the symbol that they all do.
Right. That's what the symbol they're all doing, right?
Yeah, which is, it's kind of an interesting maneuver. Reminded me of, I always think of movies.
The Italian.
Reminded me of Hunger Games. That's what it reminded me of. Remember in Hunger Games where they were giving a symbol to Katniss?
Yeah,
which I think was that a V or was that what was it? It was something. But it's something
a very. But this is actually an Italian symbol, by the way. Just the Italian hand motion. We won't go there.
Is it? But that's the derogatory use, isn't it?
Yeah. Well, that's I'm Italian. What can I tell you? We put what we see in what we are and who we are, who we are. By the way, the load is up. Justice Serve TV, photo bombs, court TV at the Karen Reed trial. We should probably add that. But do you want to try to see if we can load that and run that for our viewers? Because you have more than just the interview there. You have what you're seeing, which is the sea of people that I say you, Michael Bryan, have created by having a First Amendment zone and getting rid of the Baja zone.
We can run it if you want. The interview with Vinny, which will be a weird perspective because it's just me holding my camera and microphone while he's doing the interview. I probably have basically a shot of his tie. I don't know. But yeah, it does have the lead up to that, which gives I think a pretty good sense of what the streets are looking like and how the people are. I mean, and they're very interactive, of course, and happy to chat with you. And in this case, help give their opinions on the verdict slip. So
yeah. So I
can do it, or somebody else can do it. It's up to you guys. However,
okay.
I think it'd be better if somebody else did.
Are you able to upload? It says if you can do it. I think this says, are you able to upload the video? You did. You did upload.
Yeah, it should be there. So let me see if I can find it and upload it, or I just
posted. I just ran it. I just posted the link to Twitter, by the way.
Let's see. Okay. Looking. All right, there it is. Is it up? It says it's still checking, but maybe it will work.
No, it's up because I see it. I see it there. By the way, I can't for some reason no longer get on to the Justice Serve TV account. Okay, just so you know. All right, manager, welcome Justice. Okay. Apparently, I am not allowed to get on the Justice Serve TV YouTube account anymore. That's an issue. I don't know how that happened.
I don't either.
It says I have to sign into Brian. I had to sign into Brian and Baden and then verify that it's me to get into the Justice Serve TV account. So
curious.
just so you know, guys, I can't get in.
Did you not pay your dues? Is that what
Did I
happened?
not? Did my co-host get me out? I mean, is that what happened?
I would never do that. Let me see if I can find. Okay, I'm still looking. I'm looking.
So I can't help you because just so you know, I am logged. I cannot get into the Justice Serve TV YouTube account. Okay, just so everybody hears me, Diz and everybody, help.
Let's see. I think I've opened it. Oh, there's
there
something.
You go. There you are.
There's something. Let's see, can I play it? This is when I go up to some folks and ask them what they think about the verdict slip. Kind of go over that, but I just had to. I'm going to just flip. This is coming up from a side street. It's safe to say totally vacant not too long ago. And now as the Justice Watch rolls into the Monday after, people have decided maybe have a field trip. I couldn't hazard a guess. I don't know. 1,000 people up and down the street. That's total speculation. But you can see here's the district court, which is where Turtle Boy had his trial, and Aiden was acquitted in that. Then this is the normal spot across the street where most folks hang out. And then this area has definitely blossomed. How you doing? Nice day.
Beautiful. Better.
So that is maybe it's the weather. I mean, like you can see the whole lawn area here is packed. Those who have found some shade. I mean, although it's like 70, it couldn't. This is perfect Justice Watch weather. I mean, it's chock-a-block here. It's outrageous. There's I can't even really stop on the sidewalk because it's like a parade of folks that are trying to get by. It's a thing. Oh, hey, how are you? Nice to see you. How's everybody doing? I will. I mean, look at this. I can't even get past this sidewalk. It's crazy.
Yeah. We came in last night, so we didn't have to deal.
Excuse me. Sorry. Just, I mean, it's hundreds and hundreds of people. How you doing? Good. Like I said, this is the Trevi Fountain. Oh, like here's Vin, who threatened to give me a hard time. So I'll stay here and let him give me a hard time when he's done. I would never want to get in his shot. Professional courtesy from the days we worked together.
I said the name. I said it. I said it just because I have to make the point.
He was talking about Casey Anthony. Excuse me, right behind you here. Sorry. Excuse me. Let Vinny do his thing. I'm guessing it's a live shot that he's doing. The way they how you doing? The way they parachute in, when the time comes, I give Vinny a hard time. So again, this is to the end of the block. Again, not like these areas haven't been used for the media before, but they are now loaded with human beings. Okay, so I'm gonna do a quick pan across, even across the street, courthouse over there. You've got folks sitting along the curb in the front of the courthouse by the lawn area, that is definitely new. Just in part because kind of run out of room over here, you know. Okay, I'm going to walk back down here because I want to get people's reaction to the verdict form. I'm sorry, verdict slip. How you doing? Hey, I got a question for you. Hi, could you hold that for me a second?
Sure.
You're familiar with the verdict slip in this case, how controversial it is?
Yes.
Okay, I want you to look at it and try and explain to me the second page. First page, no big deal. That's pretty straightforward.
Okay.
Here's the second page.
Oh, wow. Yeah, that's very confusing, huh?
I don't
It's
know.
like guilty, 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 guilty. And yeah.
If you look hard, you can find a not guilty. If you look hard.
Yeah.
But how would you?
But it's confusing. I don't know. I mean, for me, I would just not guilty.
You're doing well. Yeah.
You know what I'm saying? But if there was any question, it would be harder. Yeah.
You have to decipher that.
Yeah. Well, that's why they made a motion this morning, right? And it got denied, of course. Yeah. And this was the issue with the first trial, right? It was all about the slips after when they talked to the jurors because they didn't understand how to fill it out.
Not only does it seem to give them options for lesser included, if they just get, juries get in fights.
Yeah.
Like, okay, let's just do that one then.
Right.
I'll do that one.
Right. And they don't have an option. Yeah. Yeah.
Okay.
Well, thank you.
Your take, I appreciate it.
Have a good day.
You too. Sure.
Please.
Sure.
I would
Can I
love
get
to.
Can I get your thoughts on it?
Sure.
As clear as mud. The first page is fine. The third page is fine. Middle page. The middle page, not so much.
Okay.
I mean, the fact that it takes so long just to go through it tells you something.
100%. It is definitely confusing upon first read. My thought is that at the very top, it should say you can only choose one. I mean, I get that if you choose not guilty, number one, you don't go on to 2, 3, 4, or 5. However, if you decide she's not guilty, then what? And that's where I think it's extremely confusing.
It almost makes it look like, well, don't give up just yet. Keep looking. See if you can find something.
Keep going. Exactly. I'm hoping that they had their minds made up and that everything that they're doing in there right now is a technicality.
How do you feel about where we're at 5 hours, I think, something like that?
I think it's fair. They have a lot of stuff to look over. I think they have over 200 exhibits to look at. And I think that in all fairness, if I were a juror, I would, even if I knew what I thought, I would still want to look at everything. Just to make myself feel good that I did my due diligence. I looked over everything and I still believe that she's 100% not guilty. Even though I did before, I still believe she is 100%. But in all fairness, I wouldn't want to leave the courtroom not knowing that I looked at everything I needed to look at.
Exactly. So remind me to put you on my next jury.
Well, sure.
Thank you. As you can imagine, most people, I just covered. Vinny's still talking. He won't shut up. I gotta get away. Gotta get away from this area.
Mike from Justice.
Hey, how are you? Good. Hey. Be right here. So he waves me over while we're in the commercial break, and this is just rolling wild while doing the interview.
I love that we're seeing the other side of the interview.
Look at all those people. I mean, there's so many people.
You did this, Michael Bryant.
I'm not cleaning up after him.
Yeah, Julian, I just bumped into Court TV alum Michael Bryant. Michael, great to see
Hey,
you.
nice to see you. Hey, could you give me your thoughts on this verdict slip? I'm asking folks what they're thinking of the age of the verdict.
Yeah, it's a little confusing.
It's a little bit
confusing.
It's a little bit.
What are your thoughts about the scene here? Because you've been in a lot of the big cases.
It's unbelievable. And I haven't seen this grow over the last 2+ months. I never would have anticipated this. First of all, let's just say the lawsuits that were filed on behalf of what I'm calling the First Amendment zone led to this, because the cops here were brutal in keeping this whole area sanitized. Really, the buffer zone, they called it. It was just wrong. We filed the lawsuits. Mark Mendoza did an amazing job. This is the result. And is this people yelling, screaming, burning buildings? I mean, this is a pretty sedate but large crowd here.
It's extreme. I mean, it shocked me when I walked up, because I was here back in May, and a few people here and there came back with the relaxed rules and the anticipation of the verdict. How do you think it'll go here, though, if it comes back with a guilty, like we see in the overwhelming majority of verdicts on Court TV?
I'm going to call it loud disappointment. I mean, I don't think any of the state troopers' cars are going to be turned over. Things are set afire. Major disappointment, and hope that on appeal things will be changed.
How about in the alternative? The not guilty comes down. What do you think happens in the streets?
Just a loud uproar of vindication. Remember, this is, Vinny, this is as much about Karen Reed as it is all the folks who live here, who see issues with law enforcement here, who see issues with the DA here, who see issues with the court here. And this is a symptom for them. So if they see a victory here, I think they're going to read it as a victory on a much larger scale.
And folks are watching you streaming where? On Justice Serve?
Justice Serve TV. Yep. Justice Serve TV.Da Kenny Bodden and I having some fun there. Yep.
All right. All the Court TV alums. Great to see you,
Hey,
Michael.
good to see you, buddy. Hang in there. Oh, hi. Nice to meet you. Oh.
I didn't realize that was you.
Oh, yeah. That must be it. I was rude to keep my glasses on, wasn't I? It's so bright out here. Yeah, she was critiquing the interview because I left the sunglasses. Hey, what's happening today? Good. I'm just visiting with my buddy Vinny there.
Yeah. Hi, Linda.
Hi.
Hi, Linda.
Hi. Hi, everybody. Love you too. I know you can't see this, but maybe you'll see it on replay.
Really?
Yeah, so we'll re-rack that for folks who didn't get a chance to see it live. I was promoting the Easter. He's amazing. Yes, amazing. The jury should have heard from him.
Cheech has been around.
Okay, so what's your take? What's your take? 5 hours plus in. What you do?
227. They're going to come back not guilty on 3 counts.
Just to send a message.
Absolutely.
All right. Interesting.
If
All right.
If anything, guilty on the driving under. But I don't think any of them.
All right. We'll see. Take care, guys.
I love Cheech.
Yeah. And you are? Hi, Kelly. How are you? Nice to see you. Okay. It's like you ever go to a like a concert and near you get to the stage, it's like suffocating with also many bodies. That's what it is. Not in a bad way. So I'm gonna wrap this little journey up. You got some takes on the verdict slip. It's a slip, all right. It's a slip and fall. Hey, isn't your plane leaving soon? Yeah.
Actually,
yeah.
about 6 o'clock. So we can
Oh, you got time. You got time.
I'm hoping.
Okay.
Soon.
Good luck.
Thank you.
Hey, good to see you, man. That was a young lady I interviewed last week, and she was concerned because she had flown in from Minneapolis. Her trip was going to end before a verdict, so she's got a few more hours to see if it can squeeze in there. So here's, this area here is, was the original kind of buffer zone. And even it's blossomed a little bit from folks across the street to a much heavier presence here. I have not
now
done
they can say put
full
signs there.
share
They,
count, but,
Michael, while
it's up.
you're interviewing this,
Definitely
they
up.
can put signs there, right?
Yeah. Yeah.
What's up, Scott?
Scott, I just overheard that. Scott McGinnis joining Will the Glarer, who's streaming, as in, it seems, most everybody. We'll check in with you again.
Michael,
All right, then.
that was fabulous. I love it. You're interviewing Vinny. He's trying to get an interview with you. You're interviewing him. And like he doesn't know the history of this whole thing. It's like, well, I'm surprised. What if they didn't follow the history of you? I mean,
I talked to him. I talked and I talked to Matt Johnson, who's been the on the ground correspondent here.
Right.
And I gave him, the background on this First Amendment fight that was underway. And they never really grabbed onto it. Maybe it wasn't salacious enough for them. But I think now that Vinny's been here, he definitely sees the difference from, he was here before and now after, and it's a massive difference.
Yeah. We did put this up, by the way, Madeira Beach caregiver. Are you still in Moscow, Russia, Madeira Beach? Excellent coverage. How? But let us know, where are you these days? You are amazing in your hospice nurse duties, and
I'd love to hear some Moscow stories. I was in Moscow in '60. I love the city. Putin and I were hanging out. No, it's a beautiful city, but I don't know how you can get in and out of there these days. So I'd love to hear that story.
Yeah. So when you see the car that says free carry, and then the sign, I guess, that says the buffer zone is right on that post. So people are still able to walk past that car because now the whole First Amendment zone has gotten so big, you're right up to that.
Yeah, as long as you don't have any signage, you could. This is so odd under the court order. You can have a sign that says Massachusetts State Police are corrupt, or criminals run Norfolk County.
Yeah.
That's okay, but you cannot have a sign that just says free Karen Reed.
Yeah. Yeah. Hey, my sis is in the chat. Hello, sis. One of these days I'll get to see you, okay, in person rather than being here with everybody. Although I love being here with everybody. Joan's been following this case, and she's my sister. I have to point her out because I love her.
How's sis doing? Is sis good?
Sis doing good. Sis is doing good. Yeah, yeah. And they're always through sis's operation with me, as you know. Sis is in there, this is doing this, and so yeah. So they haven't had a question yet.
What do you make of that? What do you make of that?
Well, first of all, this is the first day they're really working, and I think all 12 of them want to be heard. We've been talking about this, like we can't stop talking about it. As a matter of fact, if we go out and somebody doesn't know about Karen Reed, we'll say, "What do you mean you don't know about the Karen Reed trial?" Right? But they have been sitting there, and I think a lot of them have thoughts they want to get out, and so they probably were going through. I think that Richard Gabriel hit it on the head. They were going through their thoughts first. I don't even know if they've gotten to this debacle of a.
Yeah, if they are like the first jury, they quickly went through 1 and 3 and set that aside, and then focused all of their attention on number 2. Interesting, it is number 2 because I'm thinking of a different number 2 when I look at that page. But they spent days. It was 4 days, the first hung jury, and it was all about the second count and all about the lesser includeds. And so, wild guess would suggest we're heading down that same path. The real question is whether they're going to come to some conclusion or not. Hey, let me say thanks to those who have contributed. Nice to have a little refreshing soda while I'm here hanging out at the park. A couple more donations, and I'll have vodka to put in it. It'll be great. So,
and by the way, if you're joining us from X Twitter, X formerly Twitter, okay, please go to our YouTube page and hit the subscribe and like and notify so you get notification when we're on. And also, if you're just joining us today, you know that Michael Bryan's making I think it's your 14th trip. I think Thursday.
It keeps getting bigger. I'm not sure. It's in the
Friday
teens.
13th. But no, because you see how you know everybody, and I'd like to get Jason Grant back on. We haven't seen him or Scott on the show in a while. They've been in the chat, but they've been one of the they've been there from the beginning, and Jason was one of the original plaintiffs in the lawsuit too. So I'd like to try to get his thoughts back on as to what's happening. You're there. You're with everybody knows you. Everybody knows you.
Well, I'm like the town bum. Everybody knows the town bum just wandering around.
Haven't seen Dina though in the past couple of days.
I saw her earlier today. I did.
Oh, you
I
did?
saw her.
Okay.
She was covering the live for. I always forget the name of their channel. Silence.
Yeah,
What is it again?
I forget. Resistance. Something about.
There you go. There
Yeah.
you go. Resistance to Silence. Yeah, she was
Resistance
covering
to
it for them.
Silence, right.
She actually has been getting into that little zone there in front of the courthouse that generally is for the media, and she's been real chummy. Yeah, she's been pretty chummy with Hardman and some of the other state troopers. So she's kind of worked her way into unofficial media. So
yeah, that's good. And so we have that. We also have the jury. Maybe we don't know. Obviously, this is lunchtime. We don't know whether it's like in some states when they send lunch in, they stop the jury clock. They told them they can't deliberate. We don't know what she is informed them, whether they can deliberate through lunch or they can't. But in many states, they stop it and say you can't talk during lunch, even if you're in that room, even if you're in that room. I mean,
okay. What's the point? Focus on the food, please. Focus.
Right.
It's dumb. People. When are you more likely to have a conversation in the real world? Hey, let's go have some lunch. And what do? You talk. Right. So why would you shut it down during deliberations? I seem to remember, as she was prepping to send these folks out, some brief reference to deliberating during lunch. And I don't know if it was a question she was asking them or just a what if that she was throwing out there. I don't know, but it seemed to come up.
Michelle W. says, I hear they stop the clock until 2. We're all hearing stuff, but we, usually the judge will say it. They'll do it in open court. And she may have just done it with the lawyers at the sidebar or whatever, Oh, Michael, blessed in Texas has your name. Although isn't he dead?
I was going to say, I think he just died recently.
Yeah.
But I'm not sure. I'm both offended and honored. So thank you.
No, he's honored. Blessed in Texas. Thank you very much for that donation. I think that's a wonderful, wonderful compliment. George Wendt. Yes, George Wendt. Yes. And all. But what's worrisome about the second count, the way this is, just like the person I was speaking to this morning, and I may have to go down and speak to downstairs somebody else, by the way, in 10 minutes, just so you know, just in case I have to run for a few minutes and leave you all. And I'm going to show this, is that Madeira Beach Care was sitting in Memphis till Thursday, but thought about rerouting to Boston if I thought the jury would still be deliberating tomorrow. See my previous comment regarding my patient in Moscow. Somehow I didn't see that come through Madeira Beach. And I know it'll find its way. I didn't see that come through, and maybe okay, got it. All right, here it is. Too bad you both can't tag team the streets of Canton. That would be stupendous. I was stuck at Memphis last night en route to Madeira Beach, Florida. Bad weather. Okay. All right. So we see that. Okay. Wow.
So
you do travel
but
a lot.
obviously returned from Moscow. So
yeah, obviously that's a return from Moscow. So, but what are you hearing from people? Because the first trial, we heard from the who was it with the bow tie? The guy.
Ronnie Bowtie.
Ronnie Bowtie. Who,
yeah.
And it may be like a conversation. Well, she was drunk, as was everybody there, right? Okay, as was everyone there. And he ended up dead. And so, she must have hit him, and therefore we were hung up on that. What do you say when someone says to me, well, come on, of course she did. She knows what she did. And there's no other reason for why he ended up dead. So therefore she must have done it. And she didn't tell us what she did. So therefore I find her guilty. And that's basically the comment I heard this morning.
Yeah, it can happen. And it really comes down to, as we've talked about before, the strength of the personalities of the jurors. If you're an alpha and you want to cram that down somebody's throat, and those somebodies are sheep, it can happen very easily. People are malleable. Then on the other hand, if you get a couple of folks that are they lock horns and, as I say, get their neck bowed, and they're not gonna budge, then you can hammer it out all you want, and it still spells hung jury.
Do you think the addition that was added, the OUI, is good for the defense or not? I mean, why don't they find everybody guilty of OUI? They all said they were driving while they had been drinking. OUI doesn't necessarily mean that you were. Let's explain the difference. The legal standard for drunk driving in Massachusetts is 0.08 of your blood alcohol level, right? And then you could still be guilty. People don't realize this, of driving under the influence if you're in some way impaired, because you had liquor. So you had one glass of beer, but somehow that one glass, this would be me if I were ever driving. But I don't drive when I drink. I don't even drink very much. Matter of fact, I hardly drink at all, unless, of course, it's top-end champagne. But that's a confession.
That's right. I'm not going to drink anymore. That's it. I'm not going to drink any less.
Yeah,
but
people don't understand. You could still be charged with driving under the influence in various states, even though you don't mean the legal limit, if indeed you're in some way impaired. Now, talk to us about that. Weren't they all in some way? Why did John let her drive him? Because he wanted her to drive him because she was, he wanted to be impaired, and he felt he was still drunk from the night before on those tapes.
Yeah, I think it's a very interesting issue because people, they heard the retrograde blood alcohol level testing.
Extrapolation, right.
Which suggested that she was, I'm trying to remember, a 0.13, 0.1, well over the 0.08, which in some states is a presumption of intoxication. I think you told me in Jersey
it's not even rebuttable.
It's not even rebuttable.
It's not even rebuttable, right?
Yeah, in California it is rebuttable, and I think in most states it's rebuttable. But you don't. That's just
which
one
means
way
you
to
can't
get there.
challenge it. By the way, for everyone who knows,
correct.
Which means you can't challenge it. You can have it, but then you can still challenge the scientific underpinnings and all. In New Jersey, it's just that's it. Unless the judge refuses to allow it in because there wasn't 2 blood tests, which is the standard. The second blood test will show you whether you go up with it. If they had taken a second blood test later on and she was like still going up or something, that means she would have had drinks in between that 5 hours possibly.
Yeah,
right?
and
But they didn't do
that is all subject to discussion and dispute. I don't think it was firmly, not beyond a reasonable doubt, proven. But you could also be found, let's say you blow or a blood test goes 0.07, you're under the legal limit. You can still be found to be OUI based on other factors. So in this case, they're relying on that retrograde blood alcohol level. They think they're done. That's it.
Right.
We got it.
That's
I think the jury has to believe that the test was legit. Remember, it was a clinical test, not a legal type test, right? And we don't know what happened in those hours after 12:30 before between 12:30 and 5:30. We don't know if she was pounding alcohol then. If so, that would affect the number, and the retrograde to 12:30 would mean nothing.
Would mean absolutely nothing. Madeira Beach caregiver, thank you very much again for that donation. My patients tend to be high profile. Patients with private planes. Here's for your vodka, Michael. You're really great. But let me tell you, Madeira Beach, she is a hospice nurse. She has my greatest respect, because that is a profession that really you must choose to be in that profession, because you are really, you're the last really nurse that people are going to really see. Just as like the doctor said, Dr. Leposada said, I'm the last doctor my patients will see. Well, you're like the last nurse that your patients will see, and the family and help. It's just so great.
And to do that, over and over for people, that is
unbelievable.
Yeah.
Unbelievable.
Yeah.
Teresa, I want to thank you both so very much and all you do. Free Karen Reed, free Turtle Boy. Yeah, I mean, we forget he's still got some major charges out there against him. So I think they're all combined. And then it's interesting that Hank was watching that. What is he playing? Was he playing? Did he watch John DePetro, or did he watch the Paul Morris show where he said, well, maybe they're going to charge Karen Reed with some kind of conspiracy with Turtle Boy if she gets acquitted? I don't know, Michael. What do you think?
Yeah, well, that's why they're asking for a jury instruction about intimidating witnesses when there's no intimidating witnesses charge. I mean, what are they forecasting what they hope to happen after the fact? That was just a weird request, which clearly didn't make it into the final list.
Yeah, but real request. Madeira Beach, again, thank you again. You're just so generous to us. How is it legal to charge OUI post-incident, Michael?
Yeah, well, what they did was retrograde, and they're basically saying we have scientific evidence that even though there wasn't blood alcohol drawn at the time of the operating of the motor vehicle, there was after the fact, and we, with our shenanigans, our mumbo jumbo, our science, bring it back to when she was driving. So that's why it's so suspect. There's so many factors that I don't think they sewed up tightly enough in this case to pin her.
And they also said, they also rely on her saying that she was buzzed. But then I think Alan Jackson, in his closing, said what you and I have said on the air. There was no indication at all, if you're driving at all, that she drove improperly.
No erratic driving.
Yep. The next morning when she's frantic, she bumps into the car, but that's in that small driveway. But there's no, and the data, if you want to talk about the data or the data, depending on how you pronounce
Thank
it.
you.
Okay, the data or the data, you say tomato, I say tomato, type thing of Cole Porter, said that she was driving within the speed limits, being very careful. And it would seem that her trip back from Fairview to where she, to One Meadows was also appropriate, you know.
Yeah.
And they lost the library video. Is that what happened?
Well, yeah, I people ask about that when I made that drive the first time. Where was there? Did you see the library camera? I don't know what happened to that, but all it did was show her vehicle driving past. So I mean, it did lock a time in that was consistent with the other time frame, the arrival at 12:36 when her Wi-Fi kicked in at One Meadows. I've seen a lot of folks say, well, how come she could be charged with OUI? What about all those other cops? Well, relative deprivation is common in the law. Just because other people are violating the law and you are the only one charged doesn't mean what you were charged with is invalid. Just means they're lucky. They know somebody. It doesn't minimize what you've done wrong. If you've done something wrong.
Higgins was like, oh, I went back and have 5 more.
He had a lot of those whiskeys.
A lot whiskeys. I mean, whiskeys. 5
and he
whiskeys.
leaves 34 Fairview, he says, because they don't have hard alcohol there. They just had beer. So,
Yeah. And let me just acknowledge this Curious Law Tuber gifted 1 Justice Served TV membership. Thank you, Curious Lawberry. And we have another Sky Stars page who just became a member today, gifted 1 Justice Served TV membership. Thank you again, because as I said, it's very important for people, who can't afford these things, and you guys come through for them, and we really appreciate that. We try to do the best we can with all of our time for all of you, and you really are our subscribers who have quickly come to us. Hopefully, we're giving them good analysis and good experts. And one of those experts I'm going to ask you about right now, Michael Bryan, we heard from this morning. We had the first exclusive interview, just as we did when Joe Tacopino finished A$AP Rocky. It was his first exclusive interview for Streaming Network, on a streaming network. Actually, his first interview. All right, since the court denied him to be a witness. And he talked about things that you can do. And he kept saying one of the things you do, because this investigation was incomplete, inconsistent, and inaccurate, is you go get all the first thing you do is get all the Ring and CCTV coverage. Talk to us.
Yeah, he was amazing, right? I mean, it's a shame the jury did not get to hear from Michael Easter. And he's got an amazing background as an FBI agent in traditional law enforcement. And he just ticked off all the things that everybody has been made aware of, things that did not happen in this case. I mean, the solo cups and the leaf blower, that's just the start. Cordoning off the area. He was surprised that there wasn't an all-out, show of force because one of their own was down, right?
Right. That was a big thing to him. Tell us why.
Yeah, really big thing. And well, he said, he said I'd walk in snow to come help a fellow officer that was down. Where were all those people? And when I suggested, maybe they had other motivations to protect other officers, he wasn't able to speak directly to that point, but he did acknowledge it, and just was just shocked that this place was not overrun, 34 Fairview, with off-duty, on-duty, auxiliary, neighboring police officers when one of their own is down.
Yeah, he talked about the thick blue line should be helping the blue line. They should be there creating that blue line. Sky Scars page, thank you again for your donation. Again, thank you much. You guys are an amazing team. We heart you. We love you all. Michael Bryan, I just happened to go quickly. I was on his show at Law and Crime, and he was into these funny little things and demonstrations, and I was too. And we just kind of knew, we have different points of view on a lot of things. But, our view is that unless we talk as people, even we have different points of view, like in a jury, hey, you're not going to get very far. So we kind of clicked. And so when Law and Crime decided they didn't want expert analysis, even though we were only doing it as 2 hours a week, it wasn't like a full-time job. Our full-time job is being lawyers, right? And we have full-time law practices. But we thought that we had something to contribute. And we just first thought we'd just do something like 7 minutes a week and have fun. So we kind of putzed around last spring, just kind of having fun, do here.
Kind of got into the Michelle Troconis case. We got into that, had the first interview with her sister, Claudia Troconis.
That's right.
But then when they decided no analysis, we kind of jumped in with both feet, and that was in September. So
right. Yeah, in September. And then for the first month of that, we kind of floundered around till we got our legs, and then Diz and Missy came on board, and here we are, and we really started taking off in October, and now it's 15,000 of you strong, and we do hope that if you're coming from X or Twitter, please hit that like, subscribe, share button, and if you're already on our YouTube page and you haven't come from X or Twitter, please hit the like, subscribe, and share, and notify, because then you get notified when we are on the air. All right. So
I was doing the other day. I was doing something out at the house, some yard work or something, and I started to think we're like Green Acres. You know, the couple of lines from the
yeah,
the chores, and then you say the stores, and I say fresh air, and you say Times Square. Yeah. So people know the Green Acres show with Eddie Albert and Zsa Zsa Gabor was one of the
no, it was
Gabors.
the other.
Was it Ava Gabor?
Eva
It was
Gabor, I
Ava
think.
Gabor.
Yeah. Yeah.
So yeah, that's that's it. We're true crime Green Acres. That's what we got here.
And the one of us is out in the field, and the other one's shopping. We're wearing Chanel. Okay, no problem. We're kind of like
Nothing
that.
wrong with that.
Sharon Logue wants to know how the weather is there, Michael. Is it hot?
It's beautiful. I mean, it really is the best Justice Watch weather we've had. Not too windy, cloud-free sky. It's amazing. Good day for a verdict.
Yeah, PTSD to Hiller. Green Acres is perfect for you. Oh, that's great. I think we're gonna have to do something with that. We're gonna need. I can see
pitchforks and
I can see Joey Kane putting together something with us with Green Acres, and they have Big Pig. Didn't they have a friendly?
Oh,
pig?
Arnold the pig.
Arnold the pig.
That was actually, I believe, that was the mayor's pig or the sheriff's pig. I can't remember now. Yeah, Mr. Haney. Mr. Haney ran the store. Mr. Haney ran the store.
Green Acres is the place to be.
Yes,
That may get us a.
Don't get a strike.
Copyright strike. Sky Stars page. I thank you again. I've only been with you all month. Would love to have story time one day. How you all get together. Goodbye, city life. I can't. I do go to the country. We have as you all know, we bought a cabin in the country. I'm not sure if that's a good idea because I said to my husband, well, be careful when you step out. Make sure you don't you step on a rattlesnake. And I said, I just read an article. You have to be 100 yards away from a bear. And if you hear a coyote, you got to get 2 in. He's like, I'm scared to move. We can't. Why are we even here?
Yep. Mm-hmm.
Yeah. Darling, I love you, but give me Park Avenue. We have to do something with that. Yeah, we should do it. We could do what? That's one of the things we should do for our members. Maybe a full dive into how we met. If we did a full dive into how my husband and I met, it involves an autopsy, but that's a different story.
Yeah, that is I don't think there was nobody died in our collaboration, not yet. Anyway.
Yeah. At least not yet. And all, but you are an incredible. I will say, Michael Bryant's an incredible partner to have in this. I mean, he
Likewise,
is
right back at you. People know a courtroom star. I've dabbled. I've worked in the trenches, but you've been on the marquee of some amazing cases. So
they all seem to be mentioned in this case too. When they were going back on, we wrote all these summations that talk about Jose and all that type of stuff, and with Richard Gabriel, who you saw. Some of you didn't like because he said that Hank Brennan's a very good lawyer, and if you don't think the defense is thinking Hank Brennan's a very good lawyer, I'm telling you, you are wrong. They may not. They know he's an adversary, just like I knew Jackson was an adversary. We butted heads. Now you love Jackson and all, but we butted heads. I mean, and so a good adversary. As a matter of fact, you have to be wary of a good adversary. It's the because they are good. So don't underestimate anybody.
Yeah, I think they respect him. They think he's down and dirty on a lot of fronts, but his abilities, I think they respect.
Yeah. But they caught him. They caught him with those holes. He just went one step over the line, either purposefully or imperfectly, with the holes in the back.
And I would love to be inside his brain just for a second, just to see if that was purposeful or just got carried away. I don't know.
Yeah, or I can't imagine. But he did seem to be worried. The only thing is, he did seem to be worried. I mean, we talked about it when that happened, and he looked at like he had never seen the backs of these. And I'm wondering, sometimes when you're coming in and trying a case, you're being fed information by people in the office that you're not a prosecutor. All right. Yeah, I'm almost wondering whether or not somebody sandbagged him. I have to tell you.
Interesting.
You can't exclude that happened, that somebody who was prepping him told him about these holes in there, and it turns out that no one corrected him. Because he did seem, Stars Page, yes, that's what he did seem worried. He never saw that before because he was looking. We go back and look at that. One day we should look at those.
When he admitted his mistake, when that unfolded.
Yeah. He did seem, and usually he comes up and he really, says, he is very forceful against it. But as we commented that he seemed worried when he was looking at the two pictures. I'm just wondering whether he got sandbagged there. It'll be interesting to know the real story. You think he's going to ever tell it?
No, no.
Okay.
There's not to anybody other than family, friends, perhaps at most, because there's no upside to telling that story.
Yeah.
Hey all, sorry. I might have nodded off there for a little bit. What I'm going to do is I'm going to set this to run for the next few hours. But I'll have my ears open, but I won't be commentating. I can't keep my eyes open, and I'm a bit of pain. So I'm happy to keep this running. And if you're happy to keep watching it, knock yourselves out. And I'm going to set it to turn off automatically. Alrighty, enjoy. I'll have one ear open, but both eyes closed. All right, darlings, love yous all, and hopefully we get some good news. Alrighty, mwah.
I wonder where he's staying. I assume it's staying at his office, or he's staying at a local office.
Yeah, I don't know. I do not know. I've not seen him at the bagel shop where he was going for lunch every day. I've not seen him there.
Yeah.
I'm telling you, if you go to that crossroads, which is where I was parked before, but with bad Starlink signal, the pink going back and forth at those crossroads.
Simi, the
I'm sure
AI
now at lunchtime it's inundated.
predictions,
but all
they're
through
in the main
morning,
chat on Discord.
as people are,
and
not
so
everybody
are
just
the
sits in a chair.
analysis
A
of
lot of people do, but some of them they just they're
closing
taking
argument.
it in and they're walking the street. It's a
Alrighty.
cute little town, but for what's happening in the courthouse.
Now, I saw when you were interviewing somebody not that we haven't know before. They had the pink shirt on, and they have like the blue painters tape over their shirt. What's that all about?
That's a good question. I don't know if that's making fun of the blue man. I don't know. I should have asked. I didn't know.
Oh, okay. Or is it covering up something that says free Karen Reed, and they're not buying?
Could be. It didn't look like it was applied, like like a sticker over something, like tape. It looked like it was incorporated into whatever the logo or the design was. So
wow,
if I
that's.
see her again, I'll find out.
Okay, all right. Now, what's your? Do you get? Should we? I know we talked about playing Hank Brennan's closing, which we should do as you go get more interviews. I mean, we do have Stephen Plord, by the way, who's on call. He's in a deposition today in California, but if there is a verdict, he will come out and he would be available for tonight. And we do have Neil. Let me see if Neil has texted me. I know he said he could do later today or early this evening. Okay. Both, by the way, Law and Crime and Court TV clocks are running, said Missy. So I guess the jury's allowed to deliberate through lunch. I gather that's what. But
That
they're
makes perfect sense. What is the number now? Where are we?
Okay, guys, where
We
are we?
know.
I've lost track. Yeah, I know they know.
Got to be 6.5, maybe. Does that sound right?
Oh, a second. Let's see it.
Yeah, I thought Dizzy. Good point. I was gonna ask if we had the technical ability to replay Easter, because that'd be great.
Yes. Oh, yeah. That was great. I thought we couldn't do that, but I'd rather replay Easter than Hank's. Hank
Yeah,
is.
yeah. People might flee if we replay Hank. Although equal time, we were ready to play him. That was the plan. But if
Okay.
we can play Easter, all the better. Then
Yeah.
maybe we play Hank at some point later.
All right. Why don't we play Easter? I think it's like about a 55-minute interview, 56
an hour.
minutes.
Yeah.
Less than an hour. And then
Fascinating stuff, I'm telling you.
yeah, we did opening statements of Jackson. We didn't do opening statements yet. We're still having finished closing. So why don't we play Easter? I think he's more important. This is the witness you didn't get to see. And then Michael, that'll give you a chance
for people to hear what the jury did not get to hear. Think about how this might have affected them.
Yeah, and we'll still be here. Now we give Michael a chance to maybe. You think your tent? This is like New York City. Will your tent be stolen, or can you just leave it there?
It could blow away. I have no idea, but I might go grab a bite and wander around a little bit. Yeah,
and see what else. And if we can get some interviews from Jason and some of the people that you were with, even Scott. We haven't seen Scott.
Yeah, I talked to Scott. I did not interview him officially, so I might get an update from him. But there's plenty of folks to chat with.
Okay, so stay with us. We're going to now replay. Dizzy has it lined up. We'll replay Easter. Michael and Michael's going to disappear. My avatar will still be here. I will still be around. All right. Michael's he just woofed. There he goes. Okay, that's not a great picture of me to start with, but there we are.
Further ado, there he is, Michael Easter. Thank you, sir, for joining. We know that you're at a secret location. You're on vacation, in fact, and we appreciate you taking the time to join us. How are you?
I'm good. Thank you. Thanks for having me, by the way.
You bet. I think our people are dying to know what the jury did not hear. Obviously, you were hired by the defense. So tell us first, I don't want this to sound like a direct examination of your testimony they didn't hear, but just give us a sense of what you looked at. What did you review? And then we'll talk about your opinions.
Yeah, absolutely. I think maybe some foundational aspect would be, originally I wasn't asked to look at the investigation from this perspective. Originally, I was asked to look at it from my more kind of natural expertise, which is the historical cell phone records and other geolocation records. And that's where Attorney Jackson reached out to me originally. And as part of that, I've testified as an expert in over 200 trials, both federal and state. Clearly, I'm now retired and I do stuff privately. But when I started interacting with Alan on the case, I started asking questions that I would naturally ask about the investigation. How do we look at the phone records? How did the government look at the phone records? How do we incorporate them into the investigation and the defense case in chief? Where does the evidence put this? And as I asked more questions were not answered. And simple questions about, well, whose phone records are we looking at? Where's the victim's phone records? Where are the other suspect phone records? None of these things existed. And as the conversation sort of evolved, Alan's like, Mike, would you mind just looking at the evidence from your investigative perspective? And for that, I spent over 20 years with the FBI as an investigator. I was a law enforcement officer prior to that, and formerly a Marine officer as well. And as he asked, I said, you know what, I'd love to look at the case. Can I get access to the discovery? And so at that point, I looked at the discovery material provided by the Commonwealth, not only with the idea of looking at the phone records clearly, which was the initial aspect, but as a fellow investigator, what would I have done? How would I have looked at this case? And what are some logical steps that I would have taken along the way? And did those logical steps take place? And maybe I'll add to that last aspect was, in that review, my focus wasn't just on what evidence they collected or didn't collect in those steps, but what is the Massachusetts State Police policy? What does it say they should have done? And that policy guide is actually online. And I looked at that and made a comparative assessment of what did the Massachusetts State Police do? Is that the best practice? And is it consistent or inconsistent with their own policy guide? And then I drafted a report and provided that to the court. And I think you mentioned it, and maybe somewhat famous now, Mr. Jackson's "Do It" comment had made it to the interweb. So yeah, that's maybe start there for you. And I don't know if that answers questions or creates more, but
yeah, that I didn't realize that that's how it evolved. You know, I thought it was from the start. You know, let's look at this investigation. I've looked at your CV, so I did know that it was cell phone and that kind of data intensive, right?
Right.
So Mr. Easter, can you tell this jury what your ultimate opinion is as to how the investigation was carried out in this case?
Yeah, I can. Well, maybe the jury's not listening, hopefully, but at least the people on your channel. So for the Bureau, I also was an instructor. And one of the things I always teach is process. Have a process to dissect the problem. And when I looked at this, I really came up with three kind of words to sort of encapsulate the investigation or the lack thereof. And the first one was, I found that the investigation was incomplete. And incomplete in the logical steps you would take to determine whether Karen Reed was the suspect or other people were the suspect. Not following logical investigative steps to collect evidence, to preserve evidence correct. We can always look back to the crime scene. But even beyond that, as the case migrated throughout that day, and how quickly and even prematurely they identified Karen Reed as the sole suspect. So the first word is incomplete. Incomplete investigations in turn birth out this next word, which I think of as an easy way to look at it would be inconsistencies. And maybe I'll stick with I's, is that an incomplete investigation creates inconsistencies. And those inconsistencies can show up in time, typically. And you saw it in this case. This case was riddled with timeline issues. And that's because they never completed proper investigative steps to collect CCTV along likely travel to and from, which they should have done. They should have traced those things. You saw in the testimony of, I think Walter tried to show some Google Maps, which is a great technique. I use it, which is to use routes that the phone or the person could have taken, and then tracing those routes for CCTV, whether those are ring cameras, business cameras, or static cameras, to see if we can develop a timeline and a route of travel for Karen Reed's vehicle or someone else that could have been there. And then an inconsistency, it breeds the follow-on, and which is another I word. Maybe I should have coined all these, but is inaccuracies. Incomplete, inconsistent, all ends up with inaccuracies, and you see it. Now we have all these inaccuracies in the case that makes you start scratching your head. Why don't any of these things add up? Why do we have so many things that conflict with each other? And the reason that happens is it happens because the investigation had all three of those eyes. Their process was flawed from the beginning. And I get the question from people that know I was assisting, which is, Mike, what do you think? Are they biased? Is it corruption? And that's a really hard question to answer. And the reason I say that is I've worked cases all over the country. I've worked cases in Central and South America and parts of Europe. And I've seen corruption. And I've seen cases that are also worked by people that are just poorly trained and have no experience. And the problem is corruption, inexperience, and no training. They end up looking very similar in the result. And the problem with that then is, how do you determine corruption versus incompetence or lack of experience? And that really then becomes a hard decision for the trier of facts, I think, ultimately. My opinion is that I don't have one, whether it was corruption or incompetence or experience. I think the results speak for themselves that the investigators lack the training and experience necessary to have a complete, thorough, and accurate investigation.
Linda,
I'm writing this down. I'm just blown away with what kind of testimony Mike Easter would have given, and just the presentation, and just this little thumbnail sketch we have of having it incomplete, inconsistent, and inaccurate, leading to it could be incompetence, it could be bias, it could be anything, but it's the same result. I'm just blown away by the whole thematic approach. And so, Mike, what would you say? I'm sure you had. I always have like a rule of threes. Was the three worst things that you saw that were not done? If I'm phrasing that correctly.
So that's a really good question. I think the worst thing that was done from the beginning was the response. And that's what struck me the most. Everyone focuses on the investigation and the outcome of the investigation. As a former law enforcement officer, I've responded to dozens of OIS, or officer-involved shootings. And I can tell you that the response is overwhelming. We don't have to beg people to come in and help find the suspect. In fact, we spend more time telling people to not come in, go home, get some sleep, come back later. When I looked at this case, my first law enforcement reaction was, why didn't anybody show up? Why didn't everybody show up? I would have walked in the snow to go help in this case. I've had agents that have been shot. I've had fellow law enforcement officers that I worked a lot with LAPD. A young LAPD officer I recall getting killed trying to stop just a graffiti incident late at night, brand new rookie cop, and made the decision to try to make a difference and paid his life for it. And the response was overwhelming, right? When you look at this, do you feel you get a response or an idea that the response from law enforcement was overwhelming? No, I didn't. In fact, at times I thought, why? What's going on over there in Massachusetts that we don't see this response? I always thought Boston, the old saying, blue was blue. I didn't see it in this case. Didn't, at least not in the way I would hope to have seen it, which is everybody showing up and not having to be sent home, or having to be sent home. Did you want to respond to that? I'll give you a second one, or you can respond.
No. Please give us a second one. This is fascinating. It's wonderful listening to you.
Okay. Well, hopefully I won't overtalk you. The second thing I think after that was what we see in the investigation. So then we have to take a step back. And the step back, the thing that I thought was most interesting was the lack of training. and that is a cultural problem. Their style of policing, the way they respond to this, reminds me of what I used to see about 20 years ago when I first came in. This sort of shoot from the hip, gunslinger kind of, our word is our bond. We just do what we do. This is how we do it. And it bore out in the response. I mean, we see a leaf blower, we see solo cups, we see a shopping bag. We see no chain of evidence. We see, and I mean, think of the chain of evidence that wasn't collected at the crime. So we see no preservation of the crime scene. And instead, we see an abandonment of it. It was never secured. No proper collection of evidence. There was never even a sketch or diagram done that anybody could go back and piece back the crime scene itself. Instead, we have to rely on some really blurry dash cam video to try to piece together where Mr. O'Keefe finally laid to rest, right? That's horrible. I mean, no one, the first thing you learn at responding to a crime scene is secure the crime scene, identify witnesses and suspects, separate them, do a safety sweep. I mean, you have a dead person on the lawn. What's the possibility the suspect's still present or other victims are present, not just on the lawn, but in the property itself? So that part is cultural. It's a training issue. And I think you'll see Massachusetts State Police and Canton Police PD have a huge cultural shift from this. And maybe that'll be the biggest thing that the city of Canton or that area will see is a cultural shift in the policing process. At least I would hope. And then my third one is the investigative process itself. It lacked a process. And that was the most surprising thing to me that, listen, I will give them this, is that having worked these types of critical incidences, the pressure, not just from the victim family, from your peers as you work this, but management, even elected officials. I've worked some of the biggest cases in the country, and the pressure that you get to solve that thing before people break for the day. They want hourly briefings. The investigators are under enormous pressure to solve that problem very quickly. And that's where the investigative process has to remain consistent. You can't start taking shortcuts. You can't leapfrog investigative steps and get to an ultimate conclusion too prematurely. Or oftentimes what happens is you miss evidence you should have collected. You eliminate people that could have been suspect or should have been suspects. And you sort of fall in love with the suspect too soon and get vapor lock, or which, a lot of people say confirmation bias, that's the person. We're going to prove they did it. And I want it done by 2 p.m. Or some heads are going to roll. That's those would be my three things on it. I hopefully maybe didn't spend too much time on it for you.
No,
it's amazing. Let me ask this as a follow-up, because I think if you were to testify, it would have come up. People are pointing out the fact that maybe it wasn't so shocking that the response to a officer down in the circumstance where you have other officers involved, as in, I don't know, the homeowner, and some of the others involved in the investigation. Did that play into your analysis at all? That there may have been not just let's take care of the officer down, but let's protect the other officers who might be involved?
I think it's a reasonable question. I don't think that is a reasonable reason, though. And I don't think it was ultimately the reason. Let's just say your argument's true. I still would have expected a large response, not to hide, but to a large response and to huddle. And hey, what are we going to do with this situation? And some very in these big incidences, there should always be a big command incident. There should have been a command incident commander, somebody in charge of the command, a response. There would be big type of group meetings. And then there's the small group meeting. The very intimate people that are going to really solve this problem meet separately. And we would have seen those things if this was responded to correctly. Even if, as you discussed, Michael, there is some, I don't want to say corruption, but a tendency to protect somebody. There would have still been a response, or we would have seen an enormous phone tree happening. Although we don't know that type of evidence was collected clearly, but I think ultimately that's where the other investigation that was happening was probably looking into.
And so I have a question. I just want to tell our viewers that we're going to hold your super chats. We're going to continue with Ms. Easter without doing the super chats right now for the moment. The issue of the medical examiner, as you know, my husband is a forensic pathologist. The issue of the whole medical examiner and dissing her with regard to the injuries. What would be the proper response when you have a medical examiner who says, "Look, you know, in the first 9 days, I've looked at everything you have. I don't find this a homicide. I don't find any injuries consistent with an automobile strike here." Where does that lead you? Does that lead you to say, you know, she's a whack job? Or I mean, I know I know the answer to that because that's what was in the text. But where do you go if you want to continue investigating because you don't want to have either what you think may be her vapor lock or your vapor lock?
Yeah, I found you're talking about Scortibello.
Yes, Scortibello.
Yeah,
right.
I found her to be one of the most credible witnesses there. Her demeanor, her poise, her confidence, and the science. You know, you hear the science is the science, right? It is what it is. I tend to look at things in my world of the data is the data. It tells the story. It doesn't have an opinion one side or the other. Sometimes it benefits you, sometimes it doesn't. In this instance, to really answer your question a little more fairly, is that that's the investigator's job, is to collect the evidence that proves the medical examiner wrong or allows them to make a more informed decision, right? That's where the see, when you think of, when I look back at this, the investigation was over by what, 11 p.m. It never really got legs. And because of that, you even saw in the trials, both of them, that they're still trying to figure out mid-trial in both cases what happened. Can we still collect some more or conduct more testing to try to bear out what really happened? And I guarantee if there's a third trial, there's more evidence that they're going to try to find. There'll be more testing. So this, in some respects, the case isn't done being investigated, and it shouldn't be. In my opinion, there's still some valuable evidence that's available that should be collected if they knew where to look.
Like what specifically?
I'm sort of reluctant to share, only because my job's not to help the prosecution collect new evidence.
Fair. That's fair. What does the issue of the whole FBI? The judge wouldn't allow them to hear that this Department of Justice FBI involved in this investigation. Now, was there things that you saw that you were able to riff on in your report, even though you couldn't mention FBI, as to things that should have been done? I'm not sure if I'm phrasing that right.
Yeah, I understand your question. Maybe just understand what I did for them ultimately was that in review, I talked about those three things as I looked at the investigation itself and the discovery items, and took each item, looked at it for what it provided, its incompleteness, its inconsistencies, and its inaccuracies. And then I wrote a report that identified what they did, what I thought the best practice would have been. And then I showed what does that look like in comparison to their own policy guide. And I wrote an opinion that on those key elements. And I looked at crime scene response, crime scene management, documentation, investigative techniques or lack of investigative techniques that were used, the premature assignment of individuals at 34 Fairview as witnesses only and not as suspects, no chronological case file, no overarching, well-maintained case management from beginning to end. And ultimately, I think one of the critical flaws was no timeline. And you saw that now in those trials, is that they couldn't put the time together, and they're doing it after the fact with these witnesses on the stand to try to make sense of time. Time is, when I teach process for the Bureau, especially like a kidnapping or abduction, homicide cases, where I've worked, if you've seen them, clearly we all seen mass shootings. I was at the Vegas. I worked Paddock's phone for that case. The number one thing is time. We need to establish a time from beginning to end and see where the evidence fits in the timeline. And when it doesn't fit, we need to understand, well, why. And that leads to follow-on investigation. Why doesn't this event fit in our timeline? Is our timeline off, or is this event that somebody recollected off? And we need to reconcile those things before we get to trial.
You mentioned a couple of things that are super important. One is a drum I've been beating all along, which is at the end of a trial, if you don't know what the hell happened, how do you get beyond that to find any sort of guilt?
Right.
But you mentioned, and I'll be honest about this, I've been known to poo-poo the cell phone data and how accurate it is and how reliable it is. And I think sometimes it's hard for a jury to embrace it as well. So how do you get them to believe? And you talk about, timelines not syncing up. They've heard everything in this case about what the data tells them or doesn't tell them. How do you get a jury to follow that science and understand and believe it?
Right. You bring up a good point. And I think it's important to make a distinction. When I say cell phone records, for me personally, I'm talking about the cell phone provider. And that would be Verizon, T-Mobile, AT&T, Sprint when they existed. I think in this case, the people kept referring to them as cell phone records, as the Celebrite or forensic extraction of the mobile devices themselves. I don't term those cell phone records. Those are a forensic extraction. Cell phone records, I look at more separately from the provider. And the times that come from those phone records are easy to sync up because we know what controls time in the cellular network. It's the switch for Verizon, for example. And so chronologically, we see those time events established, and we can replicate those by reattaching to the network very easily. I completely agree with you, Michael, on the Celebrite stuff. I couldn't agree more. In fact, I find, and I don't want to poo-poo Celebrate because I think the tool is amazing, but it's amazing for a couple things. It's amazing for content, your call list, and like I would say searches of the internet. It's horrible, absolutely horrible at time. And it's horrible at time because every time I've worked a case, it's always the outlier. They're like, what happened at this time? I'm like, according to what? They're like, the forensic extraction. I'm like, okay, forget time. Forget time when we look at Celebrite. Let's just look at it for content. I think there's a lot of value, and we could probably have that discussion separately. But time from Celebrite or any other forensic extraction tool, I do not put a lot of weight on it. Instead, I look at it and okay, where did you get it from? What sourced the time? Is it, when we look at the forensic extraction, time can be controlled by a couple things. One, the network time, NTOP, the network time protocol, or GPS. So what's controlling it? And how was the time recorded? Was it the event start, duration, end? Was it something they looked back at? I absolutely, you're probably getting me too excited about it. I absolutely, every time I work a case and they're like, well, we got the time from the forensic extraction, I just like, please God, help us, because it's never right. And anytime, whenever it's, you think to this case, I think you would even find yourself, there's one of my eyes, there's too many inconsistencies in time as it relates to Celebrite. So then inconsistencies bear out one of the Daubert standards, I think, or Fry, or whatever you guys use on the East Coast, of reliability. If something's inconsistent, is it reliable? Right? And I would argue it's not.
Yeah.
So yeah, Mike, I think I totally agree with you. I think if you could look past time, the forensic extractions are great for content, photos especially. I've worked so many cases where kidnappers have photographed their victims or photographed evidence that they stole, that kind of stuff. So even text content, the names of people that are on their phone tree, because sometimes that's it'll say killer 2, and it's like, perfect, that's exactly what we wanted it to say, that kind of stuff.
How about the apps? I know when we were doing Aaron Hernandez, there was an issue about whether the app's time was correct versus, because all the apps seem to have different times versus the time that was done from the extractions. How does that play in, and was that done here?
Yeah, I think it's interesting. I think one of my fellow my peers, the guy I used to work with, testified in that case. So I hopefully I don't say something that's different than what he said.
Well, I had the two not guilty on the double murder. So we didn't have the first case. We didn't have the first case where he was convicted. We had the not guilty case, which was after the first case was convicted.
Okay. All right. I don't want to contradict prior testimony from a colleague. I think what I would say then is, what was the app collecting? Oftentimes the user gives permission for the app to collect location information, and then what is the derivative of the evidence collected from the app? Did they use it for source location information? Then you should accept that the app time is GPS time, right? So it really would depend on what you're collecting from the app. If it's photos, you got to be really careful, because is the metadata from the photo is what's controlling time, or is it when the photo was sent, when it was taken? So I would think we would probably have a larger discussion on what the app's doing for you. But I tend to find apps are going to mirror device time. But we could talk about instances where that may not be true if the phone is no longer connected to a cellular network, no longer connected to Wi-Fi. I mean, there's some nuances. I wouldn't say there's always the one answer is the right answer. It would. Maybe I'm hedging my bets here, but just saying.
No, and then gets on. People have the app open. There's no Wi-Fi. They can't. The app doesn't record, and then they come to a place that the Wi-Fi or something is. Right. It does record, and then that gets all confused. That's the
I agree with you.
Right. Yeah. That's the concept. No, that's really, really interesting. So when
Hey,
you get,
hey
how many
Linda,
people-
I'm sorry. Let me interrupt, Linda, give a little update on where we are and reset here. Michael Easter is with us. He's the witness that did not get to testify on behalf of the defense as to police procedures in this case. We are now in Justice Watch's past 3 hours, and we have not confirmed this, but we understand that the defense request to fix the verdict slip has been denied. Shocking. We're trying to confirm that. Wouldn't surprise me, but that's what we're hearing. Anyway, I'm sorry, Linda. Go ahead.
No, I just had, when you gave your final conclusions and opinions, how many opinions did you give at the very end with regard to what we call the because that's how Alan Jackson wanted to use you, that you can't trust the messenger here because, how they got to giving the message was really, it's a legal term, screwed up. And therefore it's an improper and incomplete investigation, and you need the specifics from you to say that. So what were your final specific 3 opinions, if you're allowed to get them, if you think you're allowed to get them?
Yeah, I sort of want to be careful, and I think you realize why. I think generally speaking, my report laid out opinions based on those 3 things that I already discussed, which is what did they do, what was the best practice, and is it what they did inconsistent with the best practice and inconsistent with their own policy guide? And then I offered a conclusion of what I think ultimately those 3 I's, the incompleteness, inconsistencies, and inaccuracies, how that led to their final conclusion, and whether you want to call it improper or not. Ultimately, those steps, I believe, created a final outcome that makes it hard to trust that the process was accurate, consistent, and yielded the correct suspect.
Oh, I'm blown away by this, and I'm blown away by the fact the jury could not hear this, Michael Bryant. I mean, to me, it's ridiculous.
It's wrong. It's just wrong, but it's not the first thing we've said that about in this trial. That's for sure. Let me ask you, Michael, are you going to be following this? I know you're on vacation, but do you have some curiosity about what's happening?
Yeah, 100%. It's interesting. When I retired, my focus was on.
You retired at what, 35? What do you mean you retired?
I'm actually in my 50s, but yes, I retired with the focus of starting my own company to provide, sell side and other location investigative assistance and trial and expert. What I found, and I never really thought about this sort of concept of providing investigative review, for lack of a better term, but it surprisingly has become up more and more since I've retired. Is because I've worked so much, hundreds and thousands of cases, is that just look at it, Mike. Tell us what you think. And it's not something I expected to do, but I sort of enjoy. And what's interesting is I've worked one recently where I looked at it, I was like, wow, great job. They did a really good investigation. And my response to the attorney was, have they offered you a deal? Because you might want to consider one. This is an incredible case. They did an amazing job. It goes back to Mike, and it is if you do a really good case and you have great process, you have a great case management, the way you collected evidence, and it's easy and easy to navigate and absorb what happened, a great timeline. When you look at it as a on the other side now as a defense, it's like, oof, these people are prepared. I don't know if I want to go to trial with these people. Maybe I should consider a plea. Hey, client, this doesn't look good for you. Where this case, you don't see any of that, and I think that's sort of it's tragic. I think ultimately, and I think the tragedy is that this should have been done not only to the process or proper, but it should have been over the top done for John O'Keefe. That's how we would have done it. You would have been these guys went over investigated the case, not under investigated it.
Yeah. And I think as we sit there and watch this trial, we think about the O'Keefe family and we think about how they're all in on this prosecution. And yet, was it really an investigation they should be proud of, consistent and confident in, that the real criminal has been found, if there is one? And I think the answer is no. And I feel for them because they're not going to get the justice that they really deserve.
Yeah, I agree. And when you watch the I think I was prohibited from watching this trial, but I tried to catch up a little bit the other day after I realized I wasn't getting called. But when you look at the last trial, watching that family sit there, I've been on this side of the government for a long time, clearly, and interacted with many victim families. And I remember working a young girl that was working at a liquor store, and she was shot point blank in the face. And that case was so devastating. The letter the mom wrote me after we found the three suspects, I keep it, and sometimes I still read it. It's just so. As a father of three kids myself and my own two daughters, it was, I mean, it broke me to read her letter and to see the grief. And that grief exists for them. You probably would expect after this to be a wrongful death suit against Karen, but there should be a wrongful investigation suit against Canton PD and Massachusetts State. They should sue them because ultimately it's their job to collect the evidence, identify suspects, and eliminate suspects and come to the ultimate conclusion of who did it. Fair process.
Yeah.
I have two comments. One really is a comment. The comment you made before about how you advise lawyers and all on it. I always tell people that a lot of times you hire experts to give them advice because sometimes your expert will say, hey, get the plea deal here. And you can go armed with that opinion by somebody like you. It's not that when people ask, well, how many cases have you been hired on? You want to be in a high profile case? No, you're giving that knowledge to the lawyer to give it to the client so they can make an informed judgment. So that really is extremely important. And the second thing is, you started your own company. Is there a link that we can post for your own company as to what it is, where it is, and where they can find your CV, et cetera, et cetera, et cetera?
Yeah, I'd be happy to provide some if you guys wanted to post it later. I'm not sure how I would do it right at this moment, but
he's on vacation. Come on, Linda.
I would appreciate that.
Yeah, we would like to do that. And the funny thing is, we have everybody in this. I don't know if you've found this, has named people like they've named Dr. Wolf Crash Daddy. We had Chris Plord, Steve Plord, who was in California, who was a major accident reconstruction on. This has been going on and talking to us honestly about what the police didn't do. He was spent 45 years with the California Highway Patrol, and his opinion too, this was an absolutely abomination of an investigation. And he's been named Crash Lord Plord. So I'm not sure how our viewers are going to name you. I don't know if they're going to call you a police daddy or what.
I've seen a few suggestions here. We'll have to see how that comes down.
So Daddy Easter. Daddy Easter.
Linda, you bring up a good one. Is CHP? I've worked several vehicle homicides. People trying to get across the freeway or hit by a vehicle. CHP, that was sort of what I compared this crash investigation to, because ultimately it has to be a crash investigation, which no one ever really conducted until years later, it seems like. Minus Trooper Paul, his attempt at that. We could probably spend a whole show on Trooper Paul, but the CHP is incredible at this. They do an amazing job. I've never the amount of effort that they go into crash reconstruction is incredible. CHP is an incredible organization for that.
Yeah, and we could tell that, and he was pretty honest. He even talked about something about we didn't even know about the diffusers and the light, that they're so far deep in there that to get in there, you really have to get in and actually break them. A small hit, a side hit, it's not going to break those diffusers. Something I didn't even know about, that I was learning from him as he's talking, and that was a big deal. The scene wasn't locked down, that there weren't patrol cars, that you didn't even wait. You could wait till the snow melt. You just secure the scene, wait till the snow melt. You'll see where everything is, whether it's a day, 2, 3, whatever.
Yeah. I totally agree with that. And you sort of hear excuses of, the weather. Well, at that moment, the weather wasn't that bad that Karen Reed couldn't drive around in her Lexus, by their accounts, under the influence. You got Kerry Roberts driving around. And you look at some of these videos, the roads were pretty empty, but you know what was driving around was snowplows. And having worked some very remote locations, you know what you end up doing is people that are getting around, hey, give me a ride. I need to get somewhere. Like when they say they couldn't go back to the police station, there was a mile and a half to get proper evidence collection bags. Why don't you ask one of the snowplows, hey, go back to the PD. One of the people at the police department is going to give you some evidence collection equipment. You're going to bring it back here, right? Yes.
Oh,
Thank
wow.
you.
Yeah. Or
Right,
one of the other folks that have been there to help. And I mean, it's just laughable.
Right.
And you'll be happy to know now that they've had the audit, you know, they did an audit of the whole process. Now they've put little baby CSI kits in the squads.
Right.
So at least they have that.
You know, it's interesting. When I saw that, I was just shocked. I was like, you know, I worked a gang task force, a gang and drug task force for about 8 years. And you know what I had in the trunk of my car? An evidence collection kit. Because at any moment, you're probably going to collect some drug or weapons from people. And you have to collect it properly. If you don't start at the beginning being prepared, you've become unprepared, right? So absolutely. You know, it's interesting. You brought up the vehicle again, and I wish I could share something that I saw in the evidence that if they would have collected, I think would have answered a lot of questions.
Well, don't tell us now. If there's a not guilty verdict, save it. If it's a not guilty verdict,
I mean, ultimately, they missed things that you know. It's interesting. They sent preservations for things, but never followed up. And that's indicative of what we talked about earlier, is that by the 2 o'clock briefing that they probably had, they'd already decided who did it and never went back to collect things that they had sent preservation letters for.
Yeah. I just noticed Jason Hodges had a note. They need body cams too. Well, they did add those. They have body cams as well. Before I let you go, I have a question about your name, and it relates to a dumb story about my son. Okay. Easter is an interesting name, obviously. So I want to get the derivation of that. My kid, who was living in the East, goes to San Diego State, and he gets the nickname Easter. And I thought, oh, it's because he lives in the East, right? No, it's because he's wearing a shirt one day that everybody thought you'd wear to Easter. It was like a short sleeve, little dress shirt you'd wear for pictures with the family.
Right.
So where does Easter come from? What's the derivation of that name?
That's a great question. My dad's family's German, but people keep telling me I look Italian, so I don't know. If you want to make the story even funnier, his dad was a reverend or a pastor. So the name Easter, obviously the
you go to see a Reverend Easter for Easter. Yeah.
Yes, and what my youngest sister was actually born on Easter Sunday, believe it or not, one year. So you can't make these things up.
No.
But yeah, growing up, I wasn't called Easter. I was called Christmas. I don't know why. Anything, just some other holiday.
That's funny. It could have been worse. It could have been Halloween or something. It could have been, Flag Day.
I even get today people, but what's just funny is my name's spelled just like, Easter. I usually say Easter like the holiday, and people always look at me cross-eyed. And I'm like, really? Or how about Easter Bunny? They're like, and it's like, what are we talking? Most of the time, it's not Easter; it's Esther, and I don't get it. But whatever.
Well, we put our thumbnail on to advertise, but we didn't want to tell people you were coming on because we didn't want any chance that you couldn't come on, that somebody would say there's some kind of gag, or because there's not. But we held it, but we put on our, and if you were smart, I think somebody figured out Easter Monday verdict question mark. We just said
I thought it was sort of a play on the Easter Sunday concept, but yeah. I mean, clearly I have limitations of what I would discuss just professionally, because that's their evidence, their request. I think in general, we can have a general discussion about it. I was not a witness in the case. I'm not aware of any gag order that was presented to me.
Right. You're not a witness.
Really, I don't have opinions that I would offer that I think would violate that trust. And ultimately, I can't have opinions about the FBI investigation because of non-disclosure agreements. So, our discussion is general topics.
Yeah, and I've been bugging Mike for a while, so we are so happy that you took the opportunity, especially when you sent me that first note, said I'm on vacation. I immediately was thinking, okay, a week or two, we'll get back to him. And you were complaining you didn't have a suit. I think I don't see anybody complaining about your attire. Not one person. So,
well, yeah, I didn't bring a suit and didn't bring a collared shirt on vacation. So
good for you. Good for you.
Yeah.
That's the way. That's the way it should be. That's the way it should be. We
right.
understand. So anyhow, so we hope to get you back with if there's a jury verdict, get your opinion, especially if it's not guilty.
Yeah,
but
I would love to discuss it again if you have other matters that you're interested in discussing. I'm always
great.
I mean, this is an area that you would think I would walk away from the law and that stuff. But, for the last decade of my career with the FBI, I taught witness testimony. I taught agents and investigators across the country how to be good witnesses. And so the interaction with lawyers and the courts is super interesting to me. I wish, in some ways, my wife, because she should have gone to law school. And I love the discussion. People think of it as an argument, but I think of it more of so I grew up being as an athlete and being a competitor, and court to me is a competition of wits. It's like a battle of the minds, and how do we interact with each other? And so what's interesting is you see, like, even in this case, people would be like, oh, they prepared you to testify. And the reality is it was sort of looked at as like this icky sort of moment. But the reality is that both sides do it. Both sides prepare their witness. And oftentimes I even tell when I teach witnesses, it's not just as much a preparation for you as a witness. It's a preparation for the attorney of how they should be asking you questions. What's your style for your going to response, so that they're asking you questions that one, the answer to, and one that you're capable of opining upon. And so I think ultimately, when people ask me that question about didn't they prepare, yes, attorneys have years or decades of learning how to ask questions. We should teach witnesses how to answer them, right? And because it's not intuitive. The interaction's not intuitive, and oftentimes you'll see in newer witnesses is that the defense themes that they have the most trouble with are ones that make them feel defensive, and they instantly get very defensive. And there's no reason to be defensive. Did you prepare to be? Did the prosecution prepare you prior to trial? Yes, absolutely. That's it. There's nothing to be defensive about. Of course. When I get asked that question, yes, absolutely. Every time. I like to do that. It's a very important aspect of being an expert witness, is helping prepare and provide I had one guy, you provided a direct script to the prosecution. Absolutely. I do it every time.
Interesting. Have you had a ham sandwich lately?
Yeah, right. Don't get the bureau in. What is it? One of the bureau sayings is a ham sandwich. More roast beef, right? I think was the old bureau standard. But yeah, guys, it's been really great being on. And if there's something else that whether it's this matter or another,
that's great.
Invite me on. I'd love to.
Absolutely.
I got plenty of opinions.
I'd love to have you on with Crash Daddy Plord, actually, because the two of you really get along about your experience being from the law enforcement side and seeing things and calling them as they are. And you can't have a better witness than that. You're not witness Dever, never say Dever. And poor Yuri, and I don't know if you caught up, poor Yuri mechanic who speaks 5 languages, asked for a dictionary on what was the word?
I saw that. What was it? I can't remember the word. I want to say
I can't remember the word either. Was it theory or was it? I can't even remember. It seems so long ago.
It might have been an I word too. I had to watch everything super fast because I was not a gag order, but there was
a sequestration, right?
Sequestration,
just in case they pulled you back in.
Yeah. I mean that's sort of more my wheelhouse as well as the examination or the review of witness testimony, and I thought was the most dramatic in terms of law enforcement testimony was how poor the law enforcement for the Commonwealth testified, which is they need to be the standard. And in fact, the standard wasn't them. The standard was some of these just civilian witnesses with limited to no testimony experience. And instead, Yuri should be the gold standard for testimony if he really has the experience that he says he has. But instead, I found him to lack a lot of credibility. He seemed to have a perfect recollection when it benefited the Commonwealth, and a flawed recollection when it benefited the defense. And you just saw him constantly filibuster in a way, which is never good when you're a fact witness. You shouldn't be filibustering. It's the facts and only the facts. He could have come off as if he was to be presented as the Commonwealth's gold standard. He knows everything. He was part of everything. He's our go-to. He should have been prepped slightly better to be a sort of a cooperative with defense. Yes, that's right. No, that's not correct. He should have been the yes and no man. And instead he was the let me explain this. Let me get ahead of this. Let me explain in my own terms. That's never good for a fact witness. Fact witness should never be doing those things. And I cringed when I watched it on fast forward, but it was very cringe. Even his demeanor of sort of, I'm up here on the king's pulpit, just leaning and relaxed in. I didn't like any of it.
Remember, he was effectively the replacement for Proctor, so the bar was pretty low already. But yeah, he was bad. He was a horrible witness, and I'm sure the jury is kicking around his testimony right now.
Yeah. Before we let you go, this is a great question because you were denied because the judge said it's within the ken of the jury to know how the police procedures, that the jury understands what was wrong with the police procedures. And this witness, Colin Sixter, does Mr. Easter think Joe Public knows what police procedures and best practices are? And that's why how she denied you. She said, of course they know. So I guess that's the ultimate issue.
You know, I don't have opinions about the judge in this case because I would be improper.
No, not the judge. I'm not even asking about this. Do you think that the normal person knows what you were going to testify about? Is it within their normal ken by just watching this jury? I guess that was the issue.
I'll give you the answer I think Yuri should give. No, I don't. That's not to disparage the public. I think you have some very informed public that have more experience watching crime scene stuff. But your general public, if I were to go ask my mom these things, she'd be like, "Oh, no, you can't do that. No, mom, you can't." And that's not because my mom's not smart. It's just that there's certain nuances to law enforcement techniques that aren't generally known to the public. And I think the things that I think we could all agree that you don't collect blood evidence in a solo cup. I mean, that's common sense. But if it's such common sense, then why did the cops do it? Right.
Yeah.
Right. So then it begs the question is, if common sense is so common, why did the cops commonly screw it up? And so then it just needs to be pointed out from another professional. Another professional needs to come in and explain, no, ladies and gentlemen, I want you to know that this is not how it's done across the country. And you know, clearly I'm not a spokesman for all of law enforcement across the country. I'm only providing my opinions based on my own personal training and experience. But I can tell you, I can't imagine another law enforcement officer looking at this and objectively and thinking red solo cups and a grocery bag and a leaf blower was the best practice.
Yeah, it's crazy. Well, I don't know. Based on what we've seen and heard of you and our chat, I think you would have had a pretty powerful impression on this jury, but unfortunately, they did not get that chance. So, Michael, thank you so much. Hey, I have a lovely car for you. You know, pick one of this car off my lot. Thanks for coming on, man. And I will reach out again. I guarantee it.
Thank you.
Yeah, thank you. Appreciate it. Have a good one, you guys.
Go vacation.
Thank you. I appreciate it. You guys later. Bye-bye.
Thank you.
Great guy. Yeah. Too bad the jury did not get to hear from this guy, right? That's
wow. I know Disney's going to ask because I'm going to say, can we cut that as a breakout and run it over and over again? He was fabulous. Okay. I loved it the second time I watched it as much as I loved it the first time. As a matter of fact, I made some more notes on it. Mike Easter. Wow. He should have been allowed to testify to that jury. Absolutely. So we have a couple interesting questions here while we wait for Michael Bryant. And we're going to, I know he's relocating to his new place, and then we'll talk, and then we'll probably go to looking at Hank Brennan's closing while we wait. A couple things, just so you know, the jury, we understand, was allowed to eat lunch 1:30 to 2:30. They could deliberate during lunch, but were not allowed to announce any verdict at all. And that's because you have the court personnel who are not going to be there, who by union contract, take their lunch. Okay. Liberty Bell has an interesting take. It'd be interesting to know how many, if any, juries everyone in the chat has been on. I've been on one. I would love to be on another. Wow. Have that conversation. All right. Tell us all whether you have deliberated on a jury and whether it was civil or criminal. Really fabulous. Sheila Duffy said, "Hi, Linda. What a great interview." Yes, we were after Michael Bryan had nailed down Mike Easter after he was not allowed to testify, And of course, he said he would come on, and we, went back to him yesterday. Didn't want to tell you all, didn't want to endanger the interview or get scooped by somebody else, or someone told us we couldn't do it. We can do anything we want on our show, but he said, nope, I'm not going to talk about anything that will violate attorney-client privileges. And of course, I'm not under a gag order, and he honored his word, and he came on. And as we said, we may be small, but we brought you some of the first exclusive interviews we've ever seen. Now it's Draconis. It was Draconis' sister and Joe Tacopino, first exclusive after the jury was sent out to deliberate. And of course, and he got the not guilty. And again, this is a first exclusive interview here on Justice Served TV. We try to bring you informative, informational interviews. And you've all seen Steve Plord. You love him, Crash Daddy Plord, who's at a deposition today in California, and I think is dying that he can't be watching us. But he knows that I'll text him if there's a verdict. Okay. All right. So that Liberty Bell, good idea. Let's see what you all say. Okay, Carlene Barth has a question. If Karen Reed is found not guilty on the OUI, will that help her in the civil suit? No, because, if she's found guilty, it helps the plaintiffs in the civil suit because they just take the judgment of conviction unless it's on appeal, and because they could endanger anything if the case is on appeal. But okay, that's one aspect, but it doesn't help in the civil suit because the civil suit burden of proof is only by a preponderance of the evidence. That means 50% plus a grain of sand. It's not 51%. It's not 50.5%. It's 50 plus a grain of sand, just preponderance. So that will be litigated all over again. But really in civil suits, what happens is they tend to settle because insurance carriers are controlling where they go. All right, so there we are on that one. Michelle James, I don't think Mr. and Mrs. Joe Public does not understand about policies and procedures. That's why we are Joe Public. We are not meant to know. Yes, there are whole books written. I was going to actually this morning take out. We have all of these books written on police investigations. I have them all written by the federal government too. The FBI has them. The Institutes of Justice circulate them. I mean, there are books and pamphlets of the police investigations and all. Of course there are, because it's telling you how to run them and what to look for. All right. It's not supposed to be that because you take this is what they've been fighting against. You don't watch CSI and say, I'm an expert, because a lot of stuff on CSI is wrong. But apparently the judge thinks that everyone is an expert now because of CSI, and therefore you don't need a police procedures investigator. It is, and I will say it, one of the dumbest rulings I have ever heard about, especially in light of the fact that she gave a Bowden charge, which is that this is a bad investigation, that it's not proper. And to say it's an improper investigation, you normally need an expert. It's no different than a malpractice case against a doctor. You can't bring a malpractice case against a doctor unless it's something so, you see it. You don't need an expert if it's something within the ken of the juror, such as you left sponges, surgical sponges in a patient, right? Racist loquitur. It is what it is. The thing speaks for itself. All right. Or you left an instrument, doing surgery, and you left a scalpel inside somebody. That becomes something, well, even the common person could know. But for any other type of malpractice, you need an expert. As a matter of fact, you need a certificate that there's malpractice in many states before you can even file a malpractice suit. All right. But you're never getting to the jury without an expert. This is no different. This is absolutely no different. That's why they're trained investigators. That's why, they go through training. That's why they get promoted and get training, because you have to have that specialized knowledge that most people don't have. Okay. I know where to attack the specialized knowledge as a lawyer, but I'm not the one who's going to testify as an expert as a lawyer to police procedures. I can just attack a person in court using my knowledge of police procedures. And many times that knowledge is gained either by reading or by having my own expert advise me. And, Alan Jackson clearly had Michael Easter advising him. That's why in his summation, he said, you separate out witnesses. But just because Alan Jackson says it doesn't make it true, unless you have somebody who is versed in being an expert tell the jury that. They may disbelieve Alan Jackson that you have to separate out witnesses. They may disbelieve Alan Jackson that you don't carry around, clothes for 6 weeks before you log them in. They may not believe Alan Jackson that it's improper to have two clothes, you bring clothes out of bags and they have red tail light on them because they've been mingled with something that clearly is a red tail light that was taken, from the scene, whether it be planned or not. So that's why you have an expert. And we see how really darn good Mike Easter was, right? We see how really good he was. And I just can't, believe, I just can't believe that the judge did not allow him in. And obviously, if she'd seen him, she'd probably double up on that opinion because he was so good. Okay, let's see. We have more comments. Let's see where we're going here. ML, I've been called 2 times, but I was only selected 1 time. It was a great experience. I was the 4th person that was an assault against an officer, which due to me, it was a hung jury, 11-1. Well, good for you for holding your ground. The judge, after the fact, asked who was the 1 person. I said I was. The judge told me that I made the correct decision, as that should have been the verdict of not guilty, to how the defendant was charged versus the actual crime. Wow. You are the person in 12 Angry Men, only you are the person in our case who getting that validation from the judge, I'm sure really was important also. And made you feel good but you held your ground. ML, I was then called again last week, which was a murder trial, which I would have loved to be on, but it looks as if that person was going to be found guilty before the trial even started. I told the bailiff, but the court did not seem to care, as the individual that I advised have stated before, if we ever were assigned to the courtroom to go up and make a conviction of guilty, to go home. We were questioned for 2 days by the judge and both sets of attorneys, and they picked the people that appeared to be either weak-minded or the person who said would be guilty. Well, we know who would have picked the guilty person there, don't we, ML? That would have been the prosecution would have picked the guilty person. And I'm sure they would have asked you about your service on the jury. And when you told them, by the way, that you hung a jury up, the prosecution would have said, I'm going to exercise my preemptory challenge. No doubt, in my mind, you wouldn't have made the jury trial. Well, I can tell you, I've been called a number of times. I never make it to the jury. I think I've told you all the story that I was called. I spent all those months inspector, came back in the end of September. I got called for jury duty. During that time, I had to fill out my card. I couldn't go. And I picked October as the likely time that I would be available. And sure enough, you only get one in New York. You get 1 time to say you can't be available and pick another time. So I had to go. I was exhausted. It was right in the beginning. I think it was October, maybe in the end of September. But I was exhausted. Everyone had known that I had just come back from a jury trial. So I got called, and I was at the criminal courthouse, but then we got moved over for this case to the civil courthouse, and I wasn't sure why. I'd never seen that before. And it turns out it was a case that involved, it was a criminal case, but involved leaving the scene of an accident where somebody had died, much kind of like this case, all right? And I didn't know anything about it. I'm sitting with the whole courtroom, and blah, blah, blah. And they whittle everybody down. Can you serve? Can you serve? Can you serve? And I get whittled down. And usually when I get whittled down, as it was the last time I was there, as soon as they ask me the question, who do you know that's in the law enforcement or in the legal community, a half an hour later, I'm finishing my answer. So and then they say, could you step aside? Could you step in the back room or something? We'll be back at you. All right. Or I'm going to get back to the story I was telling. Or in the latest trial that I was called in during COVID, where I heard them arguing when the door opened as we were coming back from lunch break over whether the prosecution didn't want me because my husband had been a witness against the prosecution in another case. And so they thought I would be biased. I had no idea. All right. So then we go back to my first story in New York of being called for jury service right after the Specter trial. And so I finally, I'm going to be one of the ones that they're going to be selecting from. And I'm like, wow, right? And then the judge reads you the name of the witnesses, and they don't they just put them together. They don't tell you prosecution defense. And the last person they read on the witness list is my husband's name. Now, I hadn't seen my husband 6 months. Gosh knows where this trial was going. Gosh knows whether, he just knew I was having jury duty. No one's talking about anything. So I'm trying to get the bailiff's attention. Hello, hello, hello. Hey, hello. I'm here on the jury. And, I don't want to affect the jury because finally I get his attention and I come over and I said, my husband is on the witness list. And I see him, go up to the court. And I see him call the prosecution and the defense up to his bench. And then I see this for me to come up, okay, with the finger. That's usually not very good. So I go up and I said, he said, Your Honor, yes, I've been on the Spectre trial. He said, well, that's not going to get you off. I said, that's fine, but my husband's on the witness list. And I don't know who from. And as soon as I said that, I knew who from at that point, because the defense was like, and the prosecution stepped back and glared at me. So I figured it was against the prosecution. So the judge said, well, you and your husband don't really speak much about your schedule. I said, well, Your Honor, I just got back. I mean, it's not like this is, talking about jury services on the top of the schedule. And my husband has lots of cases, so he sent me back to go back to the jury room where I was then let go the next day. And then I learned when I came back, I talked to him about it, and he was called like a week later or something. And the reason why is because he had gone to the medical examiner's office. It was a case involving leaving the scene of an accident with a big bus. And the question is, what bus? And one of them was a New Jersey Transit bus, and one was another bus. New Jersey Transit bus is actually owned by the government in New Jersey, but it is driving in New York. They bring New Jersey Transit brings people to New York City. And it turns out the question is, which bus had run over this poor person? And my husband went, and when he went to the medical examiner's office to look at the clothes, he saw these big tire tread marks on the clothes of the now decedent. And of course, they matched the New Jersey they didn't match the New Jersey Transit bus. They matched another bus, okay? Probably one of the New York buses. And so, it's a good lesson. You always go look at the evidence. You always go look at the evidence at the medical examiner's office. And my husband's a hero. What can I say with regard to that? Because or else they would have convicted maybe an innocent person. And instead it was a not guilty based on his testimony, where the, no one had bothered to look to see these big tread marks. So, and yeah, that's my story about jury duty. That's my 3 stories about jury duty. And then, of course, in New Jersey, when I was there, I got called to be the grand jury duty. But, I was a defense attorney, and they didn't want a defense attorney on the grand jury. So there you go. But if you can be on a jury, please be on a jury. All right. It is a very important thing to do. It is important. And, you see how people like it once you get to serve. It's fascinating. And I always wanted to be on one. And I don't think anyone's ever going to pick me to be on a jury because of my background. Maybe I'll get on a civil case one day, but then I do plaintiff's work. So I don't know about that. All right. So SLUT, Inside the Upside Down. Thank you for all you do. Utah, Tanya, and Rob, they were great, weren't they? Also, our channel's up. We've added videos of our Canton tour, as well as the unedited version of Albert Encounter from Cop Cam. We love you. You guys were great, Utah, Tanya, and Rob. You were absolutely great. All right. So would you just put your channel? I know we had we put your charity in the other night. In the chat, put your channel, the actual link to your channel, so everyone could see it. You guys were great. We had a lot of views. Everybody is in love with Tanya, Rob, even though they really, only heard her, right? But they're all in love with her, and we thank you for coming on. And we are happy to have made your acquaintance, Michael Bryant, who, like, for instance, if he had not been there, if Michael Bryant hadn't been there, we would have never met many of the people that have been on our channel. And it's important to get their information. So thank you. But put your link to your channel in there. So you've added videos of your Canton tour, as well as the whole unedited version. We had to edit our version. Not that, I'm a purist when it comes to First Amendment. I find nothing wrong with the F word. There you go. But some people do, and especially since we know that we have 16-year-olds in our chat, and we are not going to. The only word I won't allow on my channel. It's not that I won't allow. If you want to use it, you're going to use it, but people won't see it. You can use it, but people won't see it. It's the C word about women. I am very violently opposed to that. As far as I'm concerned, that's just like the N word, only gender. And people only say, I don't even care about the B word. The B word people call, say bitch all the time. That's not a big deal, right? Has to do with puppies and pregnant dogs. All right. So, but there we go. We do have we did put up the upside down your channel, Rob and Tanya. And if you want to go see the unedited video, you can. And yeah, you probably should, right? You probably should. Okay, absolutely. So let's see what else we have in terms of questions with regard to that. All right, I don't see Michael Bryant. I think he was getting something to eat. So what I think I'd like to do is we have queued up, and because we want to be a sort of fair, and we try to be fair on this channel, and also because the jury is in there talking about Hank Brennan and the evidence, and we need to see what he said, see if there's anything we missed. I know most of you here are free Karen Reed, but I think we have to see a bit of Hank Brennan and comment on that. But before we do that, I do want to have you hit the like, share, subscribe button, especially if you've just found us through Twitter, our Twitter account. Come onto our YouTube channel, hit subscribe, hit like, hit share. It doesn't cost you anything. And then you can hit the notify button. So when we go live, which, these days is a lot. I mean, we've been on there all day, right? If we go live, you can get us. So it doesn't take you anything to just wander over to @JusticeServed TV on the YouTube channel and hit that subscribe, share, like, and notify. Especially subscribe. Yeah, the more subscribers we get, the more emojis we have. We're making one for Crash Lord Flord. Hopefully, we'll have it ready tonight if there is a verdict. But if there's a verdict or something's moving in the courtroom, we will let you know. You know that the defense attorneys have to come back from Yanetti's office, so we would see movement if that happens. All right. Oh, okay. You're gonna have to take some Advil or some aspirin. Let's listen to a little bit of Hank Brennan and let's see how he addressed the jury after Alan Jackson went. Can you all hear? Because I don't hear anything from him. There you go. Now
He's a Boston police officer. He worked to help the community. Everything you've heard.
I'll be here behind Tubi.
He was a good man. Helped people. When his niece and nephew had nobody, he took them in. He took them in. John O'Keefe seemed to be the type of person who would help anybody at any time. And on January 29th, 2022, John O'Keefe needed some help. He needed help from somebody else. You see, John O'Keefe had just been hit by Karen Reed in front of 34 Fairview Road, and he lay on the ground dying. And he needed help. Someone to reach out a hand, someone to knock on a door, someone to make a phone call to 911, even anonymously. Not take responsibility, just to help. And there was only one person in this entire planet who could help him that morning, to give him a chance. Maybe it was a 33% chance if he met the Isaac Wolf of the world. But to give him a chance. And that one person who could help him that morning was this defendant right here, Karen Reed. And she made a decision. In her Lexus with the shattered taillight, debris field all over the front yard, and John O'Keefe lying helpless like a child on the front yard. She made a choice. She didn't call 911. She didn't run to his aid. She didn't knock on a door. She made a decision about herself. In her Lexus, she drove away. She was drunk. She hit him, and she left him to die. She was drunk. She hit him, and she left him to die. Before I go through in detail the evidence, let's talk a little bit about the evidence as a whole. she was drunk. She was drinking that night. She was drinking McCarthy's with John. She was drinking at the waterfall. Her blood was taken. The samples of the retrograde analysis, almost 2 to 3 times the legal limit. She was drunk. She hit him. The timeline in this case is beyond dispute. You can accuse, assault, characterize, malign, twist. The timeline doesn't change. It is data. Data is data. The black box, the forensics from the SD card, we know exactly step by step where they were. We know in that window, she hits him because he never moves again. His healthcare data, the temperature on the battery of the cell phone, the physical evidence, the debris field, the DNA, the hair. And then she left him to die. He had a basal skull fracture, counter coup. You heard all about it when the back of your head hits the ground and the brain comes forward. Dr. Wolf told us the reason why they have level 1 trauma centers around the country is because people can survive this injury if they get help. That's why they have this care. That's why they have these hospitals. But you gotta get help. You gotta get help. And if you don't, you develop symptoms, ecchymosis, raccoon eyes, your brain swells, and you die. She was drunk. And that night was a recipe for disaster. But before we get to the drinking, in some ways, the fate of this night was sealed well before that night because John O'Keefe and Karen Reed were in a toxic relationship. This relationship was crumbling. We hear lovey-dovey, and it was crumbling, and we know it. And we know it because a month before, his niece Kaylee talks about when they went to Aruba. It should have been a wonderful event. It was discord. It was fighting. It was aggravation. And when they got back, the discontent was palpable. Miss Reed reaches out to Brian Higgins, text messaging. John O'Keefe, the relationship is crumbling. And you heard a little bit about what that relationship was like. Kaylee, his niece, told you, when there was an argument, John would do what John does. He would walk away. She described to you one time, to get away from the scene, he walked into his bedroom. But the defendant wouldn't let it go, pounding on his door, having to get the last word, never letting go of the fight. Kind of mirrors what happens on January 29, 2022. And maybe outward appearance, they got along. Maybe sometimes quietly they got along. But behind closed doors, relationships have up and downs. We have a bird's eye view into the relationship on January 28, 2022, because we have the text messages, not so lovey-dovey. The relationship is almost over. The tensions are simmering beneath the surface. They are not getting along. She believes Mr. Keefe is already halfway out of the relationship and he's not into it anymore. You will read them, you saw them. This relationship was unstable and at its end. And so fast forward that night. That night, after this discord, after the arguing, they go out and what do? They drink. And they drink a lot. So he drinks a lot and Karen Reed drinks a lot. You've seen the McCarthy videos. You can call it 6, 7, 8, whatever you want to call it. You can see the shots into the next drinks, more shots into next drinks. Count them yourself. Over a half dozen mixed drinks in just a few hours. Sober? And then at the waterfall, a shot, a mixed drink. Now, it was brought up the waterfall that there was some type of discord between Brian Higgins and John O'Keefe. They knew each other. They were friends. Brian Higgins' conduct of speaking to Karen Reed is not honorable. It's not. But they were friendly. There was no adversarial relationship. There was no anger between them. What we heard is they barely greeted each other. Can we have slide 1, please? At the Waterfall Bar, when you see John O'Keefe come in, here's him barely greeting him. That's him and Mr. Higgins, barely greeting each other. Reality sometimes is different than argument. This is a celebratory mood. Take that down, please. Celebratory mood. A bunch of friends. They're playing around. They're hugging. They're grappling. This is a fighting technique for a murder 2 hours later. Is that the story? They're practicing their moves to murder John O'Keefe. In the celebratory mood, you don't see any aggravation or animus between Brian Higgins and John O'Keefe. Inevitably, the next morning, Karen Reed is brought to the hospital and they take her blood. Now, the government doesn't have to prove that she was drunk. It is either that she's over the legal limit, 0.08, or she had enough alcohol to affect her ability to operate a motor vehicle safely, but you will know that she was far beyond the legal limit. After the retrograde analysis, almost 2 to 3 times the legal limit. Almost 2 to 3 times the legal limit. Now, it's been intimated, not come out and said that maybe she went home and started drinking after she got home. No evidence, mind you, no evidence. And that somehow that is why she had a high blood alcohol level. It's not appropriate for me to comment on the credibility of another attorney's argument, so I won't do that. But Karen Reed will do that for her. So if we listen to slide 2, she'll tell you exactly what she thinks about that claim.
My alcohol intake's probably about 5 or 6 or 4. The drinks that they were pouring me at McCarthy's, which is where I consumed most of the alcohol, was the weakest at the time. It tasted just like all soda water with lime.
Slide 3, please.
I wouldn't have gotten on the expressway